All right, welcome everybody. This is the June 9th, 2020 public hearing for Duncan Road. We appreciate everybody being here tonight. This will be there will be people here at the courthouse that will come in and speak one at a time. That will go first. The second part will be those people that are on video conference. We will call you in one at a time. I'm going over the housekeeping rules, and when those housekeeping rules are finished, then those people that are on video conference will go into a waiting room, and then you will be called back up in just a few minutes. So here are the housekeeping rules. First of all, clerk called the meeting to order.
You just listen off this one.
Yeah, it's got to be muted.
Yeah, but that way you can see it.
Squire Sebastian, will you say here?
Here.
Squire Blackburn,
We need to hear you, Squire Blackburn. Sorry.
Present.
Squire Muller,
Present.
Squire Tracy,
Here.
Squire Booth,
Here.
Squire Moore,
Here.
Here. Now I'm going to go over some housekeeping rules for the magistrates who are also called the staff. When people speak, you're not to interrupt them. Allow them to finish speaking. Whatever time that is, and we'll talk about that in a second. That when they're finished, then you will have an opportunity to redirect or to cross-examine and ask them questions. All questions must be held until the speaker is finished. Raise your hand at the end of the presentation and I will call on you. So if you have a question for the person that has just spoken, if you'll raise your hand and we'll go down the row and call on each of you. I need to make this statement to you as members of the court. Is there any member of the court that has a conflict that would affect their ability to hear this matter and make a decision based on the testimony and evidence presented this evening, or any reason they cannot decide the matter based on the standards of KRS 100.213? Seeing no one, okay. I want to go back now to the video conference and read these housekeeping rules for the video and audio public testimony. These are the housekeeping rules. All persons speaking via telephone or video conference must first state their name, and then you will be sworn in. You will be given X amount of minutes, and we'll go over that in just a second, to speak. And then you will be stopped after your time limit. You may be asked questions by the court, staff, or the applicant. There shall be no profanity, no derogatory comments about any individuals. Once you are finished, you will be dismissed from the conference. Now, I go back to the magistrates. Do you have a motion to limit the testimony to 5 minutes? Does anybody disagree or want to change the amount of time for 5 minutes? Okay. Squire Booth.
I think 5 minutes is an adequate time. I recommend I move this testimony be limited to 5 minutes.
Okay, Squire Muller.
Judge, do we know how many people will be speaking tonight on both behalves?
How many are out there? There's 7 in the outside here at the courthouse. Andrew, do you know how many they're online?
Judge, I believe there are going to be 1, 2, 3, 4, 5. I believe there's going to be 5 if I'm counting correctly. Yeah, 5.
Looks like there's more than that names on the board, Andrew.
Well, some of the people are members of the applicant team. I don't know if they're going to be,
okay.
You know, I don't know how that works, Judge, but my understanding as far as the people who are not a part of the applicant team, staff, or the magistrates, there are approximately 5 public comments, if that makes sense.
I'd say there's close to 15, Squire Muller.
Okay, thank you.
And Judge, when you're discussing the time limits, are you referring to staff and the applicant, or you you're
only the speakers, not staff or the applicant.
okay? Just wanted to clarify what was limited.
Thank you. Squire Tracy.
If the staff of the applicant intends to speak, do they need to sign up? Do they need to be signed up? And if so, can we get that?
No, they do not have to be. That is part of the testimony. The staff, which is Robert Hewitt, and you all and the magistrates are allowed to cross-examine. The applicant allowed to cross-examine each speaker.
Okay. I was asking, not in regards to county staff. I was asking in regards to the applicants.
They're separate from staff.
Okay.
There's two
Yes,
different terms, staff and applicant.
Okay.
Okay, we have a motion on the floor for 5 minutes. Is there a second to that motion? There's not. Squire Moore, is that a second, Squire Moore?
Yes, that's a second.
Okay. Is there any other motion? Okay, let's go to that. Clark, call the roll.
Square Sebastian,
I'm going to vote no on that. I think we may want to give just a little more time. Thank you very much.
Squire Blackburn,
You need to unmute yourself, JW, Mr. Blackburn. Squire Blackburn, you need to unmute yourself, sir.
Sorry about that. I vote no. I think you'd mentioned 12 people at 5 minutes. That's as important as this issue is. I think everything needs to be heard. I recommend more time.
Squire Muller?
I'm good with more time, so I guess I need to wait and make a motion after we're done this. So I'll say no.
Square Tracy,
I would agree. I think with all the contact and with the interest that has been shown in regards to this, I think we would be best to warrant more time.
Okay, so,
Square Booth,
I thought just what
Well, it was my motion, so I'm voting yes.
Squire Moore,
I'm sorry.
Yes.
Judge Wells,
5 minutes was fine with me, but we'll go now. So I asked, yes, but
motion fails.
motion failed. So the floor is back open for how much time you want. Okay, let me say this to you, Court. You have to say a time and we have to vote on it. So somebody pick a time. I threw 5 minutes out just to throw it out. Now, somebody else pick out however much time. Squire Moore, did you raise your hand? You have a time you want to talk about? You have to unmute.
Okay. Judge, we have to set a time. I don't want to be filibustered, but the squire of the district can make the suggestion and
Recommend 10 minutes.
I'm looking for a magistrate to give me a time limit. Squire Blackburn,
I make a motion for 10 minutes.
10 minutes, okay? Is there a second?
I'll second that motion too, Judge.
Okay, thank you. Now we have a motion and a second. Call the roll.
Square Sebastian,
Yes.
Squire Blackburn?
Yes.
Square Muller,
Squire Muller?
Yes.
Yes.
Square Tracy,
They're gonna put me in a waiting room in a minute. I can't hear you.
Tracy?
Yes.
Square Booth,
Yes.
Moore?
Yes.
Judge Wells,
Yes.
motion carries.
So we'll be giving each speaker 10 minutes plus cross-examination. The 10 minutes you'll be allowed 10 minutes to speak, and then whatever time there is for a cross-examination with no limit on that. Those people that are on the video conference, I'll be put in the waiting room, and we will call our first person in just a moment. Thank you. Okay. This is called a public hearing in accordance with the Kentucky Revised Statute 100.211. This Tyranny Storage LLC is requesting approval of a zone map amendment from Agricultural District AG to Industrial General District IG for a 85.388 acre portion of property located in Franklin County, identified as a portion of Tract 1, 84.058 acres plus or minus, and a portion of Tract 2, 1.331 acres plus or minus, located at 690 Duncan Road. The property is more specifically identified as a portion of PVA map number 087-00-00-031.00 Tract 1, and a portion of PVA map number 087-00-00-031.01 Tract 2. Clerk, will you please swear in the staff and presenters that are present in the courtroom? Yes. Raise your right hand. Go ahead.
Do you swear to tell the truth, nothing but the truth?
I'll do it. All right. Mr. County Attorney, would you please qualify the staff? Mr. County Attorney, have you qualified?
Yes, sir. I'm sorry, Judge. Forgot to hit mute. Mr. Hewitt, state your name, where you work, and what you do there, sir.
My name is Robert Hewitt. I work for the Franklin County Fiscal Court, and I'm the Director of Planning and Building.
And how long have you been Director of Planning and Building at Franklin County Fiscal Court?
Approximately 13 years, 5 months.
What qualifications do you have for that position? That is education, certificates, licenses, etc.
I have a Bachelor of Science from Western Kentucky University, geography major with a minor in city and regional planning. I'm a member of both the American Planning Association and the Kentucky chapter of the American Planning Association. I'm also a certified stormwater inspector.
And in your capacity with the Franklin County Fiscal Court, are you responsible for reviewing applications for zone change along with other related staff, including the application process, maps, attached documents to ensure conformity with the at least application process?
Yes.
Judge, unless there's any other questions from the court, I'd ask the court to accept Mr. Hewitt's qualifications regarding what will be his testimony as to the application and his analysis of that application.
Okay. Any other questions by the court? I'm sorry.
I would also move the court to accept his documentation, curriculum vitae, etc., which was previously presented to the members of the court relative to his qualifications.
Okay.
And introduce that of record.
Okay. Mr. Hewitt, with that being said, Mr. Sparks, Mr. Hewitt, will you please present your report?
Thank you. I do have one addition or amendment to my report that was submitted. Mr. Tippett, if you could go to staff exhibit number 1 on the screen share.
Yes, sir. I'm going to pull it up here in just a second. I'm working on it right now. Okay, it should be coming here in just a second. Okay, do you see it, Mr. Hewitt?
Yes, could you minimize the image slightly?
Minimize it.
Yes, we're only seeing a portion of the document.
I'm giving you the whole screen.
All right, scroll to the bottom then, please.
Okay.
There you go, thank you. So, court, I am presenting an amendment to the staff report, page number 14, which consists of my recommended findings of fact. I have added findings number 7 and 8 that I would like to read into the record. Item number 7 reads, on February 13th, 2020, by a vote of 6 for and 2 against, the Franklin County Planning Commission recommended approval of the zone map amendment. Finding of fact number 8, that the existing zoning classification given to the property is inappropriate and that the proposed zoning classification is appropriate. I would like this staff exhibit number 1 entered into the record in addition to my testimony.
Does the court have any questions of Mr. Hewitt? Squire Booth? You need to unmute. Thank you. Squire Booth?
Yes, I'm sorry. The employment center definition of the employment center, does that have a certain number of employees that are expected to be working in that center? Is there a minimum?
No, it does not. It only generalizes land use activities.
All right.
Any other questions for Mr. Hewitt? Squire Sebastian?
Thank you, Judge. Mr. Planning Director, I've got a few for you. Are the goals within the comprehensive plan weighted?
No.
So one does not carry more weight than another. They're all equal, correct?
That would be fair to say.
All right. You had also qualified yourself, and we accepted the qualifications of your certified stormwater inspector status. Is that the appropriate terminology? Is that the appropriate title, Robert?
Qualified, I believe.
Qualified stormwater inspector? I'm sorry. Can you not hear me, Robert?
We didn't hear your question.
Yeah, the answer is yes.
Okay, thank you. I just want to make sure I had it correct. In our packet, there was a letter from Otis Engineering who serves typically as the county's engineer. And there were some statements in that document that talked about that the county engineer will be looking very closely at how water management design is provided, because the property in question is at the head of the watershed for Slickaway Branch. Flooding has occurred on numerous occasions, and that is a known problem area. So given your qualifications, can you tell us how this can be mitigated before we get into more serious issues in this area? Thank you.
Well, only generalized because that is a site-specific development plan determination. Our regulations do allow us to request additional storage for areas of sensitive flows. And that has already been discussed with the property owner.
So was there any information in our packet that discussed, because I couldn't find any, and I read every piece of this. I couldn't find any about that discussion, just to understand the nature of what the response was in regard to what the county engineer had raised as a serious issue. Thank you.
Stormwater design is not an element of a zone map amendment. It is specific to a site development plan. If a site development application is submitted for an industrial property, stormwater design calculations must be submitted for the county attorney's review. That stormwater design must be prepared by a professional civil engineer and submitted in conformity with our regulations. So this is not the time for those calculations.
Do you have any other questions, Squire Sebastian?
Not at this time.
Okay, are there any other questions? Squire Blackburn.
Yes, Mr. Chair. Squire Sebastian touched on the goals in the comprehensive plan. One of them was growth is healthy and that it's planned. And then the boundaries of our city and our county are changing if this goes forward. There's a lot of things in here on these goals of the plan. As she said, they're not weighted. Who decides which ones weigh more than the others?
Well, they're not weighted. There is a comprehensive plan committee established by the Planning Commission who, in general terms, prepare the document. The goals and objectives are submitted, in this case, to the fiscal court for your adoption, but then the rest of the heart of the document is prepared by the Planning Commission.
Okay. Okay, thank you for that. And as she touched on earlier, I know this is in my district, and I go out there every time it rains. I have since the day I was elected, and I know rain events they can be quantified, but they've changed over the years, and there was some scouring over the road right after the development began that almost washed the abutment of the guardrail right at that curve. And I hadn't had an opportunity to talk with with Mr. Russell, with our emergency safety guys, to see if he had more calls in that area because of that. I'm real concerned with the watershed. As you know, you and I both spoke well before this even came up, that there's sensitive areas in Franklin County, and that you were personally working on a plan to raise restrictions. And
Robert, I just have one follow-up question, since this issue was raised about the Planning Commission and how they interact with the plan and how a committee is put together. Is there any review or revision process ongoing right now for the 2020? I read in the notes that Chairman Jackson talked about how the 2020 plan would start to be reviewed and revised. And I don't know the timing of that in relation to what we're looking at. So the question would be valid and germane to that. Thank you very much.
So could you be more specific on your question? Are you interested in when the next plan revision will begin?
Yes, sir, because in the notes that were provided to us in this document, Chairman Jackson noted that process was to begin a couple of months. So that would have been about April. So I was just trying to see if that is underway, if that is something new that we need to consider in regard to what we're talking about tonight. Thank you very much.
Ma'am, it's my opinion that what you need to consider is what's before you this evening and the way that the comprehensive plan is currently written. Any potential revision to the comprehensive plan will be some time out. The comp plan committee will not be formed until group restrictions have been lifted by the governor.
Rick Sparks, do you want to address that?
The court is required at today's hearing to determine one of three things: whether or not the existing zoning classification is appropriate for the applicant in the application, whether or not the existing zoning classification is inappropriate and the proposed change is appropriate, or whether or not there have been major changes of an economic, physical, or social nature within the area which were not anticipated in the currently adopted comprehensive plan. The prospective, potential, etc. changes that may be applicable to the comprehensive plan are not an issue before the body today. It could all be changed tomorrow, next year, may never be changed. It's where you're at right now today.
Okay. Thank you. Are there any other questions for Mr. Hewitt? All right. Seeing none from the staff, does the applicant have any questions for Mr. Hewitt?
Well, Mr. Hewitt needs to finish with his presentation,
Oh,
Judge.
I'm so sorry. I'm so sorry. I thought you'd finished. I'm
No,
sorry.
sir.
I'm sorry. I'm sorry.
That's all right.
Hold on.
Mr. Tippett, could you put on the screen staff exhibit number 2, please?
Yes, sir. Give me just 1 second. It should be coming up. You should have it.
Okay, very good. Thank you. So this is an aerial image from the county GIS that shows the subject property. I would like for you to note that I have identified both the Franklin and Woodford County line, the jurisdictional line, and that there. The request is for 85.388 acres, and the judge mentioned that is in 2 separate tracts. The entire property is 102.49 acres. There is a stamped survey and legal description within your packet for verification. We are only considering this 85.38. Next exhibit, please. Should be exhibit 3A.
Let's make sure that, can the court hear? Can you hear Mr. Hewitt? Thumbs up. Can you hear Mr. Hewitt?
Most of it.
Okay.
It's wavering.
Speak up a little bit more. Speak up a little more. Okay.
There's a considerable delay and lag in this.
I brought an extra Wi-Fi device. We may need to split up some people in here.
Let's go ahead and see if he, go ahead and speak. Okay. Let's see. You moved up.
Okay. So what I have on the screen now is the current cover of the 2016 comprehensive plan as it exists today. Mr. Tippett, if you'll scroll down to the next image on that, there should be a map attached. This is the countywide version of the future land use map. It's not to be confused with the zoning map. This is a map that the Planning Commission has adopted showing the appropriateness of the potential for future zoning of any given parcel within Franklin County. I have, with a blue pen, marked the location of 690 Duncan Road. Mr. Tippett, if you'll scroll so we can see the rest of the legend, please. You can see that that property has been identified in the current comprehensive plan as employment center. Mr. Tippett, exhibit 3B, please.
Yes, sir. You should have it.
Yes, sir. So this is the cover of the 2010 comprehensive plan. along with its associated future land use map, which identifies each individual parcel within Franklin County. Once again, 690 Duncan Road has been identified on that map, and as you can see, it's also noted as employment center. Exhibit 3C, please.
Yes, sir.
What we have here is the 2001 Comprehensive Plan Future Land Use Map. 690 Duncan Road, once again identified. At this time, the category was called Commerce Center. Under the land use guidelines, the language for Commerce Center is the same as it is for Employment Center in the 2010 and 2016 Comprehensive Plan. So with this history, you can see that for the last 19 years, this property has been designated for future light industrial property or uses, excuse me, eligible for an industrial style zoning. Mr. Tippett, Staff Exhibit 4. So this text is taken directly from the 2016 Comprehensive Plan, which is the identification of Employment Center, which is that burgundy color you saw on the map. It reads, for the record, office employment and light industrial uses can and are being developed in a way that still provides a diverse economic base while blending in with residential and commercial areas. Employment centers are areas that encompass primarily office, warehousing, and light manufacturing areas in a campus-style development. This style of development places buildings on larger tracts. Exhibit 5, please, Mr. Tippett.
Just a second.
On that last exhibit, the remaining portion of that one sentence was cut out, so let me finish it. This style of development places buildings on larger lots with landscaping and green space that are attractive and relatively free of a fence. So that was the remaining definition of employment center. So an exhibit, staff exhibit number 5. This is a map from the Kentucky Infrastructure Authority that publishes, identifies infrastructure currently in place by utility companies. In goal number 1, growth by design within the comprehensive plan, it states that it should be future growth will be based on long-term vision for our community, public service availability, and suitability of land for development. In the documents received both at the Planning Commission level as well as in the documents received for this hearing, the Kentucky Capital Development Corporation, which is funded by both the city and the county, has identified a lack of available industrial property for sale or for development. Without adequate infrastructure, development is hindered or not able to occur. The map on the screen right now is the KIA map, Kentucky Infrastructure Authority map of the wastewater infrastructure. So this is the sewer lines. While the property is not highlighted, just for reference, you can see the county line, and then the pond is always a good reference, basically in the middle of the screen. The call out you see in blue is a sanitary sewer line 8 inches in diameter that runs roughly along the western boundary of the subject property. All utility companies, along with the transportation cabinet, were contacted as part of this application and asked whether or not they could serve this property for future development. The sanitary sewer department had no objection to the request. Staff exhibit 6, please.
You should have it.
This Kentucky Infrastructure Authority map shows potable water infrastructure. This property is served by the Frankfort Plant Board Water Department. What you see on the left side, the western portion of the property, is a 24-inch water main. The blue call out you see on the right-hand side is running parallel to Duncan Road. That's a 12-inch water main. The plant board, in their review comments, said that they could provide service to the property under their standard tariffs. The fire department, fire chief, said the property could be served with fire protection based on the size lines, flow, and pressure. Goal number 2 of the comprehensive plan refers to the distinction between town and country identity. As you can see in your staff report, that goal is on page number 6. The property, and there is a map identified as figure 1.1 at the back of your report. It identifies this property as being within the suburban sub-area for development. That is identified in a document known as the Subdivision and Development Plan Regulations. Generally speaking, the suburban style development does not recognize the city boundary. So if this property were in the city, or if it were in the county, it would look exactly the same because the city and the county share the same regulations. So it's a suburbanized area identified as a result of available infrastructure. That map was also prepared by the Planning Commission, adopted, and forwarded to the fiscal court. That has been in place since approximately 2004. Goal number 3 on page 7, infrastructure as a planning tool. In industrial zoning applications, along with commercial, the county's regulations require that a traffic impact study be prepared. The applicant hired a professional traffic engineer, prepared this study. County staff presented that both to the Planning Commission's traffic engineer for review, as well as District 5 Permits Division. Within the response from District 5, Mr. Brian Eaton, professional engineer with the Transportation Cabinet, states, quote, the analysis suggests that a change in signal timing to the existing system of US 60 Duncan intersection and I-64 eastbound intersection and I-64 westbound intersection would improve the issue and even lead to a decrease in delay compared to the existing 2019 traffic counts at the interchange. What it's referring to is the intersection of Duncan Road and US 60 because of some the numbers that you see within your transportation study. It talks about the number of cars that go through there both during the AM peak hours and the PM peak hours, so whenever there's the most traffic. The Planning Commission's traffic engineer has also provided a response to this and ultimately has determined that the analysis for the full build out is in compliance with our current regulations. I currently have the Planning Commission's traffic engineer at this meeting available to answer any questions if the fiscal court has any. Continuing on within that goal, I also reference once again, as I've said before on the maps, the water and wastewater infrastructure facilities, domestic service for potable water, as well as fire protection. Goal number 4 on page 9, promote economic health. What I've identified is that this property is in proximity to additional or adjacent industrially zoned property. So the adjacent residentially zoned properties are actually along Duncan Road, identified as the Hilltop subdivision. Once again, Kentucky Development Corporation in their letter has stated that there are several reasons to support the zone change. They say this is a critical time for Franklin and Franklin County. Once again, citing the lack of available industrial property left for sale or development. If approved, this additional 85.388 acres of industrial zone property in the county has the potential of creating a significant economic impact for the community. Goal number 5, economic health. The property is not located within a special flood hazard area, so no flood zones exist. This is the portion of the report where I do reference stormwater and ponding and overtopping of Duncan Road. I have worked with emergency management. I have been on site during those events. The county engineer and I have met with the applicant and his team. If this zone change occurs, that we will be asking for additional detention on site. I believe that they're prepared to provide that if they have that opportunity. The property actually is not within our phase 2 stormwater service area. Goal number 6, preserve existing neighborhoods. I did not find that an industrial use across from the Hilltop neighborhood would promote the stability or preserve that neighborhood. I would refer back to the definition and description of employment center in that those types of uses should be compatible, or they should be designed in a way to be compatible and not conflict with the adjacent residential properties. If we could, Mr. Tippett, let's go to staff exhibit number 7. Ooh, sorry.
You should have it.
There we go. So this is a copy of the Woodford County zoning map. I placed a blue X in the approximate location where 690 Duncan Road is located. What you see in the bright yellow with the call out is the Hilltop Meadows subdivision that I've referenced within the report. There were several residences from that subdivision that came and spoke at the prior hearing. You can also see just northeast of that within Woodford County, they also have industrial zoning on their side of the Woodford County line. The green areas are identified as an agricultural zone. Goal number 7, promote quality development that strengthens community character and pride. You know, quality development can bring many things to a community. It can provide additional jobs, new businesses, and increased tax base that can help fund our parks, help improve our roads, improve our water, stormwater, sanitary sewer systems. So growth is healthy, but it needs to be done correctly. This property is unique in that it is surrounded by Franklin County zoned industrial property. Mr. Tippett, if you could go to staff exhibit 8.
That's no.
So this is the Franklin County zoning map from the GIS. And you can see, as I've stated in page 1 of my report, industrial general zoning occurs on all sides of 690 Duncan Road, currently within Franklin County. You do see a small sliver of rural residential off to the east. This property is within 1 mile of I-64 interchange, even less than that to US 60. So for 19 years, this property has been designated for future industrial zoning. In conclusion, I have presented 8 findings of fact. That's based on my education, training, and experience. With that concludes my testimony. I would like for my report and testimony to be entered into the record, and I'm happy to answer any questions.
Okay. Are there any questions from the staff? Any other questions? Squire Blackburn.
Yes. On finding number 1 on your goals, is it appropriate I'm sorry, I've got to get my thoughts together. There's a whole lot going on right now in my head. Let's just skip to number 2, growth by design. Responsibly designed, planned, and managed creates a sustainable community that provides for a quality lifestyle for all residents. I don't feel that the residents in that area, I've not talked to one, that it's been appealing to them. Number 3, distinguished town and country identity. Does large diameter sewer and water lines constitute areas to be for subdivisions? Because I can tell you, I grew up on a farm and we didn't run sewer lines and water lines through our fields. We ran them on the borders. So I would say that every big farm has a sewer line and a water line running down its border. Is it a proximity thing? I don't understand where the subdivision development or suburban development, is it based purely on infrastructure or is it on location as well?
Both.
Both, okay. That's number 3. Number 4, continue to promote the development and quality expansion, environmentally sustainable. This development's outside of an industrial park already it's wanting to be on agricultural zone land. And you said all the land surrounding it in Franklin County is already zoned industrial commercial?
Industrial general, with the exception.
Industrial general?
Yes, with the exception of that small sliver on the east boundary.
Okay, even residential properties are zoned that way?
Well,
industrial general?
Zoning and use are 2 different things. If the home was present prior to the adoption of zoning by Franklin County, or the property owner requested that zoning, then the home can remain as a legal nonconformity.
Okay, so they're paying a different tax base if they live on it. Because I've got a homeowner that lives on said property they were unaware that it was industrial until they looked at their tax statement and they want it fixed. So that's an issue we might have to look at. Another question I have is did you all get the boundaries between the counties straightened out? I know that was something early on, and I just wanted you to state something on that just so everybody could hear about it.
A professional licensed surveyor in the state of Kentucky has provided a legal description as well as a graphic depiction of that legal description that is included within your staff report. There has been no claim against its accuracy by another survey professional.
Okay. Thank you. Goal number 5, protect environmental health. States protect the integrity of the natural environment, including water, air, and land quality by ordinance and by overlay planning. I know that I was there. I was at both meetings at the Planning Commission, and I know Mr. Otis shared some concerns about the water. And I can just say that I've been in this district a long time. I know a lot of people that live there. Duncan Road never ever flooded before Industrial Park 3 was put in 20 plus years ago, and now it does. I'm concerned that we want to make sure that we cover our bases on that. But also going back to the boundary between the counties, I know that the Franklin County, did we pay for that?
No, sir. The applicant did. It's a requirement of the application.
All right. So did Franklin County agree to that, or did Woodford County agree to that as well? Did they receive that as a finding for them?
I believe Woodford County received a copy of it. I can't recall if I sent it to them directly or not. I don't recall. It's been many months.
I don't think it's been agreed upon by Woodford County at this time. So that's something that you may want to look into. We were on number 5. Okay. Let's see here. sorry, I'm jumping around a little bit, Mr. Hewitt. The streams are a big deal for me. That's the beginning of the watershed that goes around through DHL underneath 421. It curves around Governor's Place neighborhood. It ends up dumping into Two Creeks. That particular stream keeps fire protection services, ambulances, first responders from about 300 households when there's an event. So I'm very concerned about that because that's all in my district. And I want to make sure that everything is addressed to make sure that that is not made worse as it was when Industrial Park 3 was developed. Number 6 in your goal is to preserve historic buildings and neighborhoods. You touched on that and said the neighborhood across the street would be preserved. The house that was there wasn't preserved. It's historically significant. And I'm not trying to say how this bears on our decision and how we come about this decision, but it's important to note this land was bought by a commercial developer. He's done a lot of work in Franklin County. He's created some jobs. He's been good for business, but it's not a good start tearing down a house that was only 2 years younger than the state of when Kentucky was created as a state. The general development guidelines for industrial uses in the comprehensive plan says new industrial development should be placed in areas where there is minimal impact on residential use and the natural environment. As you laid out your 7 goals and placed them in a position of benefiting with this development, I feel like I can lay all 7 of them out in a direction that questions every one of your statements. So I just want to make sure we have answers for everything. It does benefit the community as a whole. Does it benefit the immediate community, the folks that live there? That's a question only they can answer. The traffic study. How many traffic studies were made?
Multiple variations. They were built upon based on criteria by the Transportation Cabinet.
So when you did the first study, was it not accepted?
Correct.
And another one needed to be made? Do you know why?
Because the traffic counts were not conducted during school.
Okay.
That's a requirement of the Transportation Cabinet.
And this traffic study was who was this done by?
Diane Zimmerman.
And so Mrs. Zimmerman, I'm sure she's a traffic engineer, probably been doing this for a really long time. And I don't want to question anybody's qualifications, but it seems like a pretty simple, I mean, is that required in all traffic studies?
Yes.
So
He'll do.
There must have been a deal while school wasn't in that day. Anyway, thank you. I think that's all I've got on what your statements are right now, Robert. Thank you.
Judge, if I may respond.
Yes, sir.
First of all, these are not my goals. These are the community's goals and policies that were adopted by your Joint Planning Commission. My responsibility is to analyze these and make a recommendation to the court. While it's we can agree to disagree, my education is in land use planning, and I've done this for over 20 years. So we'll leave it at that. As it relates to the county line, Mr. County Attorney is welcome to weigh in on that, but I don't think that's the question before the court today.
There's a lot of questions before the court today. One we have to decide on is what we're discussing tonight. As you said, they are the county's goals. And you say as interpreted by, I guess, the Planning Commission creates a planning land use committee as well. Was there any public input or resident input when these land use plans were created?
Yes, sir. The 2016 comprehensive plan we're currently working under is a readoption of the 2010 plan. I was staff for that study, and that took 5 years to complete. There were no less than 3 committees, some as large as 35 members.
Were any of the members residents of the area?
I'm sorry?
Were any of the members residents of the area?
All participants were encouraged to be, they're residents of Franklin County. How about that? Franklin County residents, realtors, business professionals, teachers. We asked for a wide range of individuals to participate in the 2010 study. The 2010 was the largest change to the comp plan since 2001.
And I'm glad you seek a wide assortment of folks with different professional credentials. I think it would be appropriate to make sure that we have people representing all corners of the county in our future studies, instead of just, I don't know that anybody that lives in that area was on that committee. So when it says we represent the whole entire county and these goals represent the whole county, I've had a lot of folks in the county saying the way that they're written on these findings that you have submitted don't represent them, and that's just my statement. And I understand. I agree to disagree with you. It's a matter of interpretation. But that's all I've got for you right now, Robert.
Thank you.
Okay. Are there any other questions from Squire Booth?
Thank you. I come from, grew up in a county, was one of the first counties in Kentucky. In Western Kentucky, it was divided up into 10 or 12 counties since then. But when I ran for magistrate here in this county, I thought, no one will vote for me because I haven't lived here long enough. I wasn't born here. I didn't grow up here. And that is important, I'm sure. I was elected, I guess, thanks to the common sense of Franklin Countyans. But my point is that people from the outside coming in and making decisions about land that is valued by Franklin County, especially the citizens that live in around that land that is in question, have are kind of shell shocked by the heavy boots that came in and just took over the land. And I think that we, as a county, should be asking, can we trust this developer? And trust is the main component of our relationship with this zone change. I'm not saying that the zone change is bad. I can understand why we need it. And if we can improve our economic health, that is a good thing. But the trust that comes with our county government, if we do not enforce what we have, our people before us have instituted, then where are we? We have nothing. Trust is everything. And I personally do not trust the developer that came in and tore down a historic building and caused water damage. And then on top of that, didn't bother to read the fire code that is prevalent, or law in this county. Sorry. So that is my main, it's not a question, I guess, but I will ask it anyway. You, Robert Hewlett, as the Director of Planning and Zoning, do you trust the developer that is at question in this zone change?
Ma'am, I don't think that's an appropriate question. My job is to administer the regulations to anyone that makes application for development within the unincorporated areas of Franklin County.
Well, that is an invasive answer in my opinion, but I accept it.
Question.
Mr. Sparks, do you want to intervene on that type of question?
Members of the court, I would remind you, and I appreciate this discussion, and it appears that this is an opportunity perhaps to air grievances at this point as opposed to focus on the statutory issues before you. Mr. Hewitt is attempting to present to you the report based on the application of the applicant to change zoning. Your duty today is not necessarily to address future usage, what's going to go there, how it's going to be built, what's happened, etc. Those are valid and important issues. Those are valid, important issues for the community, and I don't want to minimize those. On the other hand, you will be judged on your decision as follows. Number one, based on the application and its completeness and information contained therein, whether or not the zone change as proposed is consistent and in agreement with the adopted comprehensive plan. Not what's going to go there, etc., but whether or not the proposed zone change is in agreement with the comprehensive plan. In the absence of such a finding, you must find that one or more of the following apply, and I'm reading right out of 100-213, that the existing zone classification is inappropriate and the proposed zoning is appropriate, or there have been major changes of an economic, physical, or social nature within the area involved which are not anticipated in the adopted comprehensive plan and which have substantially altered the basic character of the area. Considerations of residential areas, consideration of flooding, etc., in the area as to the change is important. Don't get me wrong, but I would be remiss if I did not remind the court that your job today is to determine whether or not one of those three things exist based upon the testimony and the report contained therein. It's not a question of what the classification, the zoning is going to be. It's not going to be a question of how many people was on the committee 20 years ago or 30 years ago. It's where it stands right now and whether or not the proposed zone change is appropriate and in agreement with the comp plan. And if it's not, whether things have changed, etc. So as you continue your deliberations and as you make inquiry before the various witnesses and presenters before the court, including Mr. Hewitt, who still has yet to complete his report, please be mindful of what you're doing here. And it's to consider the zoning, not the actual activities. Those will be governed by a whole different set of laws. They're important, don't get me wrong, but you can't muddy please don't muddy the water, because that's what you're here to do, is the 213 standard.
Thank you, Mr. Sparks. Mr. Hewitt, do you have any other testimony?
No, sir.
Now I've got some questions for Mr. Hewitt, Judge.
Okay, you do? Okay, go ahead.
Just to wrap it up, I guess, to bring it on home. Mr. Hewitt, have you had an opportunity to review the application for the zone change?
Yes.
Is it complete? And if you had an opportunity to review the contents contained therein?
Yes, it is.
And have you had an opportunity to compile a report and make recommendations not only to this body, but to the Planning and Zoning Commission?
Yes.
You have a copy of that report?
Yes.
Has that been presented to the fiscal court?
Yes.
In that report, did you make recommendations to approve or disapprove the zone change?
Yes.
And you set forth specifics as Squire Blackburn went through as to the basis, whether or not it is in compliance with the comprehensive plan, et cetera. Did you not?
Yes, I did.
And those have been presented to the fiscal court. So now they get an opportunity to further ask you those questions if they choose to do so. Is that right?
Yes.
Have there been any changes to your report or your recommendation since that was presented to the Planning Commission on January the 9th, 2020?
As I testified earlier, staff recommended findings of fact number 7 and number 8 were added on page 14 of the staff report and entered into the record.
And those have also been provided to the members of the fiscal court so they can inquire further as to those details. Is that correct?
Yes.
And in that, that's what the court gets to decide. Your recommendations was to approve the zone change. Is that right?
Yes.
And have you introduced to the court and to the formal record your report and recommendations, good, bad, or indifferent?
Yes.
Have you introduced those yet? If I missed it earlier?
I have. Yes.
Okay. With that being said, no, Judge, I was just trying to perfect the record to make sure that report was formally entered and the terms are contained therein. And now to give the court the opportunity, if they want to ask questions as to those recommendations, focusing again on the KRS 100-213 standards. And that's all.
Thank you, Counselor. Squire Tracy.
Thanks, Judge. Thanks, Robert. Just one quick question. You mentioned traffic study. The traffic studies that were performed by the State Transportation Cabinet on Duncan Road, would it be the same type studies that were done on Versailles Road out by the interstate? Are they the same type? Are they different?
There was a separate study performed by the Kentucky Transportation Cabinet and adopted last year, in which it's known as the Urban Area Transportation Plan. Is that what you're referring to?
Yeah, I guess I'm just trying to find out if we all know the bottleneck that the Versailles Road turns into. So I guess I'm trying to find out, you mentioned buses and things like that, but were the factories letting in and letting out, were they taken into consideration when the traffic study was completed on Duncan Road?
And both the applicant's traffic engineer and the Planning Commission's traffic engineer are on the meeting and can answer that directly. I will let them answer that. But I can't answer whether or not the state's urban area transportation study included the same peak times that the applicant's traffic engineer used or not. But I do have a copy of that urban area transportation study because it is also, I think, referenced in Mrs. Zimmerman's revised January 8th, 2020 study.
Okay, thank you.
Yes, it does show improvements to Versailles Road, to address your question, the bottlenecks.
Squire Muller.
Thank you, Judge. Robert, thank you for presenting tonight. Quick question. What is the SOP for our planning and zoning to distribute the future land map, the comprehensive plan? Do we put it out? Do we mail it or anything? Or is it just if you find it, you get it?
We have it on the county website. I believe the city has it on their website as well. Historically, the county wasn't very tech savvy, so we didn't have the opportunity to put it on a website, but now that we have the new website, it's there. Along with our zoning ordinance, subdivision and development plan regulations, stormwater regulations, floodplain ordinance. It's all under the planning building codes portion of the website.
Okay, thank you.
Yes, sir.
Anyone else? Squire Sebastian.
Thank you, Judge. Robert, I just had a question. We've discussed the application and our attorney, Sparks, has brought up the application. So as I understand it, Franklin County zoning ordinance requires that An application form has to be submitted to the Director of Planning and Zoning. And all applicable information on the form has to be completed for that to be a whole document for you to review. And so the zoning application requires that if a proposed change involves only a portion of a property, then a full survey has to be conducted by a registered surveyor. Do we have one of those? I was looking through here to find that because it was noted in some documents that condition existed. I could not find where that condition was satisfied. Thank you.
Yes, ma'am, we do. We have a stamped legal description that's in your packet. And then we have a graphic of the survey of the legal description, also stamped. The surveyor certification is number 3.
What page is that on, Robert? I'm just trying to sort through this about 1,500 pages of material that I've read. I'm just trying to find it. That's all. Thank you.
You're welcome.
What page is it on?
Well, Mr. Tierney's attorney has supplemented some additional information, and it's under tab of his submittal as well. It was part of the Google Docs you received.
So was that in the Google Dropbox, or was that part of the bound document?
Part of the bound document.
The bound document of the applicant.
All right, thank you. I'll look at that right now. I had missed it in this other 1,500 plus pages. So sounds like maybe it's provided in the June 9th document. Thank you very much. I'll take a look right now. Thank you.
Are there any other questions? Any other questions? Mr. Hewitt, do you want to present a traffic engineer at this time?
No, sir. I believe perhaps the applicant may have a question.
Okay. Okay.
But the Planning Commission traffic engineer, I just have them available for questions if need be.
Okay. When would you like to bring them on if there were questions?
Immediately, if there's a question. If there's a question related to
Zimmerman is here
That's what I was asking you.
online.
Well, if you don't mind, Squire, hold on, please. Wait till you're called on. And so, just a point of clarification. Is the applicant gonna present a traffic engineer? Okay. Okay, all right. That's what because I've heard questions about a traffic engineer and I didn't know when to bring them on. Okay. Mr. Rump, do you have any questions for, as the applicant for Mr. Hewitt?
I do.
Yes, sir.
Judge, he'll stay there and I'll move.
You can come right here, please, sir.
Yes,
Yes, sir.
Pick me up.
Yes, sir.
Mr. Hewitt, there's been a lot of discussion about a comprehensive plan. And as Mr. Sparks told us, it's sort of central to the issue here tonight. Can you tell the court members what in land use planning, is there a set of statutes that governs that? And then is there an ordinance that governs that?
Okay, yes, thank you. There is a provision in KRS 100 that says if you choose to adopt land use regulations, you must first adopt a comprehensive plan. That comprehensive plan is prepared by the Planning Commission. Goals and policies are submitted, in this case, to the fiscal court for you to adopt and then to send back to the Planning Commission, and they complete the remainder of the document.
Now, you talked about, I think it was Squire Blackburn or maybe it was Squire Sebastian were asking you about what the Planning Commission does to put together this document. You mentioned that the 2010 plan, there were 3 committees that met over 5 years. Now, who chooses these members of this committee? Is it a closed club, or do all people have a seat at the table, or how does that work?
Thank you. So the chairman of the Planning Commission establishes a selection committee. That selection committee ultimately becomes chairs of the subcommittees, which would include infrastructure, transportation, housing, and population. And so those chairs, if you will, present names back to the full committee for their respective committees for consideration by the full commission.
And then each of those committees has a chair.
Yes.
And do these committees have meetings?
Yes,
Are
public
they public meetings?
Yes, sir.
Can any
meetings.
member of the public come?
Yes, they're advertised.
Are they advertised in the newspaper?
Yes.
And I assume, looking at your all's website, it will be well advertised to anybody that wants it. They're not held in secret, I guess is what I'm saying.
That's correct.
Does the Historical Society have members on that committee?
Yes.
Does the Envision, Frankfurt Envisions, do they have members on the committee?
Yes.
And also the industrial folks, the commercial people, the whole blend of people. Are farmers on the committee?
Yes.
Can you generally describe, well, maybe I'll just ask you sort of in a leading fashion, is the reason you have a comprehensive plan is because a community that wants to have a planned development and operation, they need goals and policies that set forth the needs of the community and analyze all the land in the community to come up with a manner of utilizing that land to meet the needs of the community.
That is correct.
And part of this comprehensive plan is a large degree of determining the needs of the community. Is that correct?
That is correct.
And then after the goals and policies are set, we've heard some talk about this Exhibit 6, the future land use map. Does the committee review a map of existing zoning and then a map of properties that perhaps might help the community reach its needs and goals, and identify properties that might suit those needs and goals?
Yes, they do.
And is that how, I think Squire Blackburn asked, are there any of these goals that are more important than other? And you answered to that, no. But as part of this process, does the comprehensive plan committee take in consideration the goals and then identify properties that meet those goals or help meet those goals or best meet those goals?
Yes,
Is
correct.
that it?
Yes,
Okay.
sir.
And then you mentioned the process-wise here. These committees make a recommendation to the Planning Commission, and then they send this up to the Fiscal Court and the City Commission, and it gets approved by them as well. It has a legislative stamp on it.
Correct.
And that's the final adoption of the plan.
Yes.
So, and this was done in 2010 comprehensively, and again, looked at in 2016.
Yes.
And now the process is starting to do that again.
Correct.
Now, in your job as the director, when somebody brings, or somebody just makes an inquiry, doesn't make bring an application, just makes an inquiry. Hey, I would place to put a commercial activity or a subdivision or whatever. These maps are all publicly available, but do you assist them in identifying properties at times?
I do, yes.
Okay. And what do you rely on to do that?
The comprehensive plan
And the future land use
and the
map.
future land use map, yes.
When the Frankfurt Plant Board meets and they try to decide what size of sewer line to run to a particular piece of property, do they rely on the documentation from your office?
We do communicate future growth, yes.
Okay. And likewise, on stormwater management is a #1 problem in every community. And is that something that utilizes the future land use map in order to do that?
Yes.
Your utility with water and sewer, they would be very interested in knowing where development is going so they can plan that direction.
Correct.
Is that correct?
And to determine their available capacity.
Gotcha.
Sir, yes.
Now, just a couple more questions. Your staff report, are all the facts in that report true correct to your knowledge and belief?
Yes.
And are the opinions expressed in that report, I think you said this a little, but are they based upon your knowledge, education, and experience, over 20 years of experience as a planner?
Yes.
That's all.
Okay. Mr. Hewitt, thank you.
Thank you. I'll be available for more questions.
Okay. Mr. Rom,
Yes.
as the attorney for the applicant, will you please present your case?
Yes, I'd like to present Mr. Ron Tierney, the applicant, the member of the applicant, Ron, to tell us a little bit about his application.
Okay. Mr. Tierney, welcome.
Thank you. Mr. Tierney, I remind you, you're under oath.
And please speak your name, tell us who you are.
I'm Ron Tierney with Tierney Storage. I reside at 20 Red Bud Lane, Winchester, Kentucky.
And Mr. Tierney, what is your position with Tierney Storage?
I'm the operating director of Tierney Storage.
And what is Tierney Storage?
It's a company that we develop land, we build warehouses, we lease warehouses, we sell property, but it's land development primarily and warehousing.
Do you build other buildings other than warehouses?
No, primarily warehouses, but they're oftentimes converted over to manufacturing facilities.
For instance, in Industrial Park number 3 here in Frankfurt, there is a company, I'm going to say the wrong name, HTNA, is that how?
Yes.
And was that built initially as a warehouse?
Yes, it was originally, the first building was built for Philip Morris. They had a tobacco receiving station there. They left along with the tobacco, and then we got involved with HTNA.
And what does HTNA do?
They manufacture automotive parts for Toyota and various automobile manufacturers.
And has other of your warehouses here in Frankfurt been converted to manufacturing facilities?
Yes, we've got 107 Prosperous Place that is a auto manufacturer. We've got a Fayette County school bus garage in Fayette County that is now that. Buffalo Trace warehouses with us in some facilities.
I'm talking about any other manufacturing. Does sometimes other manufacturing occur in these warehouses?
Yes, yes. And Kentucky Department of Health has a facility also where they're providing PPE equipment for the state of Kentucky.
The Tierney Storage, is Frankfurt the only location that it's operated in, your company?
We've got facilities in Winchester, Kentucky. We've had some in Lexington, but we primarily go up and down 64.
And does the company do the construction itself, or do they hire out that, or how's that work?
We do quite a bit of the land development, and then we will hire out for the steel erection, the concrete work, and that type of thing.
Have you had how would you classify your relationship with the Frankfurt community and the government in Frankfurt concerning all the rules and the regulations that one must follow in order to do development work?
There are a lot of rules and regulations we comply with.
Have you've heard some mention? I think Squire Booth mentioned that you've done some things that perhaps would generate a lack of trust, and you've done some things perhaps that might have violated. I think she mentioned burning, something of that nature. In your business, first of all, how long have you been in business?
40 years. And
have you endeavored in your business to engender trust?
Yes.
And have you?
That's how we sell.
But I mean, even with regulatory authorities, you work with them in order to meet their requirements?
Yes, we work with them very well. I feel like they would say we do well.
For instance, and also in Clark County, how many buildings have you developed in Clark County?
We've done 32 buildings in Clark County.
Okay. Now, do you hold any position in Clark County regarding?
I'm president of the Industrial Authority in Clark County.
So in effect, you hold the position that Terry Bradshaw's the hired person. Right. Mr. Will.
Right.
Mr. Will holds your position here in Franklin County. Do you work with developers there?
Yes,
Were you elected to that position by the other members?
yes.
Is that the first time you've held that position, or
No,
did they
I've
bring
been
you
on
back for another
I
term?
was on the board for 18 years and they brought me back. This is the third year.
Okay.
I've been on there.
Tell the board a little bit about Tierney storage personnel.
I have my son Patrick that works with us. We also have Jeff Hurst, who's a local Clark or Fayette County or Franklin County resident. He's a principal in the company as well.
Okay. Do you also employ engineers and surveyors and things like
Yes,
that to assist
yes.
you?
We work with operating or engineers like HMB is doing work with us. Traffic studies done by the engineers.
Okay. And what's your what's your tact on the type of professional you want working for you?
We want somebody that we can get in touch with and that does a responsible job and can guide us in the ways we need to do.
You need to get it done correctly.
Yes, right.
And have you found that HMB and Diane Zimmerman and Jared Stevens, those have all been responsible people to work with?
Very good.
I think, did not HMB, were they formerly the engineer for either the city or the county over here?
Right.
The present application, you've asked that the property at 690 Duncan Road, at least 85.38 acres in Franklin County, be rezoned.
Yes.
And you've asked for a rezoning to employment center / mark IG industrial general, I guess is what that stands for. Why did you choose this property?
We came here in 2006 to develop a property for stock lumber, and then we built a couple other buildings, and then we built the Philip Morris thing, and then we've developed several properties in that. And as I was sitting on a bulldozer up on top of a grade on the last building we built, I could see the grade of that farm over there, that it worked in with the grade that we were working on that particular building. I knew we had water because it was on the property we developed. The water, sewer, and electrical.
Is it also proximate to others?
Right. Yeah, we butt up to it on three sides ourselves.
Did you start to make some inquiry about the property of the government officials, perhaps the planning office or whatever?
Right.
And what did you learn when you made that inquiry?
That it was in the comprehensive plan that it was to be a employment center, which works for us. And then we did some exploring about the historic value of it, that type thing. We had the house inspected, and by a reliable reconstruction person, he said it's in such terrible shape, the walls are full of mold and water, that there was no way that it was salvageable. And our insurance company saw it and said, you have to get this, you got to do something with this building because it's going to hurt somebody. It will fall in. You wouldn't want to go up on the top, on the second floor.
Did you also seek some professional advice about the possibility of land use here, or utilizing the land for a industrial use?
Yes. Right.
I think you began with talking with Andy Layson, who's an engineer who's now, I guess, retired.
Yep. And HMB has taken over that position. We've done core samples of that land, things like that, so we know what actually is on the property.
And when you did that much exploration, did you find it suitable to go forward with the idea of purchasing the property and making it and developing it into an industrial park?
Yes, did. I feel like we can do the water retention. We've got probably in the development plan, there's probably 35 acres that are devoted for water retention that we can put 3 or 4 different detention areas on it that will reduce the amount of water that comes off that property from developments.
Have they, in putting together the plan, did you actually go out and purchase additional property that could be utilized in this development?
Yes, we HT&A had bought a piece of property from us and we saw that it would connect to this farm at the backside, and that would give the industrial park a second exit out of it. Because one time there was a truck that turned over down at the original, or the entry to the industrial park, and shut down the industrial park for 4 hours. That was not very well received.
I put up on my screen share a document, and can you identify what that document is?
Yes, that's where we purchased the property to build a entry off of Fortune Drive into the back of that property.
So in effect, you repurchased the property that you had sold to HTNA.
Yes.
You repurchased part of it.
Yes. A strip of,
in order to do that, did you have to commission a plat of the property?
yes, we did.
And I put the plat up there, and is this a plat that Mr. Stevens did at your expense? And I'm going to try to use my cursor. Is this the corner
Yes.
where I'm pointing there? Is that Fortune Drive?
Yes, that's where Fortune Drive came down and cul-de-sac.
And is this the piece of property that you
Yes.
purchased from HTNA?
Yes, it is.
And what was the purpose of purchasing that piece of property?
So that we could have a second exit in and out of the industrial park, as well as to serve that property. We could make do going out just on Duncan Road, but this makes it much safer in order to do that.
Now, I'm sort of jumping ahead a little bit, but this is a document that has been produced and is filed as a tab delivered to the fiscal court members. And the reason I'm showing it now, I'll go into it in more detail later, but does this show on it that same platted area where I'm putting the cursor? Is that Fortune Drive? And does it show that
Yes.
same? I'm running down
Yes. Right.
that tract of land,
Yes.
and then the tentative roadway would run
Yes.
around here
Yes, it
and
is.
connect and go out exactly the same place that the entrance is now.
Right.
So would that roadway area and the roadway that you might build, would that interconnect all these properties over here on Industrial Park number 3?
Yes, it
Right
will.
now only have one exit, but if this is approved and this street is built, it will have another exit going out here.
Yes.
And likewise, anything you do on your property could go out through Industrial Park number 3.
Correct. And it'd
Now-
be built to county specifications if the county decides to accept that street.
Now, we've talked in general about, I'm really concerned about Squire Booth's thing about you being trustworthy, okay? So I'd like you to tell the commission, did you build these buildings over here?
Yes, those two there.
Okay, and are those buildings occupied now by
Yes.
tenants and paying
Both are fully occupied.
and this building right over here, is this a building that you built?
Yes, that's a stock lumber. That's the first building I came down here and built in 2006.
And this series of buildings right here, did you build all those buildings?
Yes, that's the compound that HTNA operates out.
So that's the manufacturing compound there in Industrial Park number 3 that
Right.
you're responsible for?
About 300,000 square feet there that they have 300 people working on it.
And this tract of land right here, this is an older map, but is that 101 Corporate Drive?
Yes.
Are you building a building there
Right.
at this moment?
We just completed a 112,000 square foot building there and occupied it this week.
Now, you didn't build this building, did you?
No, I didn't. We
Or
built
this-
another one on down over the hill, and then we built.
It's not shown on this map.
Yes, right.
Okay. But all these, when you say you were sitting on the bulldozer on the hill, it would have been when these buildings were under construction.
Yes.
Now, in building all those buildings, I think there's an exhibit here that Terry Bradshaw put together, showed the assessed value of all that property. But did you have a lot of contact with the building code office here in Franklin County in terms of finding out what it needed to be done and whether you could comply with it and all that kind of stuff?
Yes, we have to go through all that in order to get a permit to build a building. We also have to get, on these size buildings, you have to get a state permit as well, and they review all the plans.
And did you have any difficulties with the planning office in working out the differences?
No, I had a question, they'd answer me, and that's the way we built it. Because they're the ones that do the inspections, and you do what they say.
And in your opinion, as a quote professional developer, is this property suitable and appropriate for the development of industrial park and having?
Yes, with the infrastructure that surrounds that property and the being within a mile of the interstate, it makes a very attractive property to develop.
Now, have you, the conceptual plan that I put up there, are you, I'll put it back up, okay? I'm sorry, I should not have taken it down, I guess. Just a second. I'm not the best at this, nor am I the worst. But there you go. It's coming. While you're up here, I mean, I'm going to ask your engineer, Mr. Gregory, about this, but the bright green boxes here, have you discussed this with your engineer to put together this conceptual plan?
Yes, they're the ones that developed that.
And based upon their recommendations, there are 1, 2, 3, 4 green boxes.
Right, those are the water retention areas.
And those are the areas where the engineer told you you needed to set aside and use for storm detention.
Right.
Or might use it, depending upon their calculation.
Yes.
Are you committed to setting aside those areas on this property?
Absolutely, we're required to by the Division of Water.
Now,
we'll do that.
There's a notation on here, and I'm gonna blow it up on one area. One area of the map, and I don't know whether it'll be visible to everybody, but right there, it says remaining green space approximately 82 acres total. So basically, this conceptual plan says out of the total of 103 acres that Mr. Hewitt testifies in this major tract, 82 of that will be remaining, which would include this roadway. So it's not all green, but 82 of that will be basically green space.
Correct.
And the only area right now that's being looked at is basically building on the top of the ridge there in that shaded, that blue shaded area.
Correct.
Let me run it up there. I'll talk more with Mr. Gregory about this, but I wanted to have your testimony that are you committed to do what is required by the planning office and based on the calculations made by both the planning engineer, Mr. Otis, and your engineers, HMB, to contain the groundwater runoff from the development of your property? Now, this is already a detention place, right? There's a pond over here.
Right.
And you plan on keeping that pond.
Yes.
And I think from talking to your engineer, expanding perhaps the pond or making it larger.
That was their plan on it, yes.
So it would lay more water.
Yes, we do plan on doing all that.
So I think that's all I had.
All right.
Judge.
Okay, thank you, sir. Are you going to, it's now the court's turn to ask questions. Do you want to be up here as well, or how do you all want?
No, he can ask.
He can ask. Okay. Okay. It's now, Magistrate, it's your turn. If you'd raise your hand if you have a question for the applicant. Mr.
Judge, before the court goes, can I ask some questions regarding the application and the proposed zone change?
Please, sir.
And hello, Mr. Tierney. This is Rick Sparks. As you heard me describe to the court their role under the statutory framework for a zone change requires a finding that your proposed zone change is either in agreement with the comprehensive plan that is taking it from agriculture to general industrial, or in the alternative, the the zone classification currently is inappropriate and your zone change is appropriate, or there have been substantial major changes of an economic, physical, or social nature that were not adopted or anticipated, which have substantially altered the basic character of the area. You are seeking a zone change to IG, is that correct?
Yes, sir.
Which one of those factors do you believe support your zone change? That is, are you asking the court based upon your argument or your position that the zoning allows that is the existing classification, or it is in conformity with that? Or Are you saying that it's changed, or are you saying that it's inappropriate?
I think it's all three items are appropriate.
Well, that's fair. It's the statute refers to or, so I'm going to ask you, you kind of got to pick one. Which one are you saying that should be the rationale? Is your position that it is in conformity with the existing comprehensive plan?
Yes, sir. And to be used as an employment center.
Yeah, Rick, this is John Rumpf. We have submitted proposed findings of fact, a proposed ordinance. I will state for the record that we believe that this proposed map amendment is in agreement with the comprehensive plan, or alternatively, as recommended in the staff report, the proposed zoning is appropriate and the existing zoning is inappropriate. We do not stand and rely that there have been changes of an economic, social nature in the neighborhood since the adoption of the past comprehensive plan, which changed the nature of the neighborhood in order to do this. This comprehensive plan was adopted in 2016, and we're not saying there's a bunch of activity out there since 2016. We're more relying on the fact that since 2001, the planners in Franklin County designate this property as appropriate for industrial use and put it in the comprehensive plan on the map as meeting the goals and policies.
Okay, the reason I'm asking that is I don't want the court to lose sight of that issue. And there's been a lot of discussion about the weathers, et cetera. And I wanted my court to be clear as to what, and thank you, Mr. Rumpf, what Mr. Tierney's position is as to the underlying fundamental basis of the zone change. And I understand then that you're asking it to be changed, arguing that it is in conformity with the existing classification. And the zone change is consistent with the current comprehensive plan. Is that correct?
Yes, sir.
That is correct.
Okay. Thank you, sir. Thank you, Judge. Thank you, members of the court.
Okay, thank you, Mr. Sparks. Questions from any magistrates? Squire Blackburn.
Yes, sir. Mr. Tierney, thank you so much for coming tonight. Thank you for your large investment in our county and all that you do to bring growth. I appreciate it. I just got a few questions for you. You've been doing this for 40 years, correct, sir?
I was in the roofing construction business for 20. Then I evolved over into where we were building commercial buildings.
Thank you. Have you ever demolished any buildings before?
Have I what? Ever demolished it?
Yes, sir.
Yes, sir.
Were you required to get permits when you did that?
No.
No. Did you know that you had to get permit to demolish buildings in Franklin County?
No, I did not.
Okay. Okay. And okay. So also, have you ever built entrances onto roads before?
Yes.
Are you required to get a permit when you do an entrance onto a road?
Yes.
Did you get one accessing your latest property on Commercial Drive?
Yes, up on 101 Corporate Drive, that one on the corner. Yes.
Right. You did get a permit?
Yes.
Um,
Or we go out on to Corporate Drive.
no, coming onto Duncan Road from that property that faces Corporate Drive.
That was a electrical easement access, and that was originally a road up to a barn. The Mr. Musey, who has farmed that area for 30 years, said there was a barn up there at the top of that hill, that was the access road to it because it wasn't on the Duncan Road or the 690 property. There was a road there, and we did utilize it to access the utilities there and the pile of dirt that we had piled up there. We did access it there, but it was a road. You could tell it was a road because it was as hard as it could be.
Did Mr. Eaton from the Kentucky Transportation Cabinet tell you to not use that road again?
Yeah. He just agreed that it was not a road, so we did away with using it as a road. The utility company still used it as an access because they needed to access it for the utilities for that. Once they finished, it was all seeded back, and now it exists as part of the yard.
Okay, because I've been out there several times and saw one day it had gravel, the next day it had straw and grass seed, and the next day it had gravel, and the next day it was open, and the next day it had concrete barriers. So, and I know that you had received a cease and desist letter in January not to use it again. So I was just wanting to get your side of it.
Right. Barriers up, but the utility company says that's the way we want to access it because our utility lines are right over that. So they took their truck and moved the barriers. But they're all gone out of there now, and we've got it seeded back. They're done with that. We put them in access around the back of the building.
Now, was that dirt at the you were talking about at that access road? Was that a berm that was in place as a barrier?
No, that was topsoil that we took off of that site and then kept it there in order to do the finished grading around the site.
Okay.
That berm, the berm existed there. That was put in when Corporate Drive was developed. There was a berm there. Now we added on to the top of it, but it didn't interfere with any visibility.
Okay. Sorry, I'm taking so long. Tell you what, maybe we'll let somebody else go, and I'll recapture my train of thought here.
Squire Booth.
Thank you, Judge. I want to ask Mr. Turney if he feels that it is his responsibility to abide by the planning and zoning rules that have been put in place in Franklin County.
Yes, ma'am, I do.
And that you will abide by those rules. And if you don't know what the rules are, that you will ask the directors of the planning and zoning what they are.
Yes, ma'am, I will. And he's very cooperative in giving me advice on anything that needs to be done. And our engineer works directly with him.
Oh, who is your engineer?
HMB Engineering here in Franklin.
Yes, I'm familiar with them. Which engineer do you deal with?
Brad Gregory.
Thank you.
Any other questions? Squire Muller.
Thank you, Judge. Thank you, Mr. Turney. A couple questions. The acreage in Woodford County, are you looking to do a zone change there also?
No, I do not. That will remain agricultural and be a buffer between that commercial property and the residential that's there.
Okay, thank you. And then couple others. When exactly did you purchase the farm there? What was the date on that?
July 19th of last year, I think. It's in July
in 2019.
2019.
Okay, thank you. And then when was what was the date that you applied for the zoning change?
I think it was, not sure what it was.
Hold on a second, Squires. Mr. Hewitt's looking that up.
January 9th, 2020.
Just curious, is there any reason that you waited so long, since you bought it? Just curious.
We were delayed on several things, and we didn't have an entrance we could even get into with the thing. I had a farmer that had 800 rolls of hay up there. He couldn't get out because he could only take them out one roll at a time. So we did some widening of that agricultural road to get it done, and then it took that long to get to it.
Okay, thank you, sir. Appreciate it.
All right.
Squire Tracy.
Mr. Tierney, thank you for coming tonight and being here. Just a quick question. Considering some of this property is located in Woodford County, have you and or your professional development staff spoken to and or presented the plans for stormwater retention and or water runoff to the Woodford County Planning and Zoning, and how this development may affect parts of Woodford County? Have you heard from them?
On that drawing that you saw, there's one catch basin that addresses the Woodford County area. It's there's one valley that goes down in there that will have a retention pond on it.
And Woodford County Planning and Zoning finds that sufficient and signed off on that?
That part's not in Woodford County. We're not doing anything on the Woodford County property.
Okay, so my question would, this development here, as far as the retention and or the water runoff, would it have any effect on that property that's in Woodford County?
No, it should not. That retention pond that's down at the very bottom of that screen, that is all is in Franklin County, but that would retain any water that came off Franklin County before it went out into the Woodford County area.
Okay, thank you.
Squire Sebastian.
Thank you, Judge, and Mr. Tierney, thank you for being present tonight to go through some of the particulars with us. We appreciate that. I wanted to, in one of the maps that was presented by our planning director, he said that there were sewer lines and some other infrastructure that was adjacent to the property that you have purchased. Will you be running the extension of the sewer lines and the water lines, et cetera, to the property that you've purchased?
Yes, ma'am, we would.
Okay. And can you tell the court how long, if you know this, or if someone in your organization knows this, how long that property was for sale before you purchased it?
About 12, 14 years.
Thank you, sir. I just think that's important for people to know that it has been for sale for quite some time before you came in and purchased that. Thank you very much.
I met Mr. McDonald when he still lived there when I first started developing property in Franklin County. And then he's left after that and nobody maintained the property. So.
Okay. Any other questions from the magistrate? Squire Moore?
Is Robert Hewitt still nearby?
He is.
Yes.
Go ahead and ask your question.
Robert, if I've got 100 acres and got a house on it that I want to tear down, I don't have to call you, do I? I don't need any permits. I can tear that house down. It's industrial. It's not industrial property. It's farmstead.
We do have now what's known as a farmstead exemption form. No permit is issued. There is no fee. It's just a matter of documentation.
Well, isn't that mostly just so that you take that house or whatever off of the tax rolls, it's
Yeah.
not really, you're not required to do it. It's just really to your benefit to do it, right?
That's correct. We perform no inspection. It's for your benefit, so the PVA office knows that that structure was removed.
Correct. Okay, that's all, Mr.
Thank you.
Mr. Tierney?
Yes.
There's a rumor that that was your truck that turned over in the entrance, blocking all access to ambulances or fire trucks. That's not true either, is it?
No, sir, it is not. That belonged to Petco. They were removing the debris from the fire down at Jim Beam Distillery. They came around that curve and turned it over.
Right. Yeah, we were in there at that time. I had been, I wasn't at the time, but we had people in there and it was a very dangerous situation. And
Right.
gladly they took care of it pretty quick. That farm used to have a pond right there beside the driveway that retained a whole lot of water and it kind of leached out of it. Did you fill that pond in?
Yes, I did. That was the nastiest hole.
Yeah.
Crap I ever saw. There's algae, nothing but algae and snakes and poison ivy. It took me 3 weeks to get rid of the poison ivy. I got just opening the gate.
Yeah.
It was no retention to it at all.
And the house on the property, was it rebuildable? Didn't it have trees growing up through it you can see from the road?
Right. And I had JWI Construction out of Winchester come and evaluate it. He does historic renovations. And he was in there about an hour and he came out and said, you don't want to do anything with this. The roof has not been taken care of for many years. And the walls are full of algae and moisture and the bricks deteriorated. The brick was falling out on the inside of the house and the floor was, he didn't go up the second floor because it was too dangerous. You can see it fall in.
I know I'm veering from what we're really supposed to be talking about, but I just wanted to get those points out there as well as what other points have been made. Thank you, Mr. Attorney.
Thank you.
Squire Blackburn?
Yes, sir. Mr. Tierney, you stated you bought the property in July of 2019, and you bought it with the intention of developing it. Is that correct?
Yes, sir.
And did you do any land disturbance in between the time of July and January 9th of 2020?
We filled in that old pond, and then we took down several trees that were in fence rows and stuff like that.
Were any of those trees in the fence rows part of a buffer zone for the factories that were in Industrial Park 3?
Not to my knowledge. There was no buffer. I own 119A, which butts right up to that farm. And there was just a bunch of scrub trees there and an old fence row. It was not a buffer at all. If it had been a buffer, we would have been required to put evergreens in there, but those were not buffer trees.
Okay.
They were just trees that were left in fence rows, and very few of them. There was no nut trees up in there at all because my guys like to hunt, and they said there's not even any trees up here. Most of them had been struck by lightning, were falling down. The old fences were decrepit. So we had a machine and we took and cleared that stuff up.
Okay. Did you have to get a land disturbance permit?
To cut a tree?
No, to clear land, to bulldoze dirt, to fill in ponds, to widen roads, to disturb land?
Supposedly we were doing less than an acre, and that pond was probably not a third of an acre.
Okay. I noticed that all the maps that we've been shown tonight are old maps. They're pre 2020 maps. Because you started doing some things immediately when you bought it. Would you consider those things were agricultural that you did?
Yes, sir, I do. And it's still agriculture.
Did you run I noticed I was out there one day and I have never been on the property, but I'm just at the road. Did you run a drainage line from your new warehouse out into the property on 690 Duncan? From the industrial property onto the agricultural property for drainage?
Yes, we did, because
it's buried.
There was a sewer line that was faulty right there at the edge of that property. We had to take that sewer line and rebuild it. And the Frankfurt Plant Board preferred not to have a retention basin right against that thing. So we just used a small area on the other side of that sewer line for the retention pond for that building, and put the weir, the water retention weir in that area there. And it made everything work much better. They didn't want a retention pond. They didn't want a manhole in a retention pond.
I'm sorry, I'm confused. Are you saying you made preparations to put the retention pond on the 690 property or on the Consumer Drive property?
I eventually put it on the 690 property, which kept from disturbing the sewer line we had to reconstruct on the 101 property.
Okay, on the agricultural property. Okay. I'm still a little curious as to what we're considering Woodford County when Woodford County government disputes the survey that we have. So that's a question that I think we're going to have to talk to them about to get straightened out.
They had a tax bill that had the right amount of acres as to what the new survey was, the 18.031 or something like that is what the tax bill was sent to me on. So apparently somebody accepted something somewhere.
Well, I understand you're going by with what you have and what you've been told. And I just want to make sure that our neighbors on the other side of the fence, or in this case, wherever that line falls on that property, are okay. I don't want it to create a bigger mess than what a lot of people are already thinking it is. So I just want to make sure that that's cleared up before we, I have a hard time even when the property line's disputed. I don't know how we can change it when we don't know where the line is.
Well,
But
Jared Stevens did the survey on the thing, and yes, he did have to change it because there was a concrete marker that was probably 40 or 50 years old out on Duncan Road, and
yes,
it
sir.
was off 120, 130 feet from what the real survey said.
I've seen that, and that had me intrigued. So hopefully we can get everybody on the same page and agree with that survey, or agree to disagree or something. I just want to make sure that all parties involved are okay with it.
Jared Stevens is available on the computer, and he can verify that. And I'm sure he worked with Woodford County as well.
Well, yeah, I just we have a letter from James Kay, the county judge executive of Woodford County, that is disputing that property line and that new survey. So that's we need to talk more with him about it. But I just want to make sure we cover all our bases, and you've been very patient, and I appreciate that. That's all I've got right now. Thank you, sir.
Thank you.
Mr. Sparks, do you want to elaborate on the dispute of the boundary lines, and should we bring Mr. Stevens on, the surveyor, to testify?
Judge, I'm not qualified to comment on boundary lines one way or the other. Yeah. I'm not aware of the boundary line controversy nor the letter. I'm assuming the court will take up that as part of the other public comment area. Mr. Hewitt testified that the boundary issue and the surveys were complete, and that is the at least evidence that's presented. What you all as the court wish to do in terms to further explore that issue is certainly up to you, and I defer to your judgment, the member of the court's doing it. But based on what's presented so far, I mean, I can't comment on it. I'm not a surveyor. That's kind of a whole nother level of expert testimony. I'm not sure what that issue is, frankly, but if you all choose to explore it, that's your discretion.
Okay, Mr. Hewitt said he'd like to testify on it. Or
Mr. Sparks, when this jurisdictional boundary was discussed at the planning.
Oh, Mr. Hewitt, if you would, sir, I'm not on the court. That should be directed toward members of the court.
Oh, okay. Members of the court, when this issue was brought before the planning commission's attorney advised them that it is not within their purview to make a jurisdictional boundary determination. And I would say the same for the court. The applicant has provided a professional survey showing the county line in accordance with our regulations, and it's been stamped by a professional licensed surveyor in Kentucky. It's my opinion that the item before you is the appropriateness of the zone change and not the location of the jurisdictional boundary. You know, that is a different court matter that would be held in the circuit court of Franklin County.
Okay.
Well, I mean, I will state this to the extent I think it underpins the issue. Before this court has jurisdiction to make the determination, you have to know where it's located at. I would agree that the court does not have the authority to make decisions relative to where the boundaries are, but I think that as a prerequisite to determining it, the court in exercise of its jurisdiction can only exercise jurisdiction on zone changes for property located in Franklin County. My point is that all indications are of record that the property in question is in Franklin County. And if that is a question and they wish to explore that, I believe that they're free to do so. Whether or not they can solve the question, y'all can't solve that question. But you also can't exercise your authority to make a zone change if it's not. There's nothing to indicate in the application or otherwise that it is not in Franklin County.
Okay. Squire Sebastian.
Thank you, Judge. Mr. Tierney, you discussed, and Squire Moore brought this up, and I appreciate him bringing this up about the truck that had turned over on Duncan Road and had kind of blocked the entrance into Corporate Drive. And during testimony tonight, there's been the discussion of another road that exits or that will exit the industrial park. Can you talk a little bit about what your plans are and in that regard, where that would take shape, where the actual road that would now exit out of the industrial park, so there would be two ways in and two ways out rather than one? If you could talk to us just a little bit about that, and then I probably will have one follow-up question, but I think it's important for us to understand that is a critical piece to this, to have more than one way in and one way out. Thank you.
On the map there that we've got on the screen, you see that is Fortune Drive that comes up there. Fortune Drive originally was a cul-de-sac, and then they put in another street that went to the left or to the right. But right there is where that road would come in, and then would go around and then go out onto Duncan Road at that exit right there, at the original farm entryway. We have to realign that so that it gives us a 90-degree vision. And, but that's where that street would go.
Okay. And in order to make that happen, what steps have to occur? Does that have to be also approved through a planning process, the planning and zoning? You know, I'm just trying to understand the nature of how the plan in moving from agricultural zoning, or would this also occur if it remained agricultural zoning? Just trying to understand that part of it. Thank you very much.
First thing I did was paid $45,000 for that little strip of land where we could access that, and it would be used for that if it's agriculture or if it's the other way, because we feel it's important to have access back there.
Absolutely. Thank you so much. I appreciate your response. Thank you.
I believe Squire Tracy was next.
Thanks, Judge. Mr. Tierney, quick question. When your company or developers, contractors, when they dug up and moved and redirected the water runoff, was Franklin County Planning and Zoning made aware of it and or approve of it?
No, they really didn't, I don't think.
Thank you.
It was a requirement that we had to have a 90-degree access to that road it came out and you kind of came out at about 45 degrees and it was not safe to go in and out. So we just redirected that as an agricultural, we were putting in an agricultural road and entry.
Okay. Yeah, I was talking about the drainage pipe, the runoff that you redirected over into the agriculture from your industrial park.
Yes, they were aware of that.
They were made aware of it?
Yes, and I think Mr. Otis has been out there and reviewed it and haven't heard back from him.
Thank
you.
He
communicates through our engineers.
Squire Blackburn?
Yeah, we were talking about that road, and I don't know that this is a question for Mr. Tierney, but I just wanted to ask it while it was fresh on my mind. Didn't a portion of that cul-de-sac road area, a previous court gave that to HTNA with the promise of them building a corporate office, and then they've since sold it back?
They gave them the portion to the right.
Pull that back up.
The cul-de-sac stays there because that's access to my property to 119 Fortune Drive.
Yeah.
So they just gave them the little street. I can't think of what the name of it is. We built a building on it for them. But it's a little short street that goes down there.
Founders or Fortune?
I was thinking
Founders, I think.
Okay.
Yeah, it is Founders Drive. That comes off of that portion. That was a cul-de-sac. It just that portion of it. That cul-de-sac still remains part of Fortune Drive because we've got two properties there that
you have an arrow.
Oh, where is that? This on point here?
Yeah, to your right, a little bit. No, over a little bit to your right. Up, straight up, not right there.
That's Fortune Drive.
That's
yeah,
it.
right.
And the road is right
the
there.
road that's county dedicated to HT.
That's it. That's the road right there.
Road right
Yes.
there. I remember now.
Yeah.
Okay.
Okay. Squire Muller, who next? And then Squire Booth. Squire Muller's next. Squire Muller.
Thank you, Judge. Thank you again, Mr. Terry. I know I don't want to make you stand up there all night. It's my understanding the judge executive of Woodford County is voiced some concerns about the zone change. What are your thoughts on that? I mean, is there something we can do to make them feel better or anything about it? Because at the end of the day, we need to be good neighbors. I think like Squire Blackburn and Squire Tracy kind of hit on.
We had offered to do put a dog park down at that entryway, but didn't get much reception for that. Where we put in a community dog park. But I think if we can get to develop this property and they see how it is developed, it's going to look more like a horse farm than it is a snake pond down there at the entry where it was.
Okay, thank you.
Okay, Squire Booth.
I have a question about the type of vehicles that you expect to come to your business on the 690 Duncan Road property. Are they trucks or cars?
It will probably be a combination of pickup trucks and cars, which would be employees, and then there will be tractor trailers that will access, which they do at all of our other plants. They would come in to access for docks and that kind of thing, bring product in, take product out.
All right.
It would be a mixture.
Okay. Are there any other questions for Mr. Tierney, the applicant? Seeing none, are there questions for Mr. Hewitt?
Yeah.
Mr. Hewitt? Does the staff have?
Do I have a question?
Does you have a question? Yes.
No, sir.
I'm sorry. The statement should say, Mr. Hewitt, do you have a question for the applicant?
No, sir.
All right.
I think Squire Tracy might.
Squire Tracy.
Thanks, Judge. I've got a question for Robert, just to follow up. Robert, okay. in regards to that water runoff that was redirected from the industrial park over onto the agriculture land. was planning and zoning made aware of that, and did planning and zoning approve that to be dug up, moved, and redirected over to the agriculture property?
We were not made aware of it. My office did discover it. I reached out to Mr. Tierney's attorney, as well as Mr. Tierney himself. My office is open to the concept of a regional detention basin to provide detention for both 101 Corporate and 690 Duncan Road. We have utilized centralized basins within Industrial Park 3, and they continue to operate adequately. So we're open to the idea in this case.
Thank you, Robert.
Okay. Squire Blackburn?
Yeah, Scotty just touched on something that created a question for me. What happens if it doesn't go to industrial? What happens if it stays agricultural and now we've got industrial land going onto an agricultural piece of land? I mean, I know water doesn't run uphill, but that's a what if question. I don't know.
Every one of those catch basins that are developed on that side of that farm all come to that farm.
Okay.
Every one of them. I put 3, or I put all 4 of them in. They all come to that particular farm.
Okay. Squire Moore?
That was going to be my question. Where was the water from that property going anyway? Wasn't it already going to the 690 property?
Yes, sir.
Yes,
it was.
Okay, thanks.
Okay. That, if there are no other questions, that ends our questions for the applicant. Thank you, Mr. Tierney, Mr. Rump, for your presentation.
Well, we've got a couple more people here that we need to,
Okay.
to bring on.
Absolutely. Bring them on then. Let's bring them on. Yes, sir.
Jared Stevens is showing up here. Maybe he can put his face up.
Okay. You want to come up here, sir?
I'll come.
Yes, sir.
Well, yeah, I'll come right to the podium and bring my computer.
Andrew, can you bring Jared Stevens up?
He's with us, Judge. He's already here.
Okay, Mr. Stevens, can you hear us?
Yes, I can.
Okay. Mr. Rumpf wants to ask you a couple questions.
Can you state your name, please?
Jared Stevens.
And we need to get you sworn in, Mr. Stevens.
Yes, you can see he's up there.
Do we need to see him?
Yes, he's up there.
His face.
He's up there.
Oh, I'm sorry. Hello.
There he is.
Hi. Can you raise your right hand? You swear to tell the truth, nothing but the truth, all the truth?
I do.
The whole truth? Okay, thanks.
Would you state your name, please?
Jared Stevens.
And Mr. Stevens, where do you reside?
I live Menominee Trail here in Frankfort, Kentucky.
And what is your occupation?
I'm a professional land surveyor.
And what is your educational background in order to engage in that occupation?
I've passed all the required tests in the state of Kentucky with education and experience.
And how long have you been engaged in the professional lands or professional surveying?
I started working in doing land survey work in Franklin and the surrounding counties in '96, I believe.
And have you worked continuously in that area?
Yes.
Have you done approximately how many land surveys have you done during your time as a registered land surveyor?
I wouldn't have a clue. I've been licensed as a land surveyor since 2007, and I'd be taking a wild guess if I was to say how many I've actually done.
Okay. Did you you have your own company there?
Yes, I do.
They at Mr. Tierney's engineer's request, did you do a survey of the property at 590 Duncan Road?
I did one at 690.
Sorry, I moved the property. 690 Duncan Road. You did?
I guess I did.
And I'm going to hopefully display that survey. And this might come up where we can see it. Is this a copy of the survey that you did?
Yes, it is.
I'm just going to ask you. Wait a minute. Let me go back and find it again. I'm sorry. There. What do you do when you do a survey like this? I mean, what process do you follow?
Typically, I start out in the PVA office, trying to find references for deeds for the subject property and the adjoining property. Look those up, research them, and find out, adjacent plats, trying to figure out where the property corners are supposed to be. And then I would begin by finding and locating, measuring the property boundaries.
Now, had this property previously had a surveyor or a survey by a licensed engineer? Could you tell?
Yes, I found multiple property corners around the property that a local surveyor had done, and he had later provided me with a copy of that survey.
And just for the members of the court, I put my cursor over here on a little piece of property. What was that?
That was a previous off conveyance to the Commonwealth of Kentucky at one time. And then sometime after that, the previous owners of the property got that piece back.
Okay. So that is why
it is deeded as a separate piece of property.
Gotcha. So that is why you've shown it as a separate piece of property.
Yes.
Because it had been divided, and I think it had been divided pre-planning and zoning. When I ran the title, there was no plat of it, I guess is what I'm saying.
There was done by the Commonwealth of Kentucky. I'm not sure who did the survey work, but yes.
Now, the subject matter tonight that seems to be of concern to the court is the division line between the counties of Woodford and the county of Franklin. And you have shown that line on here. I'm running my cursor over it as we speak. Is that correct?
Yes, sir.
Was that something that you were requested to do by Mr. Tierney's engineer?
Yes, it was.
What did you do in order to form an opinion about that?
I started doing some research, trying to find the definition of the county boundary line. Started out with a description of the county line from, I believe, 1795.
I'll put up on the screen a document.
94. I was close.
94.
Yes.
You went and found these documents that where an act was in 1794 to create the county line.
Yes, it did.
And this act, did it establish Franklin County and the boundary between Franklin County and Woodford County as being from the Scott County line where it leaves South Fork of the Elkhorn Creek to the Kentucky River, 1 mile above the mouth of Glenn's Creek?
That's what that description described, yes.
Okay. So that was the beginning document that you began with in order to draw that line on the survey that you certified.
That's where I began, yes.
Okay. And let's see if I can run on down here a little bit. Did you find another document that you found related to the establishment of the county line? And is it now?
Your audio's breaking.
It was in a state statute of Kentucky adopted. I'm sorry, that's me, I guess. Was it the state statute? My internet connection is.
Go ahead.
Are you okay now, Jared? Can you hear me?
I did not hear your question.
He's not on there.
Well, I didn't get there yet. What is this document? Can you see it?
I see that document. I believe that is the document that is describing a Kentucky State's Congress to for the counties of Franklin and Woodford County to reestablish the line between the two counties. They were to appoint 2 surveyors, I believe, for each county. And then after this was done, the 2 counties were supposed to record the survey in their courthouses.
So basically, the 1794 Act established the line, and then this January 17th, 1817 Act kind of implemented what had been established and directed.
I can't hear all. I can't hear what all of your question was.
Come up with this 1817 Act directed them to form committee. 1817 Act we just look at, did it implement the 1854 Act, which established the county line, or did it provide for a method of implementation? That is, 2 commissioners be appointed by each county, and they work together to come up with a line.
I didn't hear all of your question, but in the 1817,
is that correct?
I did not hear the question.
What did the 1817 document do?
The 1817 document authorized the commissioners to perform the survey work to reestablish the line between the 2 counties. The document that you see on the screen right now from January Court 1822, I believe is the document that I found in the Woodford County Clerk's office.
It's posted there. It's the Franklin County.
Okay, is that the Franklin County
office? It looks like that's your post. Excuse me. Can you see the post-it note up in the corner that you put on it?
I see the document there, yes.
Franklin County Order Book.
Okay.
Okay. And so was this the document where apparently Franklin County put the record an order establishing the county line based upon the report?
That is the Franklin County document then. The Franklin County document did not record the survey. It said that it was ordered to be recorded, but I was not able to find one in the Franklin County records.
Okay. Then what did you next Woodford County?
This image up on the screen now that has a blue pen written up on the top right corner, E14, is a document that I found in the Woodford County Clerk's office that was the report from the survey or the commissioners with a description and an actual survey of the line between Franklin and Woodford counties.
And that's sort of a rough drawing of that there that's now displayed on the screen?
Yes, I'd say that was a pretty usual drawing, more than likely, for 1822.
And did this description that cast or anything, or how did it refer to the monuments in the survey? That is, the locations or things on the ground that indicate where the line is.
The survey from 1822 defined monuments being in several locations. One mile upstream from Glens Creek along the river. The other one being at the Scott County line with Woodford, with Scott County, and then defined some monuments along the route. And I believe that I found some monuments along the route, namely the one at Old Versailles Road near the property.
And did you actually, I think, well, there's E15, but let me go back. I think you took a picture of that monument.
Yes, that's the picture
Is
of the
that a
monument.
picture of the monument?
Yes, it is.
Okay, and that's the one that's laid on the old. Well, I think you also indicated that you found 3 stone monuments that match the county line is drawn on the USGS map as well. Is that right?
Yes, that is one of them. I found a total of 3. That being the one that the picture on the screen is the closest one to the property.
And based upon this research in the county court's records and in the state statutes, did you form an opinion about where to draw the county line on the survey that you certified in this case?
Yes, I did. It was my determination that the monuments that I found on the ground, namely the one that there of the picture, was the best evidence available for the location of the county line. That and the description for being 1 mile up the Kentucky River from the intersection with Glens Creek.
So you extrapolated from the monuments you found, from the 1 mile up the Kentucky River on a bigger map than this, and came up with this line. I think it left 17.109 acres in Woodford County and 85.38 acres in Franklin County. Is that correct?
If that's what it says on the drawing, it's a little blurry for me, but that sounds right.
And on the drawing that you certified that has been filed, did you also put a note on this drawing that explained everything that we just talked about?
Yes, there is
that note up here at the top.
There's a note at the top left.
Read, but
there's a note at the top left that describes how I determined the county line between Woodford and Franklin County. One other thing I'd like to bring up, and I don't know, Squire Blackburn had brought up the fact that the Woodford County,
and that's the note we're referring to.
I was unaware of this. I know that there was some contention before I got involved with the project, but nobody has indicated that there was a disagreement since the survey's been completed. I didn't know if there was a date on the letter that the judge executive had submitted.
Gotcha. Just for the record, I'm unaware that Woodford County had disputed the line as well. And Jared, were you present at the planning and zoning hearing?
I was present.
You were present in the room
at the first meeting. Yes.
But you didn't testify that night, did you?
I did not testify.
Did you testify that night? And did anybody in the room at any time during the 5-hour hearing raise any issue about the county line?
I believe that the position of the commission attorney was that that was not an issue for the planning commission.
But I guess what I'm asking, maybe that's about it. Is that correct? That you recall anyway. That's all I had.
Yeah, I did not testify
from this witness.
Okay.
I guess I should ask you, will you make, your survey is already part of the process, but will you make those documents that I've labeled and submitted as county line documents, will you make those a part of your testimony today?
Yes.
Okay. And those are accurate copies of documents that you obtained both out of a legal book as well as the county clerk's records in Franklin and Woodford County. Is that correct?
That's correct.
That's all I have.
Are there any questions of Mr. Stevens, the surveyor?
Can you take that out?
Yeah. Right now.
Okay, Squire Tracy. Squire Tracy.
Thank you, Judge. Just one quick question.
Tracy.
Thank you, Judge. Just one quick question. while researching and surveying the property, did you happen to see or locate a cemetery or burial headstone, any things of that nature?
I did meet with Mr. Tierney on the property because I was concerned about the location of a grave on the property that I'd heard of through news reports and so on. And Mr. Tierney showed me where the grave was, and I located that on the face of my survey.
Okay. Thank you.
Okay, any other questions? Hearing none, we do, I remind you,
Judge.
Squires, don't want to touch it. Yes, sir. Yes, sir. Go ahead.
Just very.
Go ahead, Mr. Spark.
Of the surveyor. Sir, thank you, sir. This is Rick Sparks. I just want to make sure that my court understands. It is your opinion, and it has been your testimony consistent with the application, that all of the subject property in question is located within the unincorporated areas of Franklin County, Kentucky. Is that correct, sir?
The area for which they're asking a zone map amendment, yes.
Yes, sir. That is the zone. The one that is subject to this application is within the unincorporated areas of Franklin County, Kentucky, and that was included in your application packet. Is that correct?
That is correct.
Okay. Thank you, sir. Appreciate it.
Thank you.
Okay. Squires, we have a lot of people that have been here for 2.5 hours now to over 2.5 hours to speak. And if you're ready, I'm going to, do you have any more?
Gregory?
Okay, I'm sorry. We have another witness. I'm sorry.
I'm sorry.
No, that's all right. We got it.
Gregory,
This is your opportunity, Mr. Brad Gregory. Mr. Brad Gregory, thank you for being here.
Yes, sir. I will say that your all's audio and video coming out of the courtroom is not very good at all.
Okay, Mr. Gregory, hold up. We got to get you sworn in.
Do you swear to tell the truth, nothing but the truth, the whole truth?
Yes.
State your name, please.
My name is Brad Gregory.
And Mr. Gregory, where do you reside?
My address is 2247 Schweitzer Road, but that's a stamping ground mailing address. Even though I do live in Franklin County, I have a stamping ground mailing address.
And what is your profession?
I'm a licensed professional civil engineer and a professional land surveyor in multiple states, including Kentucky.
And where do you presently practice your profession?
I currently work for HMB Professional Engineers in Frankfort, Kentucky.
And how long have you been a professional engineer?
I've been licensed since 2002, and I have worked through my internship prior to licensure for the last 24 years.
And are you in the area of land development?
I'm sorry, the first part of your question cut out.
What is your experience in the area of land development?
So my entire career, I have been involved with land development through every facet, from the transportation infrastructure, utility infrastructure, stormwater infrastructure, urban hydrology and urban hydraulics, and pretty much every facet that's related to commercial development, or commercial, residential, and industrial development.
Have you done work for the city of Frankfort and for the county of Franklin?
Yes, I have done work for the city of Frankfort, and previously my previous partner and I, Andy Layson, actually served as the county engineer, just like Jonathan Otis does. We did that from 2002, I think 2002 or 2004 until 2012 when Mr. Otis took over.
Well, I know you provided me with your resume, And I wish I could put it on this screen, but it won't go. So we're in the time we have, let's go ahead and let me share this screen and get moving here. At Mr. Tierney's request, did you put together a conceptual drawing for the property at 690 Duncan Road?
Yes, sir.
And did you, is this that conceptual drawing?
Yes, sir.
And can you just generally go over the drawing? For instance, what are the yellow notations that run around the outside of the drawing?
Sure. So the yellow notations or the yellow lines that you see, those are the adjoining property lines as described by Mr. Stevens' survey. And some other supporting documents such as the PVA. So the yellow text that you see on each one of those is the owner of that adjoining parcel that was reported on Mr. Stevens' survey, along with the current zoning. Do you want me to go? Go ahead.
Go ahead. What does the blue line indicate that I'm kind of running my cursor over?
That blue line indicates the exterior boundary of the entire parcel at 690 Duncan Road.
And that's the whole 103 acres is within the blue line. Is that correct? That
yes,
was
sir.
In the original farm. And what does the light blue line that I'm running my cursor over indicate? See,
that is the Franklin and Woodford County. That's the line that divides Franklin and Woodford County.
Was that based upon the survey that Mr. Stevens just testified about?
That is exactly the survey that Mr. Stevens provided.
And what is the pink lines on this drawing? What do they represent?
Those pink lines follow the ridge lines, or they delineate the drainage watersheds. So any drop of water that falls, whichever side of that line it falls on, is the direction that it's ultimately going to flow. So those become delineators between the individual different watersheds that flow off of the property.
And why are those lines important to you as a development engineer?
Typically, yes, sir. Typically, you will try to design your site to where you have some sort of a stormwater mitigation structure inside of each one of those drainage divides, or inside of each one of those watersheds to catch water before it leaves your development. That's not always, you're not always able to do that, but in this case, we are actually able to provide some area where stormwater detention could be constructed in each area before water is allowed to leave the site.
And in development engineering, is water a principal consideration for you as a development engineer?
Yes, sir.
Is that why basically you begin with that inquiry about how you're going to handle the water of the piece of property that's being developed? Answer audible.
Yes, sir. Yes, sir, we do. Typically, that's why we try to orient the buildings and the grading such that we're not diverting. We never take water out of one drainage divide and put it into another. So that's one source of potential increase. That's something that the county engineer, Jonathan Otis, or in his capacity as the county engineer, that he would review to make sure that we're not doing that. So, all of the existing places where we have to construct the basins, that would be these draws or sort of a hollow. The way the land lays, that we can put dams across those and catch that water prior to it leaving the property. That's probably the very first consideration that you have when you look at the potential development of a piece of property.
does this enable you of doing all this design, water design work to comply with all the regulations of both the county of Franklin, the state of, and they probably have a hand in there as well. If it's certain. Is all this what? Can you hear me now?
I can hear you now, but can I offer something? I think
Sure.
the louder you get, the more it cuts out for us, or something. I'm not sure.
Okay, you sound like Judge Richard.
I can hear you. No, well, actually, I can hear you there when you speak in a normal tone, I think, but I'm not sure. But you all are definitely having technical issues in the courthouse.
It's there's some bandwidth that's been happened that's causing lag. So,
is the water design work that you do and the drawing of these pink lines and establishment of the waterhead, is all of that designed to comply with the county, state, and federal rules and regulations regarding stormwater management?
Yes, sir, it is. Before we are able to even begin any sort of final development plan construction, a complete drainage report and analysis, stormwater runoff report has to be designed and calculated and then reviewed by the county staff. And they has to meet the current Frankfort and Franklin County shared subdivision and land use regulations. There's certain criteria that has to be met before you can even have an approval of a development plan and begin construction. And all of those things we will take into consideration for any development that we do.
And you will take them into consideration for this development?
Yes, particularly for this development.
Now, well, I lost my thought. Let's look back. Oh, there have been questions earlier, if you were listening, about the stormwater issue, and at what point in the, I guess basically the construction of the facilities that might be built on this property, or at what point in the zoning process does that type of activity take place? What you just said, the calculations, the design, the grades. Can you tell the fiscal court at what point, are those part of the zoning process, or are those part of some other process?
No, sir, those are not part of the zoning process. All of that is a detailed engineering design that will be directly dependent upon where the buildings are exactly placed, how the finished grades, how much impervious area is placed out there, like rooftops or driveways or roads. So all of those details are done in final detailed engineering design just before you would submit that with your development plan for approval to then be able to go out and do construction. So it's basically the last thing. It's all part of the final process. It's not part of the zoning process.
So if this zoning change is approved, there will be another proceeding before the commission where a development plan is reviewed. And at that point in time, you as the engineer would submit to the planning commission staff and their engineer all your calculations based upon what is actually going to occur on the property. And a judgment will be made as to whether or not the infrastructure that you had proposed would be sufficient to handle the water runoff. Is that right?
It's nearly correct. So it doesn't necessarily have to go before the full planning commission, but it would still go through a technical review committee, which would include the county engineer, county planning staff, fire chief, all of the utilities, all of the sewer departments. Typically, unless there's some extenuating circumstance, it would not go before the full planning commission. But that usually that extenuating circumstance is if you're asking for some sort of variance from the official code.
Okay.
And we are not anticipating asking for any variances. We feel like we should be able to satisfy all of the development conditions that are present in our development standards.
So let's go back briefly to the plan here. There are these green hatched splotched areas. Can you tell the court members what those are?
Those are some preliminary areas that we have identified as great spots for stormwater mitigation, most likely conventional stormwater detention ponds. With the exception of the existing lake, our proposal is to right now, or what Mr. Tierney and I have discussed, is he likes to keep the lake feature there. So we've talked about, that would remain as what you would call wet detention pond. So it would be look just like it normally does now, but we would build more capacity into that pond where it could temporarily store more water above the elevation where it's at now, but then it would recede back down to a normal elevation. So, and that pond already acts as a very significant stormwater control structure for a large portion of the existing Industrial Park 3.
Now, there's been some discussion of what about this Woodford County property, and would stormwater runoff from this property go into Woodford County? Is that the purpose of this detention area?
Yes, sir, it is. There is one other small area where it's actually labeled there in Woodford County, remaining green space, approximately 82 acres, that spot right there. So there would be a little runoff that could leave the site right there. But however, we're not proposing to do any work in Woodford County. So that is the intent, is to have a detention basin that would catch everything that runs off of this property. We could likely divert any water that would try to leave through that spot directly into Woodford County to go through our proposed basin.
It could be piped over there.
Piped, or with an open channel, or even just directing the roof drains possibly that way. The intent would be to try to control every piece of stormwater that we touch that is something that is new.
And certainly if Woodford County planning office or governmental authorities would allow a detention facility to be put in there, is that something that you could design and would function well for the property? But it would have to be in Woodford County, I guess is what
But it would have, yes, it would have to be in Woodford County, and it would have to be approved by Woodford County. And I think that probably opens up a whole nother, is it even permitted over there in Woodford County? I couldn't tell you.
Okay. Based upon your review of the property, do you see, well, one last thing before I go on. We've mentioned it, but we haven't really dwelled on it. So let me get back to this screen where I can blow this up. These notations on the conceptual drawing, here we go. Now, let's see if I can blow it up. You mentioned it a minute ago, but I'll try to get it bigger to where actually we can draw attention to it. The green, several places on this drawing, you have placed a notation that said remaining green space approximately 82 acres total. There's one of them is right there. Would that 82 acres be 82 of the 103 acres?
Yes, sir.
In the total parcel? And
yes,
would
sir.
That 82 acres also in the road, would the roadway be within that 82 acres?
Yeah, yes, sir. As of right now, I didn't know exactly the way the road would go or where it would be. So I have included that in the green space, but it would likely only amount to maybe 5 acres of the total.
Okay. So a great majority of this 85 acres in Franklin County would be green space, including this area over here, which I think is probably 30 acres, with that lake on it.
Yes, sir.
So-
As of right now, preliminarily, we're looking at approximately whatever it says on that drawing there, around 22, 25, 21 acres that's comprised of our building site. And that would not be completely impervious new building. That would also include some interior green space and landscape and softscape and that type of thing. That's the area that we have identified as most likely potential for building would be along that ridge. And then in effect, the rest of the property would remain as it is now.
Now, would you make your resume and your conceptual drawing a part of your testimony here tonight?
Yes, I will, please.
Thank you very much.
That's all. Okay. Okay.
You have another witness?
I have another witness, but
Yes,
anybody
sir.
want to ask him a question?
Okay. Anybody want to ask Mr. Gregory any questions? Mr. Moore, Squire Moore?
Yes, sir. When you do a water runoff map or design, are you trying to capture anything that's, well, let me back up. Aren't you trying to make the same or less amount of water come off of that property?
Yes, sir. We are bound by the subdivision regulations to not increase the peak flows coming off of our development. In other words, we have to put in structures that control the runoff to at least the pre-developed flow rates.
Okay, thank you.
Any other questions, Squire Blackburn?
You're on mute.
Can you hear me now?
Yes, sir, I can.
Can.
Brad, thank you so much for coming in today. We really appreciate it. You had stated that it's under your guidelines that you produce no more outflow on the land than pre-development. My concern is in an area that's already a problem due to the conditions of the surrounding development. I know when that's taken into effect, is there an ability to kind of go above and beyond the prescribed criteria to make it even retain more?
Yes, sir, we can. And I'm not going to speak for Mr. Tierney, but in my conversations, I can speak to my conversations with him, is that he has indicated that he would be willing to do that. And we have the capacity to do it. And I think that, personally myself and dealing with him, it speaks to his willingness to, make the site better than it is today or to produce a quality development.
Thank you.
Any other questions? Seeing none, you call your next witness.
Diane Zimmerman, traffic engineer.
Diane Zimmerman.
I'm here.
Okay. Ms. Zimmerman, go ahead.
Okay. Do you promise to tell the truth, the whole truth, and nothing but the truth?
I do.
Okay, thank you.
Could you state your name, please?
Yes, Diane Zimmerman.
And Ms. Zimmerman, where do you live?
12803 High Meadows Pike, Prospect, Kentucky.
And what is your profession?
I am a licensed professional engineer in the state of Kentucky.
And in what area do you practice engineering?
I have spent most of the past 33 years doing traffic engineering and transportation planning.
And where have you been engaged in that occupation?
I started my career at the Kentucky Transportation Cabinet. I spent 2 years at the North Carolina Department of Transportation. I was president of Zimmerman Grider Incorporated, which was a Frankfurt-based engineering firm. I worked for 15 years for the Jacobs Engineering Group, which was previously known as Jordan, Jones and Golding, and I spent a year and a half at CDM Smith. I'm currently self-employed.
Okay. Now I will put up on the screen a resume that I think is part of the county's production. I think it was produced, and it's also been produced to each member of the court in the applicant's handout. Is this a true and accurate copy of your resume and you're showing your experience in education?
Yes, it is.
Would you make it part
Yes, I will.
of your testimony today?
Yes, I will.
Thank you. Now, did you, at the request of Tierney Storage and its engineer, conduct a traffic impact study for the property at 690 Duncan Road?
Yes, I did.
And I projected onto a screen a report that's dated December 15th and revised January the 8th of 2020. Is that, does it appear to be your seal on that study? And
yes, it is.
The original or a copy of the original?
Yes.
Tell the court very briefly what you did in order to put this report together.
Well, I started by contacting the county's traffic engineer, Brad Johnson, and discussed whether or not we could make the traffic counts in July for the purposes of determining whether or not a turn lanes would be required on Duncan Road at the entrance. And he agreed that at that point that July counts would be sufficient for that purpose. And so there was a study done in July based on that. We thought at that moment we were only evaluating the entrance at Duncan Road. Once that study went to the transportation cabinet, they requested that we make counts once school was in session in August, and that we include the intersections of I-64 with Versailles Road as part of that study.
Well,
and so I also did a site visit. I've driven through that area numerous times over the years and obtained the signal data from the Kentucky Transportation Cabinet.
And did you also kind of survey the existing uses of property in the area? What type of uses?
Well, the existing uses are the industrial site, the state office complex, as well as the BizAct properties, where the Cracker Barrel and the Logan Steakhouse are, and the new Shell station that went in on the corner.
Okay. And when you say conducted a study, a traffic count, where actually somebody sits ice down and counts the cars? Is that what you're referring to?
Well, given that it's 2020, we now make traffic counts using video camera, where the video camera is installed at the intersection, and then a person counts the cars off the videotape. So in essence, yes, someone is sitting there counting, but most of the time the counts are, today, most counts are made with video camera. It's safer for the person to be in the office counting.
Did you encounter any problems in conducting either the counts, the studies, or putting together your report?
I'm sorry, John, I didn't quite catch all of that question.
Do you feel confident that you got all the information? Do you
Yes,
feel confident that you gathered all the information?
Yes, I do.
You do? I've displayed on a screen the page of your report that gives your conclusion. What was your conclusion after conducting these traffic counts and doing all the calculations necessary that are a part of your report?
The roadway network can adequately handle the traffic that would be generated by this development, and the only improvement that would need to be made is the improvement of the signal timings out on US 60, specifically at the interchange. During our analysis, we discovered a signal timing plan that would work better than what's currently on the ground.
Did your report get reviewed by the Planning Commission's traffic engineer?
Yes, it did. It was reviewed by Mr. Brad Johnson, and it was sent to Mr. Brian Eaton at the Kentucky Transportation Cabinet for his review.
And did they comment on it, or did they accept it?
They accepted it with some minor adjustments. There was some missing data in the appendix that they requested be updated, and a few other minor revisions. That's what caused the January revision.
Okay. There's been some discussion about traffic improvements on Duncan Road and also on US 60. Have you received an email from Brian Eaton at the Transportation Cabinet?
Yes, I did receive an email from Brian Eaton. It is on the screen.
And what was the subject matter of that email? And
the Transportation Cabinet, as I believe it, Robert can probably add a little more information to this, but the Transportation Cabinet has been doing an evaluation of this section of US 60 Versailles Road, and trying to figure out how to solve some of the issues that occur routinely happen, daily happen at there. And so part of that project, now they have finished their evaluation in March. And so obviously post my study in January, and they are recommending some, what I would term minor improvements along Versailles Road at Duncan Road. They're going to install those reflective black back plates at on the signal heads. That's to help with visibility. They will modify the left turn movement from Versailles Road to Duncan Road coming from Versailles to be a flashing yellow. They're going to install some be prepared to stop flashing signs. They're going to restripe the southbound auxiliary lane drop, and they're going to refresh the stop bars and arrows.
Will that affect the safety of that Duncan Road interchange there?
It will improve. It will improve it should minimize the crashes that have occurred there. All of those measures are items that the cabinet does when they're trying to reduce crashes, and these are specific crashes that they believe they'll be able to reduce.
And then at the bottom of the email that's now displayed, what was that conversation about?
In addition to the Duncan Road intersection, they were looking at the off ramps of I-64, and they're going to install dual left turn lanes on US 60 for the interchange, and that will reduce the queuing that occurs there that creates the bottleneck that one of the Franklin Court members mentioned. And there, at least at the time of this email, which was April and before all things COVID happened to all of us, the project letting date for that work was to be next summer. So they're still working on putting together those plans, but they were planning to do the intersection upgrades at Duncan Road this fall.
I guess, and will that, in your opinion, help the situation out there on, with the study that you did? Will it provide area of 690 Duncan Road?
That question didn't come through at all.
I said, if those traffic improvements that are mentioned by the transportation cabinet, if those are actually occur, will that improve the traffic flow at 690 Duncan Road?
Yes. Well, it will improve the operation of the intersections on Versailles Road.
Okay. Are you
none of those will have any impact on the flow of traffic at 690, but it will allow Versailles Road to accommodate the traffic that's generated at 690 Duncan Road.
Are you familiar with this document that I have in my hand? It's a small urban area study of Frankfurt and the Kentucky Transportation Cabinet.
It has been it was discussed I have it's been discussed in my presence. I haven't actually seen the document.
Then I won't ask you about it. Thank you, Diane.
Thank you.
I'll pass it.
Okay, you through? Are there any questions for Ms. Zimmerman? Squire Blackburn. Squire Blackburn?
Yes, sir. Can you hear me?
Yes.
Yes, sir.
Thank you, Ms. Zimmerman, for being here today. I know this is a long process, and I appreciate your time. I know your traffic study, was it done on a one-day count?
Yes.
Okay. And I see you're for Corporate Drive, it was done in July, but on Duncan Road, it was done on August. Is that correct?
That's correct.
Okay. Were all the factories in production during those 2 dates?
I believe that they were.
I'll have to go back and check the dates.
The August count was actually less than the July count on Duncan Road. So that indicates to me that the July count is valid for the Corporate Drive intersection.
Okay. Thank you. Also, there is a Lakeshore Arena, which is a little bit past the Industrial Park 3 out on the left. They start weekend horse shows that you generally start on Thursday and run through Sunday. And they're actually starting this Thursday and going the rest of the summer. I don't know if that was happening at that time. It's kind of like any road with business and things like that. The traffic pattern isn't constant, and it does vary. I know with bourbon tourism, I don't know when the peak bourbon tourism happens, but I do know that most of the traffic that goes down that road, if it's not people that live on it, are the folks that are driving to go to see the distilleries that are on out in that direction. But I just wanted to see if you had checked with those factories to see if they were in production at that time, and I'll go ahead and check that on my time as well. Thank you.
Thank you.
Okay, are there any other questions for Ms. Zimmerman? Tony, Mr. Rump?
Yes, Judge, I have some closing remarks.
Yes, sir.
Other remarks.
You're
that
more
I'd
than
like to make. I could either make them now or make them later, but
go right ahead.
Okay. Well, to the members of the court, I appreciate your attention to all of our witnesses tonight. We all know why we're here. We all know the history here. The Planning Commission took action on this, held a 5-hour hearing, made a vote to recommend it. We all know that the staff spent from July all the way to January reviewing this matter, requiring Mr. Tierney to both implement traffic studies, new traffic studies, implement a survey, and establish the property and do everything that they should have made him do, okay? They should have made him do every bit of that. I think it was a surprise to all of us to find out where the county line was, because as the testimony mentioned, there's a monument right across the road on Duncan Road that's wrong, that some engineer put in there 35 years ago, and it's just flat wrong. But for you with Rick Sparks' speech here about what your decision is tonight, he's correctly quoted the statute. You either got to find that this map amendment is in compliance with or in agreement with the comprehensive plan, or you've got to find that the existing zoning is now inappropriate and the proposed zoning is appropriate. We think we presented evidence to qualify both questions. But if you just answer the first one correct, if you answer it in the affirmative, then you don't have to go any further. Now, I spent some time on the comprehensive plan. Most citizens, most folks that are in public office, that's above their pay grade. Unfortunately, it's been part of my pay grade, and I've had to learn about it, and I've had to do research about it. So that's why I had Mr. Hewitt testify about it. I wanted you to know that this comprehensive plan is not something that somebody went in and flipped somebody $50 and had them put their land in the comprehensive plan. That's not the way it works. It took 5 years with every player as a part of it. Now, why is that important? It's important because people have to buy into a comprehensive plan. People want their county to not be developed helter-skelter. Now, I'm sorry this is on Facebook, but I live right next to Powell County, and they don't have planning and zoning. They can do whatever they want to in Powell County. In Montgomery County, they don't do planning and zoning outside a 1 mile radius of the courthouse. In Madison County, they let people do whatever they want to do. And they pay for it. They pay for it in infrastructure. They pay for it in fire protection. They pay for it in schools. A county, I told Mr. Hewitt that I'm very proud about Franklin County, how proactive it's been in putting together its comprehensive plan. And the question for you is, does this fit within the comprehensive plan? The reason it's important how the comprehensive plan was put together is that for the last 20 years, this citizens group that's met, after getting all the policies and goals together, took a look at all the property in Franklin County, and they assigned employment center. They assigned industry to this property. It's long before Mr. Tierney made an offer on the property. It's before Mr. Hewitt came to work. And it's before Terry Bradshaw came to work. So to say that somehow this is an erroneous designation for it is almost beyond belief. I would ask you to look at page 17 of Mr. Hewitt's report. And I'm proud to say I have 10 grandchildren. And the joke at my house is the puzzle makers are going to be the good ones. The puzzle maker, the people, the ones that can put the puzzles together, concentrate and do that. Well, I challenge you to look at that map on page 17 of the existing land uses around this property and come up with any other conclusion that the puzzle piece of 690 Duncan Road fits squarely in there. Now, I guess I'm a big boy, and you might come to a different conclusion, but and we'll still be friends. But I'm just telling you that there's absolutely no way that puzzle can't be completed if you don't use 690 Duncan Road. Now, there's been some discussion about these utility lines, and they relate to the comprehensive plan. I'm counsel for Winchester Municipal Utilities. I'm extremely sensitive to land use planning because when we go out and put a sewer in, we want to put one in the right size because we don't want to go back 5 years from then and put another one in. So community planning like this is very important. So what did the Franklin Plant Board do? They looked at this map that's been around for 20 years and they said, well, we can't put a 6-inch water line out of this property. We better get a 24-inch out there to serve this industrial property. And then what do? They don't stop right at the property. They surround the whole property with 12-inch. Those are very big lines. Somebody made and they're expensive lines. A 24-inch ductile iron line is 5 times as expensive as a 6-inch ductile iron line. So who else relied upon this plan? I think the Frankfurt Plant Board did. Now, you might also wonder who else did. Well, it looks like the Transportation Cabinet is kind of looking at improving Duncan Road, improving US 60. Wonder why they're doing that. I mean, anybody can drive by out there and see the Bizac property and see the other property and know that this is it's within a mile of the interstate. If you're like me, when I go on a trip, I don't want to drive 5 miles from the interstate to get gas. They hover, industrial and commercial, they do that. They hover on the interstate. You drive around, you look, these companies want to locate near an interstate. Now, the industrial development, I know other people are going to speak about that, okay? About how important it is and that kind of thing. But I would just call you to one little fact. I sit on our industrial board. Mr. Tierney is the chair of it. And I'll tell you what, the day is gone when a company shows up and says, got any land, agricultural land that we can buy to put a plant in here? They show up now. They probably want you to give you the land, but they certainly don't want to fool with the process that we're in. So that's it. You're just not going to have industrial development, and because there's so many competing. It's now a national thing. You all are just like us, right next to an interstate, and that's a big advantage if you use it. If you use it, it's not an advantage if you don't use it. And we're not talking about putting, big warehouses down in the middle of Frankfurt and that kind of thing. We're talking about putting warehouses where your planners or industrial facilities where your planners have put them for the last 20 years. And everybody having a seat at the table. Now, in closing, I've cut this way back. I have a lot more to say, but I've cut it way back because the hour is late. I agree with the opponents here. I agree. Land use planning is very important for a community. Franklin County and Frankfurt have been in the forefront on the issue. For 20 years, citizens have been diligent in meeting, exchanging ideas, and formulating a vision and plan for the community. They've diligently followed all the regulations and all the laws. They've held the meetings. They've adopted the plan. They've made the policies and goals. They put the map together. They presented them to the fiscal court and to the city commission. They've approved them over and over again. And that's how it's supposed to work. Everybody having a seat at the table. Nobody, hey, why don't you put my land in there? No winners, no losers. Now, the reason that one last puzzle. The reason I included Mr. Hewitt's resume in your package, you might think that's a strange thing to stick in a package when you've only got a few documents in there. Well, the reason I put it in there is because it's impressive. You'll recall at the very beginning, I mentioned to you that the one way you tell about whether testimony is a fact or not is you consider who the party is, what their experience is, and what their interest is. Well, Mr. Hewitt is somebody this fiscal court luckily hired about 20 years ago, or 18, and luckily have kept him here. He's not only educated in planning, he's educated about 20 years of experience in Ohio and Kentucky. He is invested in the community. You look at his resume. He's a graduate of Leadership Frankfurt. He's been extensively involved in the area, Bluegrass Area Development District. He's been the point man on the construction of the building that we're sitting in. He's been the coordinator of the Franklin County Fiber Optic. He's built a fire station. He's built the public safety building. He is a man. I've never met the man that has his community in mind. So I suggest to you that his opinion should not be disregarded. I suggest to you that the comprehensive plans committee's opinion should not be disregarded. I suggest to you that the planning commission's 6-2 vote should not be disregarded. So we can listen to the few and we can think of ways to vote against this, or we can follow the law and see that it's very clear that the comprehensive, that this This proposal is in an agreement with the comprehensive plan. And if you throw all that out and say the comprehensive plan's not worth anything, I think if you look at all of the infrastructure, the lay of the land, the puzzle piece, and all the existing and surrounding uses, the proposal to lease 80% of this property in green space, the natural buffer of 14 or 18, 17 acres in Woodford County, to these neighbors that knows how appropriate this zoning classification is for the property and how inappropriate. It's been a long time coming. That 20 years ago, they said there ought to be an industry here, and we're just now getting there. So we would ask you to give second reading to the zone change ordinance. Thank you.
Thank you. Okay, that was your closing argument. It is now time to bring people in. We have clerk. Do you have the first person?
Yes, Carmen Inman.
Carmen Inman. Carmen Inman. Will you administer the oath, clerk? Yes. Sorry. Welcome. Welcome.
Do you promise to tell the truth, the whole truth, and nothing but the truth?
Thank you. Would you please state your name?
My name is Carmen Inman. I'm the president and CEO of Frankfurt Area Chamber of Commerce.
Okay. You have up to 10 minutes.
I won't take that long. And I've already told you, if I have extra time, I give it to Ms. Bradshaw.
Okay.
All right. Okay. The Frankfurt Area Chamber of Commerce Board of Directors voted to offer strong support of the zoning change for 690 Duncan Road from AG to IG in order to promote the development of this property in the industrial park at our January 28th, 2020 and June 4th, 2020 board meetings. This zone change comes at a critical time for Franklin County and Kentucky Capital Development Corporation, as we have limited industrial property available for sale or development. The future development of this farm will be beneficial to the county by increasing real estate tax generated by this property and adding nearly 100 acres of developed property that will create jobs, additional occupational taxes for our county, our schools, and our health department and our community. We have to look at what we're doing to be competitive in today's economy, Franklin County both do. We have to be proactive instead of reactive to issues if we want to invest in our future. We can talk all we want about our children and our grandchildren wanting to live here in Franklin County, but what are we doing to make it happen? Are we creating development? Are we creating jobs? Or are we keeping our taxes at a livable tax rate? With the Duncan Road property, we have an opportunity to check off some of these boxes. Yes, we are open for business. Yes, we want our families to live here. And yes, we care about our citizens by keeping our taxes at a livable rate. The Frankfurt Area Chamber of Commerce, as you know, is a business organization, and we invest in our opportunities. We take risks, and we build on our return of investment. Our small businesses know how a little risk can help prepare today's enterprise for tomorrow's events. Build resilience, businesses, and maximize change to thrive in the light of unprecedented challenges, as we have seen all of them do through COVID-19. Today, I ask the Fiscal Board members to invest in our community, invest in our future, and duplicate the resilient efforts of our small businesses. Rezone 690 Duncan Road to allow development for additional industrial land and help stimulate our local economy. Thank you.
Thank you. Now the squires may ask to cross-examine you.
Okay.
Are there any questions for Carmen Inman? Squire Booth.
Well, this is not a question.
Squire Booth.
I was asking that the video of her be lowered so we could see her face and not just the bottom of her chin and on up, you know. So, you know, I'm always looking.
Are there any questions for Carmen Inman from the matches? Squire Tracy.
Thanks, Judge. Thanks, Carmen. Carmen, quick question. How many of the current businesses that are located in the industrial parks right now, how many of them are members of the Chamber of Commerce?
In our industrial parks, we
Uh-huh.
probably, I'll say 15 of our local manufacturers, and the Creon Club is also members of the chamber.
Thank you.
Any other questions for Carmen Inman? Any other questions? Hearing no other questions, Mr. Hewitt, you have a question for Carmen Inman?
No, sir.
Hearing no questions from our staff, does the applicant have any questions for Carmen Inman? Carmen, thank you. God bless you. Thank you for hanging with us so long. We appreciate you. Thank you. Call the next speaker. Who is it?
Oh, I'm sorry. It is Terry Bradshaw.
Terry Bradshaw. Swear in.
If you don't care, Ms. Jane has been out here for a long time.
Okay, that's fine.
You okay?
Yes, yes, sure.
Jane Julian.
She may have some documents to present to the court too. Okay, okay. Miss Jillian, come on in. Miss Jillian, welcome. Come up to the podium. Would you please raise your right hand and be sworn in?
Hi. Do you promise to tell the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Please state your name.
Okay, I'm Jane Julian.
If you go, we'll move up to the, just a little closer. Thank you. There you go. And we apologize you've had to wait so long, but thank you.
Okay, well, that's all right. I'm here now.
Yes, thank you.
Hello to all magistrates.
Hello.
Yeah, okay. Let's see, and I have a paper copy of my remarks, if anybody wants.
Just hand it to him.
Okay, yeah, that's a clean copy. No germs. Okay, and I'll just read my remarks.
Okay. Remember, you have up to 10 minutes.
Up to 10 minutes.
Yes.
This is gonna be one of my long ones.
Okay.
Okay. I'm Jane Julian and I live at 1915 Louisville Road. Judge Wells, magistrates, and all other officials, thank you all for agreeing to hold this evidentiary hearing on the proposed zone change at 690 Duncan Road. I know that it is out of the ordinary for the court to hold such a hearing, but we live in extraordinary times of change and adaptation. I thank you all, therefore, for being willing to treat this proposed zone change in quite a different way than usual. I attended both of the planning and zoning public hearings about the proposed zone change. At the first hearing, I heard many Duncan Road residents and neighbors speak against the proposal. As I listened to the testimony, I was struck by how many longtime residents talk about how they've spent their lives building homes on Duncan Road and raising their families there, all the while working to support themselves and to contribute to our community in so many ways. There are also young families living on or near Duncan Road, and all these households have invested their entire lives in our county. As a result of this disrespectful land destruction, I ask you all to consider this question. Why would young people want to move to Frankfort and put down roots in a neighborhood where there is no guarantee that their homes and property will be protected from extremely inappropriate development? Our community has to revisit our comprehensive plan in 2020. Now is the perfect time to revise our plan so that it serves the needs of all citizens in Franklin County. We all need to be part of any planning process that affects our daily lives. Our hard-won personal property, but the court denied the zone change and instruct Mr. Tierney and his group to halt their continued destruction at 690 Duncan Road. At the same time, I ask that the court and other local government bodies involved in this issue work with Mr. Tierney and his group now to mitigate past, present, and future physical damages to the 690 Duncan Road property. Thank you for your time and attention.
Ms. Julian, thank you for your comments. Are there any questions for Ms. Julian from the magistrates? I don't see Squire Booth. Mute. Squire Booth, mute.
I can't hear you.
Squire, you need to unmute your, thank you.
Yes, I know. I'm so sorry. I wanted to ask, how long has the land that you live on now been in your family?
My Julian ancestors bought the farm where I live in 1813.
Wow. Okay.
That's a long time.
Any other questions?
Yeah.
Okay.
And
Are there any other questions for Miss Julian? Go ahead, Squire Booth. Go ahead. Go ahead. Sorry.
Oh,
Sorry,
no,
I thought you're finished.
I'm finished. I just wanted to say that I'm grateful for having that land left natural, and I drive by it every day. Thank you.
Okay.
Well, thank you, Squire Booth, and I must say, I'm really glad to see you, if only on TV.
That's right. Squire Blackburn.
I just wanted to thank Miss Jillian for coming in and waiting 3 hours and 40 minutes before she could speak. I appreciate it.
Okay, thank you.
Okay.
Yeah, you're
Are there any
welcome.
other questions for Miss Jillian? Seeing no other questions, Miss Jillian, thank you. God bless you. Thank you for waiting this length of time. You'll follow the sheriff's deputy. He will show you how to get out. Thank you. The next speaker, please.
Terry Bradshaw.
Terry Bradshaw. Okay. Would you please raise your right hand?
Do you promise to tell the truth, the whole truth, and nothing but the truth?
Yes.
State your name, please.
My name is Terry Bradshaw, and I'm the president and CEO of the Kentucky Capital Development Corporation.
Okay. You got it. Up to 10 minutes.
I will try not to repeat things that you've already heard. We could get hit and miss out in the hall, so I don't want to take up your time with the things that you've been told so far. So if I do that, I apologize. I just want to address some things that have been out in the community that are misstatements, and I want to be sure that we have those facts correct as we go into this decision-making process. One of the statements that I heard was that the industrial parks are not being used properly. Not exactly sure what that means, but I can tell you that the 3 industrial parks that we currently have in Franklin County were originally valued at just over $2.5 million. That's the property in each of those, collectively in the 3 industrial parks, prior to being purchased for industrial park use. At that assessment, assuming they did not get ag adjustments on their taxes, they were just paying straight up, they would have paid $30,866 a year in property taxes. Property taxes within those parks now, the property in the parks now is valued at $99,409,005. That provides $1,227,353 in property taxes to the county budget each year, which is an increase of about $1.2 million annually. Those same 3 industrial parks provide 2,728 jobs with a total of about $185 million in salaries, which provides over $1 million in occupational taxes each year also for the county, and about 500,000 to 600,000 of those for the city as well. There is an Excel spreadsheet that I submitted in your documents that shows you each industry and what their contribution is. There was also a question about the land in the Industrial Park 3, there being some vacant land there. The only industrial land that is available in Industrial Park 3 are a 1.37 acre parcel and a 2 acre parcel. that have both been sold under contract twice, and then there were some issues with the way the ground was packed under the industrial park, and so those contracts didn't go through. The reason there is land that is not developed in that park is because it is not industrial land. A number of years ago, the Kentucky Capital Development Corporation entered into an agreement, a written agreement with the Musey and Hanley farm owners. They had an agreement that they would sell the property to KCDC to be used as an industrial park. KCDC committed about $4.5 million to the purchase of that land, and then to the adding the infrastructure to get that park developed. And I believe before there was ever a building built on it, those same people came back and petitioned planning and zoning to change the zoning of the industrial park. And so they changed the whole back section of the industrial park to professional office. And there is not a great market for people who want their professional office in the back of an industrial park. So fortunately, we did actually sell that property after spending about $250,000 having it mowed. So we did actually sell all that property. We have a developer who is putting professional office space back there. So that, I hope that clears up that question. There was also a question about Mr. Tierney and whether he deserves to have this property rezoned. Over the past 5 years, and that's all I can speak to for Mr. Tierney because that's the only time I've known him since I've come to Frankfort. But in the past years, he has purchased $20 million worth of buildings and property in Franklin County. He's added value to each of those properties by building new buildings, upgrading abandoned buildings, providing infrastructure, and most importantly, jobs. It has been said that we have said a number of times about things in this industrial park will be paid for by the taxpayer, which is incorrect. The infrastructure runs to the property line. I think Mr. Hewitt mentioned that earlier. And the internal infrastructure in the park would be paid for by the developer. But that being said, Mr. Tierney is a taxpayer in this county. He pays $160,000 a year in taxes in this county. So I don't want us to forget that as we are trying to take care of the other property owners in our community, that Mr. Tierney is also a property owner and a taxpayer in our community. He has provided the city and county with a steady stream of available properties and spec buildings that we would not have had otherwise. Because of his willingness to relocate the Recon Group, which was in a building that he had there in the industrial park, we had HT&A who wanted to bring some more of their employees here and build what they call a campus here. They were looking for a community, and they wanted to move the building they have to that campus. So there were 150 jobs here in that building already. Mr. Tierney worked with us to move the Recon Group to another building that he retrofitted so that they could fit into that building. It's actually a larger facility that gave them the ability to add 45 new jobs to their already 90 jobs. We had 145 that we saved at HT&A. They have committed to 200 additional jobs, and it was about a $44 million investment in our community. So I don't want us to get confused in thinking that Mr. Tierney doesn't do great things for this community, because he absolutely does. Let's see. The comprehensive plan, I believe Mr. Hewitt got this, and what he didn't cover, Mr. Fromm most certainly did. There was not a question in the original hearing that there was ample proof that Mr. Tierney's request complies with the planning and zoning and with Franklin County Comprehensive Land Use Plan. I would say, just in addition to what they said, and I think Mr. Hewitt may have mentioned this also, but like I said, it was hit and miss in the hall. If we don't follow the Comprehensive Land Use Plan, Mr. Hewitt and I really have a hard time knowing how to do our jobs from day to day. Those are our guiding principles. Those are the things that we use when we work with potential developers and people who are interested in investing in our community. It was said at some point, a number of times actually, warehousing is not a great job generator. I'm not sure where the confusion came with the IG being for warehousing. Warehousing is allowed in IG. But over the last year, with Mr. Tierney's knowledge and lots of times his assistance, we have shown that property to 5 different industrial projects. We had to ultimately pull out of those projects because the deadline came before the zoning was changed. But we have a project in the works on that property that we are still in the running for, and then we just actually submitted a new project this morning, another one that we have that is available that we are sending an RFP on. So that's 7 projects and nearly 1,000 jobs and several billion jobs of investment that we ultimately were unable to be competitive for because we don't have the land to do that. And let me be clear, we don't have the land to do that. We have listed on our site, because we list everybody's property on our site that asks us that we list their property on our site. But there are qualifications that each property must meet before we can recruit industry there. And we don't have, I included this in your packet also. We don't have any property other than 9 acres that is not in any of the industrial parks that is available that meets those qualifications. So the only property in the comprehensive plan that is left that is recognized as a future employment center is there at that intersection. And there was one other statement made previously that we should just wait for an industry to come and then we would develop the property. And I've provided for you statements from about 30 site selectors throughout the country and other professionals in economic development that assure you that's not the way it works. We would never get a project if we wait for the company to come and then we try to find some land and we zone it.
Okay. Okay, are there questions for Ms. Bradshaw as from the magistrates? Squire Tracy, is your hand up? Squire Tracy?
Thanks, Judge. Thanks, Terry. Just a quick question. Mr. Tierney touched on just leasing the new 112,000 square foot facility that he built. How many new jobs have been created there at that location?
100.
I don't know the answer to that. Mr. Tierney can provide that answer for you.
100. Okay.
100.
100.
Okay. I'm sorry. I didn't realize you weren't involved in that. I'm sorry.
Any other questions? Any other questions? Ms. Bradshaw, before you go, give us an overview on what are industries looking for in a community. I know land is important, and on the average, how many acres do they look at when they say, we like your community, but this is what we need. We need this size.
Well, it's all over the place, honestly. And I can tell you, in those 7 properties that we have shown this piece of land. We had a 50-acre request. We had a 16-acre request. We had a 25-acre request with the ability to expand to 50 acres. We had and I don't put that on your notes, but that was a 23-acre request. The grade construction was a small 5-acre request, which we didn't have either, except for the 9-acre one that they looked at, and that didn't work for their project. Another 50-acre request, and then the one this morning is a 10+ acre request.
Yeah, so it is all over the place. Okay. Hold on a second. Staff is next. Mr. Hewitt, do you have any questions for Ms. Bradshaw?
No, sir.
Okay.
Ms. Bradshaw, I noticed this afternoon you submitted some documentation to public hearing at franklinkentucky.com. Is all the factual information that's contained in both your letter and the spreadsheet that you sent in, is it true and correct?
Yes, sir.
And would you make that part of your testimony here tonight?
Yes.
And also, you had previously, your board had written a letter. I've been shut off here. I'd show it to you.
Yes, we have.
That in support of this project, and I think it has also been submitted to the planning office. I don't know whether it's up. It probably is on that website somewhere. Would you make? Is that true and accurate? And was that from your board members, 100% of your board
yes,
members
sir.
for the project?
Yes, sir.
That's all.
Okay. All right. Ms. Bradshaw, thank you. Appreciate you coming in. Sorry it took so long. Let's have the next speaker, please.
Evan Goddard.
What's the name?
Evan Goddard.
Okay, Mr. Goddard. Welcome.
Hey, thank you.
Would you please raise your right hand?
Do you promise to tell the truth, the whole truth, and nothing but the truth?
I do.
Okay, thank you. Please state your name.
Thank you. My name is Evan Goddard. I live at 1310 Duncan Road.
Okay.
First off, I want to thank you and all the magistrates as well for having us here.
Yeah, you.
Thank you. I won't filibuster for 3 hours. I'll keep it short. I'm pretty hungry, like you guys probably are as well. So I'm sorry for my perceived crankiness. I've been in a hallway for 4 hours. So.
I understand. We apologize.
Absolutely. So I live at 1310 Duncan Road. My wife and I built our home in 2016 with absolutely no idea that the Blanton Crutcher farm next door would become what it has. Based on the past 11 months of my own eyewitness accounts, I personally am led to believe this zone change occurred long ago. And this is all just a formality. So I implore you to please prove me wrong. Here are some of the events that have led me to believe this. First, I watched as arguably the oldest house in Kentucky was demolished to the ground without so much as a permit. We've talked on that, no need to keep going. Second, the entrance to the farm was completely gutted right away with the removal of an ancient cypress tree. It's not a snake pond. And the pond that was serving as the watershed for the surrounding area, they're gone already before this zone change has happened. With the watershed out of the way, the Slickaway Creek area of Duncan Road now floods over more than ever. It's really easy for anybody who is not driving the road every day. I live on Duncan Road. I work on Duncan Road. I pass it every day. It's not as good as it's being made out to sound right now. So this is due to the enormous building right at the curve that pours water off its 100,000 plus square foot roof and into a small drain that Mr. Tierney has constructed on the property. The drain passes through the Blanton Crutcher farm and sometimes over the road into the creek. The rate at which the water flows off the roof and pours into the man-made ditch reminds me of an old saying, trying to stuff 10 pounds of blank into a 5-pound sack. You can use your imagination. Mr. Hewitt said earlier that the improvements are going to be made to the road soon. So who's paying for that? Is that you, me, the taxpayer? Who's maintaining it? Same question. He also mentioned a traffic impact study, which is a very interesting choice of words, which brings me to my next point. I've personally witnessed 2 traffic accidents, one of which involved Mr. Tierney's dump truck. I don't know if, or Mr. Tippett, are you showing the pictures?
If you're ready for them, I can show them. Yes, sir.
Just let them go as a slideshow. You can see the entrance there that we're talking about. That's the snake pond and the cypress tree that he was referring to. And that's what it looks like now. With that traffic impact study, hey, there's a traffic impact. So both of these accidents caused me to be late for work. I understand now that one was his, the other just was near his property. So I did personally see the one that's on the screen with my own eyes. I was late to work because of it. I work at Monoplast for reference. So fourth, my wife and I had no choice but to look on and listen in for months as an excavator with its sedan-sized brush cutter attachment easily cleared out the existing transitional border barriers, trees, and fence lines. We now have an unhindered view of airtight mine products, Hawkins, Belasto Metal KY, Hayashin Telimpu, and all of their daily noises and nighttime lights, along with the daily excavations that are sometimes only feet from my backyard. As you keep scrolling, you'll see the excavators on there. To mitigate some of this light and noise pollution, my wife and I purchased 23 Norway spruces for a total price tag of $7,500. So I've already had a financial impact because of this. We'll be paying these off for years. So I guess I can put the family vacations on hold for a while. However, I'm afraid this pales in comparison to how much my property values are going to decrease if this zone change is approved. Simply put, no one wants to live next to an industrial park. Do you? Fifth, and probably most importantly, my argument, where is the tombstone that belongs to Miss Elizabeth Miner? It's on there somewhere. Yep. So I grew up on the farm my whole life. I used to go over there when it was for sale and even before. It was just kind of fun. You'd see the tombstone. Hey, that's really cool. Where is that now? I can see the site from my bedroom window, and the house is completely gone. It's all been graded. Everything's been bulldozed over. Where's that tombstone? I asked this in the January meeting and again in the follow-up meeting. No one's given me any answers. So let me just go ahead and read this excerpt from KRS 525.115. Anyone online can look that up and read along with me. That says that 1, a person is guilty of violating graves when he intentionally, A, mutilates the graves, monuments, fences, shrubbery, ornaments, grounds, or buildings in an enclosing any cemetery or place of sepulture. B, violates the grave of any person by destroying, removing, or damaging a headstone or footstone, or the tomb over the enclosure protecting any grave. C, digs into or plows over or removes any ornament, shrubbery, or flower placed upon the grave or lot. 2, the provisions of this subsection 1 of this section shall not apply to ordinary maintenance and care of a cemetery, nor the removal and relocation of graves pursuant to procedures authorized by and in accordance with applicable statutes. 3, violating graves is a Class D felony. You're a judge. You know this. 4, the court shall order the defendant to restore the cemetery to its pre-damage condition. Again, that is KRS 525.115. I encourage you to please look that up. For context, I watched for 3 days as the entirety of the house and surrounding area was loaded into a dump truck and hauled to the back of the farm and dumped just out of view. You can see it on this picture where the little clearing is towards the top left. That's where the house is now. I'm not sure if he filed that. I saw in the newspaper that he was supposed to report where it went. If you're curious, fly a drone over it, take a drive on the property. That's where the house is at. 6th, it's funny that Mr. Hewitt said economic health, because this is really important for me and my family. On April 14th of this year, my mom came down to pick up my son for the day. And as soon as she opened the doors, our house began to fill with a noxious smell of smoke and debris. I looked out the window to notice a steady plume of yellowish brown smoke originating just beside where the house debris lay. I immediately called the fire department to check the air quality as my eyes and throat were becoming slightly irritated. I ended up having to duct tape all my doors and turn off my HVAC in an attempt to keep any more smoke from entering our home. Just for context, my wife is pregnant. We're having a baby in 2 weeks, so this isn't great. So the fire department ultimately came out, and I watched as the excavator that was previously loading the house into the fire, switched gears, and he did help extinguish it. According to the State Journal, shingles, a tire, and a portion of a radiator, various metals, brick, and painted wood were among the burn piles. Mr. Tierney reported to the State Journal that he, quote, was not aware his actions were illegal. I was going to ask him how long he's been in the construction business. I heard him say earlier, 40 years. You should know better. You should know better. There's no excuse for that. My mom ended up having to go to the hospital due to smoke inhalation, which was later confirmed by her doctor. She continues to be plagued by the adverse reactions due to this fire. That's why she's not here tonight. In closing, I've been forced to listen to this every single day for the past 12 weeks due to the pandemic and shelter-in-place orders. How can all this happen if the zone change has not already occurred? It's my last paragraph. There are currently 2 excavators, 1 bulldozer, and 1 dump truck that work 5 days a week from 8 to 5:30 roundabouts, creating a constant array of beeping, bumping, banging, clanging that is audible from literally every single point on our 45-acre farm. Based on the information above, Mr. Tierney has procured an alarming pattern of blatant disregard that I fear will become exponentially worse if this zone change is approved, allowing him to move forth freely and unhindered. I beg of you, please vote no to this zone change. That's all I've got to say. I really appreciate your time.
Okay, thank you. Are there any questions for Mr. Goddard from the magistrates? Squire Moore?
Where is your farm adjacent to this one?
Do you guys have that map that you guys have been showing all night? The survey map?
You have that survey map.
It's on there.
He's cut me off.
I'm sorry.
He's shown on the.
I'll give you a minute of my time.
The fiscal court has that map.
Okay, Andrew, can you show that map?
Andrew, can you pull up that map?
I'm not sure, Judge. The bandwidth issues we were having earlier was related to the So that's why I turned him off, because it was causing the lag, I'm pretty sure.
That's okay. Are you?
Hold on a second. Turn Mr. Rump back on and he'll bring it up, Andrew.
He should have that ability to turn himself back on.
Are you behind the farm? Are you on the same road on the same side?
Pull up the map and you'll see it.
We're trying.
In Woodford County or Franklin County?
So my house is in Woodford County, but of the 45 acres that I share with my parents, Tom and Susan Goddard, part of, I don't know how many acres, 19, 20 are in Franklin County.
Okay.
Our house is directly next door. There's one fence that separates us. There used to be the residential or transitional barriers, which I'll also show you on that map, have all been removed. I know it was said earlier, they were little bitty trees that didn't have any type of bearing. But the thing is, when I moved into my house in 2016, I couldn't see any factories. I could see 3 lights from the factories. Now I see every factory. I see them well enough that I can list off their names. This is under oath. This isn't just because I'm driving over and looking, they're mad about it. It's constant noise.
Okay, are there any other questions for Mr. Goddard? Squire Booth.
Do you plan on selling your house and moving?
Absolutely not. My grandfather purchased the property. My parents built on it 34 years ago. My wife and I built on it. We're raising a family on it. We just spent $7,500 in trees. I plan to live there until I die.
All right.
Thank you.
That's a citizen for you, right? Thank you.
Andrew, can you bring up that map?
I thought Mr. Rumpf was bringing it up.
No, Mr. Can you get it, Tambra?
It's not letting him share his screen.
There it is. It says right there. It's the screen. I can see a screen right now.
There it is.
There you go. Okay, so scroll down to the very bottom.
I got it.
It's the bottom.
Just a minute. Do this. You got it.
So basically the entire bottom of the screen is our farm. Yeah. So where the blue runs the outline, you see the little yellow dotted.
I'm showing this property here.
Okay.
That's my house right there. That you're go to the right a little bit, if you wouldn't mind.
That one?
That one is my house right there.
Okay.
And his mom lives near there too.
Mm-hmm.
Okay.
So my parents live about 500 feet up the hill. The old house was exactly 1,000 feet from our house.
That's okay. We saw it. Yep. Okay. So all 4 of those lots are parcels are your family?
Yes, sir.
Okay.
Yes, sir. Yeah, they had to break it up in order for us to get the in-family conveyance to build our house on the land.
There.
Yes.
Got her.
So we have a very unhindered view, and the potential stormwater management basin has already begun. That's in one of my pictures there. We started that about 3 weeks ago.
Okay. Mr. Rump, thank you for bringing that up. Thank you for sharing. Mr. Goddard, thank you.
Appreciate your time, everybody.
Do you have a question?
I would point out
Yeah.
that it appeared that at least 2 of those houses were Woodford County. I mean, it looks like.
Yep, I just said that under oath.
Okay.
I'm in Woodford County, but our farm is in partially in Franklin County, and I have an unobstructed view of everything that's going on daily.
Okay. Do you have any other questions? No. Mr. Hewitt, I'm sorry, did you have a question?
No, sir.
Okay. Being no other questions, Mr. Goddard, thank you. Bless you for staying here this length of time.
Appreciate
and all
you.
the best to your wife.
Thank you very much.
Thank you.
Thanks.
Thank you. Call the next witness, please.
Tom Goddard.
Or speaker, Tom Goddard. Please, sir.
This comes off.
You can take it off. Yeah, I hear you. I hear you. I hear you.
Do you promise to tell the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Thank you, sir. Welcome.
Thank you.
Thank you for
Thank you, Your Honor.
bearing with us.
I appreciate you, and I appreciate you lobbying for us earlier that you were thinking of us, and I thank you. Judge Wills and honored magistrates, my name is Tom Goddard. My home for the past 32 years is the Scenic Spring Farm that shares a border with the subject property. I'll refer
you know what I'm talking about. It has been a nightmare to witness a beautiful historic farm being reduced to a barren waste. Though the property is zoned agricultural, Mr. Tierney is actively developing the property as though it is now zoned industrial. That was my son, Evan, just like what
we figured.
At the January 9th meeting, let's back up, of the Planning Commission, Chairman Jackson stated that any further findings in fact may be submitted to Robert Hewitt of Planning and Zoning by January 30th, 2020. This would give the commission ample time to study the findings before their meeting to vote on February 13th. The Duncan Road Hilltop Meadows Neighborhood Association submitted its findings in fact to Mr. Hewitt on January 30th. The same day, we received written documentation from Mr. Hewitt that he received these findings of fact and that he would submit them to the Planning Commission. Excuse me. Weeks later, on February 13th, the Planning Commission meeting took place. The Duncan Road Hilltop Meadows Neighborhood Association findings of fact had not been submitted to the Planning Commission. The Planning Commission took a 5-minute break to photocopy and then to read the 6+ pages of findings in fact that were withheld by Mr. Hewitt. This happened just prior to voting on the rezone several moments later. In the meeting, I openly asked Mr. Hewitt why he did not submit our findings in fact, and he responded by waving his cell phone around the room and saying he did not receive them until 4:31 on January 30th. Chairman Jackson did not state a time of day deadline, only a deadline of the day of January 30th. Mr. Hewitt made his own personal decision to create a time of day deadline to justify withholding our neighborhood association findings in fact from the Planning Commission. So instead of having weeks, the Planning Commission had minutes to review our findings of fact. I humbly ask, well, I beg this court to please visit the subject property firsthand and in person. The subject property is just a 5-minute drive from right here. Travel down Glens Creek Road, McCracken Pike, past the Castle and Key Distillery, and then turn left on Duncan Road and go up Jed Hill. At the top, start looking after passing the Lakeview Horse Arena. You can see for yourself how the Industrial Park 3 is now fully exposed and in full view from this scenic byway in the heart of the Bourbon Trail. There used to be trees that disguised it from view. In this instance, these trees were the transitional area for Industrial Park number 3, and they have been removed. The transitional area, as outlined in the comprehensive plan, needs to be restored as Industrial Park 3 is now out of compliance with the comprehensive plan. Then please make a short visit to the subject property at 690 Duncan Road. Please look at the wholesale destruction taking place on this farm that is on the National Registry. Confirm for yourself that the less than 1 acre Franklin County land disturbance permit issued to Mr. Tierney has been violated. Near the entrance of 690 Duncan Road, and we've covered this several times, but it's here and I'm within 5 minutes, you'll see a new drainage ditch coming from a huge warehouse built on a steep hill. The ditch drains into a small old culvert under Duncan Road, feeds into the Slipway branch. This warehouse is in the industrial park, but the new ditch is on the property requesting the zone change. On October 31st, 2019, there was a heavy rain and Duncan Road flooded and went totally underwater at this location. The culvert was overwhelmed from the storm water racing down from that new warehouse. And that's never happened before because this old modest drain system was never meant to divert so much water from a very large warehouse roof. And I think this is in direct violation of the comprehensive plan that addresses stormwater management. Stormwater from the subject property drains across my farm. This is right now. My land is already experiencing dramatic soil erosion damage as a direct result of the wholesale obliteration of the water retention characteristics that used to be present on this subject property. This is also in direct violation of the comprehensive plan that addresses stormwater management. It will become much worse if this property is rezoned. And please know, all of you, that you are welcome anytime to visit my farm and see this for yourself. Come see me. I ask that you vote against rezoning until the subject property and the Industrial Park 3 are brought back into compliance with issued permits and with the comprehensive plan that was written specifically to prevent irresponsible development. And that's all I've got.
Okay, thank you, Mr. Goddard.
Thank you, sir.
Are there any questions from the magistrates for Mr. Goddard? Squire Booth?
Yes. Hi.
Hi, Squire Booth.
Hello. Hey, how long have you lived on your farm?
I've lived on the Scenic Spring Farm for 32 years.
Scenic Spring Farm is a sign identifying it on Duncan Road?
There used to be, but the archival quality of the sign kind of
deteriorated.
Used to be one. Yes, my other son made it. He's a graphic artist, and it is beautiful. But I didn't protect the finish of it well enough.
Oh.
When you come visit, I'll show you what's around behind the barn.
1310?
I'm at 1300 Duncan Road.
1300. Okay.
Thank you.
Thank
Are
you.
there any other questions for Squire Muller?
Thank you, Mr. Goddard, for coming in. Judge, I would ask maybe Robert Hewitt if he could answer some of those things that Mr. Goddard.
If you don't mind, let's go through the magistrates and I will ask Mr. Hewitt.
Okay.
I'll give him an opportunity to speak.
Thank you.
Are there any other questions from any of the magistrates? Okay, seeing no other questions, Mr. Hewitt, would you like to respond?
Sure. The letter from Hilltop Meadows subdivision was written on January 29th. They chose not to submit it until 4/31 on January the 30th. While Mr. Goddard is correct that no time limit was given, my office closes at 4:30. So I made an assumption that anything that came after the office closed was not entered into the record. The same as I did not submit the Chamber of Commerce letter that also came in after 4:30, later prior to the hearing in February. Upon discussion of the issue with the Planning Commission's attorney, Ed Logan, he said that is not my administrative authority to waiver from the guideline and ask the commission if they would allow the document to be entered into the record, of which they did. It was received. They did take a recess. They all had an opportunity.
A 5-minute break.
They all had an opportunity to review it, and then they acted accordingly.
Okay.
So there's my response.
So it was on the record?
Yes, sir, it's on the record.
Okay. Okay. Is your report on file on our record?
Yes.
With us? Okay.
It is.
Okay. All right. Squire Blackburn. Squire Blackburn? Squire Blackburn, you have to.
Yep. Can you hear me?
Yep.
Yes.
We can now.
Thank you. Mr. Hewitt, you said you had received it, I guess, on your inbox at 4:31. The following day, did you email the people back that sent you that email?
No.
You did not?
No, I did not.
Okay. Thank you very much.
Squire Tracy? Squire Tracy?
Yes, sir. Thanks, Judge. Robert, just quick question. I've asked a couple different times in regards to the drainage pipe that was dug up and moved and redirected. Is it true that it is redirected into a small culvert like we've been told?
Judge, point of order, is this a question of staff or are these questions of Mr. Goddard?
Well, no, wait a minute. Is this,
Who's being questioned?
are you, who are you asking that question to, Squire Tracy?
Same thing I just said, Robert.
You're asking, okay.
Robert.
Question, would that be better answered through Mr. Rumpf or Mr. Tierney?
No, because Robert he answered my question earlier today when I asked if he was notified about it being redirected. And he said no, but they did go out after there was a complaint or after he was made aware of it, and that it met that he was okay with it, or whatever was said. But I'm just trying to see if that's true what we were told. Has that been redirected to a small culvert pipe? If so, has that been approved by planning and zoning?
Squire, I did not say I was okay with it. And once again, Judge, point of order. Should we release Mr. Goddard or is staff being questioned? Is his testimony, is Mr. Goddard's testimony done because there's others, or is this, are we redirecting to staff?
Okay.
I'm happy to answer the court's questions, but what about Mr. Goddard?
Okay. Do you have any questions, Mr. Tracy or Squire Tracy, for Mr. Goddard?
No, sir.
Okay. So, and as you asked that question, what was your point? What were you trying to? Please. This is not a questioning time for Robert Hewitt. It's Mr. Goddard's time.
Okay. Well, I'll ask Robert when Mr. Goddard's time's up.
Mr. Gregory can answer the question. And John, I'm just
Came here.
very patient with allowing testimony about things that are not relevant to the issues under consideration. And where this culvert is running, I don't know how it relates to whether or not this property has been comprehensive plan. The zoning classification for this property.
Excuse me, but we're not privy to what's being said right now. I can't hear what's being said.
Hang on. Okay, Mr. Sparks, can you intervene here? Mr. Sparks? Hang on a second. Mr. Sparks?
I share the concern that Squire Blackburn noted. I wasn't able to hear the issue.
Okay.
I was raising the objection, Mr. Sparks, to the fact that the testimony, most of the testimony of this witness, and certainly the questioning that's occurring now, is not relevant to the issue that's before the fiscal court tonight, and that is whether the proposed zoning is in agreement with the comprehensive plan, and or whether or not the existing zoning is appropriate and is not appropriate, and the proposed zoning is appropriate. Also, I may as well state this objection while I'm up here. It is error for us to have all this discussion about the previous hearing and what occurred at the previous hearing, about Mr. Hewitt's previous report, about anything that happened at the other report. Now, the reason for that is that this is a de novo hearing. I would move to exclude any information that is about what happened before at the previous hearing. This court elected to have a new hearing, and by doing that, you might say flushed the old hearing. And that's why I've been very careful tonight to offer all the evidence again that occurred at the previous 5-hour hearing. Now, the Planning Commission, I will say this, and the Planning Commission attorney let the opposing folks say whatever they wanted to say. And every time Mr. Tierney wanted to explain anything, whether it was the grade or the roadway or anything at all, he said, that's not relevant, and cut us off. So I've been patient. I've let 2 or 3 witnesses go, and I've let the fiscal court, I respect your all's authority here, and I've let you ask questions, but I now would issue a continuing objection to any consideration of any evidence of any previous hearing unless it's used for impeachment, and that's fair game. And also anything that does not have to do in testimony or facts or documents that have to do with anything but the relevant issues before the court. That's Rick, that's my statement.
Mr. Sparks.
Well, that's quite a lot to take in on a short amount of time. If this were a judicial hearing, the court would be bound by a great deal of less latitude than the court has granted the witnesses. That is a fact, and Mr. Rumpf and I both know it. This would have been cut off, I don't know, about 3 hours ago. It is not a judicial hearing. It's an administrative hearing. So certain degree of latitude is and should be permitted. To the extent that there is a lot of discussion on what is, as Mr. Rumpf pointed out, a de novo hearing. That is, the court is elected to do this afresh and make determination accordingly. I would simply remind the court that regardless of what you've heard about various and sundry matters, and the judge gets to control the hearing, the law that you will be applying says that before any map amendment is granted, the fiscal court must find that the amendment is in agreement with the adopted comprehensive plan, or if you don't find that either the existing zone classification is inappropriate and the proposed classification is appropriate, or there have been major changes to an economic, physical, or social nature. I do frankly share and appreciate the concerns that various witnesses have presented. The only witness that has testified as to anything as to that question was Mr. Tierney, because I asked a pointed question: which one are you saying is the deal? Mr. Hewitt likewise indicated that it was zoned AG and that there was the employment center to be proposed. If the court wants to hear those things, okay, Judge Wells, that's your call. How far are you going to let this play out? And I think they're important to the community, and I don't want to minimize that. And I think Mr. Rumpf would agree they're important to the community. He's not trying to minimize that. But I would just remind the court, as I did some time ago, that is the standard under which that you must apply your finding of fact to grant a zone change amendment. Whatever you want to hear, Judge Wells, that's up to you. This is not a judicial hearing. You're not a judicial judge, and you're not making rulings based on the rules of evidence as we would normally do, but there has to be some materiality to the information presented. You got a lot of discretion, sir. You can hear and let it go if you want to, but at the end of the day, what you're going to have to decide is the standards contained in KRS chapter 100.213.
Rick, my objection is not material. I think we would all agree that the things that Mr. Goddard has said and his son would say, and they're material items and they need to be dealt with. The question is, are they relevant to this proceeding? And I submit they're not. I can bring Brad Gregory right back in here because he's been on the site and he's been addressing these issues. He's been involved with designing the stormwater control for 101 Corporate Drive, which is not 690 Duncan Road. The best thing that could happen here is that all that water running off of Industrial Park number 3 would be diverted to 690 Duncan Road and contained there. That would be the absolute best thing that could happen. Mr. Tierney is paying his engineers now to make calculations about 101 Corporate Drive, and he is committed to doing whatever is necessary to contain the water on that site in accord with the regulations. But my objection, Rick, is relevance, not materiality.
Well, and of course, Mr. Rumpf, you know as well as I do that this is not a hearing governed by Chapter 13B, nor the rules of evidence, nor the civil rules, etc. The ultimate decision as to what is going to be heard is up to the judge.
That's correct.
Frankly, if I were adjudicating, there's a whole lot of things, including about half the testimony from Mr. Tierney as to relevancy, because the issue isn't what he's putting on it or what he's doing on it or whether or not it's going to look like a horse park or whether it's going to look like a county dump. It has nothing to do with the decision as to whether or not the thing is going to be rezoned. The question is a statutory question, and if the judge wants to let it go, judge, members of the court, just be mindful that ultimately your decision is going to be based on certain things, and that is the standards contained under 100.213. And you have a lot of latitude, but I think the point is well taken, that is the issue before the fiscal court today.
Okay, thank you. So here's how the proceedings have gone. We allow the speaker to come in and speak. We get questions from the magistrates, from the staff, and from the applicant. All of those have taken place, Mr. Goddard. Thank you for your words. We appreciate you being here. Thank you very much. So,
thank you.
Please call the next speaker.
Connie May.
Okay.
Miss May, okay, Miss May left.
Who's the next one?
Chris Schindler.
Chris Schindler. Ms. Schindler, thank you. Thank you for waiting. If you'll come in and raise your right hand and be sworn in once you get your mask off and everything ready. Okay.
Hi. Do you promise to tell the truth, the whole truth, and nothing but the truth? Thank you.
Thank you. Please state your name.
My name is Chris Schindler. I live at 6660 Robert Harmon Road, Frankfort, Kentucky. And I appreciate the opportunity to speak today.
You need to step closer to the mic. Yeah. Thank you.
I'm sorry. Yeah, speak a little bit louder if you could, please. Thank you.
The mic is here, so we can. Okay, awesome. Okay, thanks. Yeah. Just trying to get the format down. I just real briefly to speak to what just happened. You know, members of the public have been waiting for hours and hours out in the hall, and many of them have left. And it's really hard to hear. We need our chance to talk. So we would really appreciate it if we were allowed to talk without being cut off or being questioned about relevancy. People have suffered here, and we would really like our opportunity to talk.
You go ahead. You've got that chance.
So I'm speaking today on behalf of Envision Franklin County. We've also submitted written comments, and we'll be touching on the highlights of those comments tonight. We request that our written comments and our oral comments are both entered into the record and considered together. By now, all of you are aware of the historic and agricultural significance of the Blanton Crutcher Farm, as well as its location on the Bourbon Trail and its tourist potential. Under Kentucky law, its current zoning, agricultural, is considered the most appropriate and the highest and best use of the land. In order to change the zoning of a piece of property, an applicant must fulfill the requirements of KRS 100.213. The application before you fails to comply with the statute on all counts. Number one, the zone change must be in agreement with the comprehensive plan. Top among the goals and policies of the comprehensive plan is grow by design. This goal and its associated policies lays out how growth is desired, but that it must be responsible, sustainable, respectful of quality of life issues and the environment and the cultural integrity of the area. I submit to you that in this case, the applicant and the application fail on these points. Growth cannot be responsible if it does not follow the law, including obtaining appropriate permits. The litany of violations already perpetrated by the applicant does not indicate that subsequent development will be any more responsible. Likewise, the destruction of community assets like the historic home and the stately trees demonstrate that this applicant cannot meet the key provisions of the comp plan goal, grow by design. The community has forcefully expressed itself that it wants growth that respects the environment and the community's historic heritage. This is not a new demand. It's been around for decades. In preparing for this hearing, I came across an article from the State Journal that had the headlines. There's a 1999 article. Vicki Sewell was planning director and Sharon was on the update committee, and they were talking about the results of public input they had gotten, in which the community, Franklin County's residents, wanted to grow as long as we're respectful of the environment and respectful of our history. And that was back in 1999. time constraints and my respect of your time prevent, I'm not going to go over every detail of our written comments to go through every goal and policy of the comprehensive plan and how they're not in agreement with the application. They're in our written comments. I hope you consider them. But in numerous areas, such as preserving the integrity of neighborhoods, preserving the distinction between town and country, i.e. no sprawl, protecting the environment, and protecting historic and cultural assets, this application fails. Compliance with the comprehensive plan is much more than simply being in alignment with the future land use map. Yes, the area is listed as an employment center on the future land use map. That alone is insufficient to prove compliance with the comprehensive plan. Yes, it's a key step, but it's only the first step. Other factors, such as public health, safety, and well-being, must be taken into consideration, as well as environmental factors. The application fails to even attempt to show compliance in these areas or respect for things like public health and safety. Instead, the application before you seems to make a good case that the zone change is convenient. It's adjacent to the industrial park. It's close to sewer and water hookups and other infrastructure. It's close to the interstate. Just because it's convenient doesn't make it appropriate. The bar is higher than that. According to statute, in order to request and receive a zone change zone change, the property's current zoning must be demonstrated to be inappropriate, and its proposed zoning must be demonstrated to be appropriate. The application doesn't do this, nor does it attempt to do this. Nowhere have I seen that this farm is no longer has high quality soils, no longer has the ability to produce high quality crops, no longer has the ability to provide good agritourism or bourbon trail tourism. It's just not there. How can it be inappropriate? How can an agricultural zoning be inappropriate if no one has proven that it's not inappropriate? Furthermore, the application fails to demonstrate that the industrial zoning is more appropriate. Yes, it's convenient, as I've said, but how can it be more appropriate if, or how can it be appropriate if it also does not safeguard those very things that the comprehensive plan and our zoning is around to protect residents from? Light pollution, noise pollution, quality of life issues, aesthetics, the sprawl issue. Those are all parts of the comprehensive plan. They must be taken in their entirety. They cannot, aspects of the comprehensive plan cannot be cherry picked to make this seem like it's in compliance. Furthermore, arguing that just because the adjacent use is industrial is not a magic ticket to rezoning. If we use that logic, the industrial park could be extended indefinitely because there always would be adjacent land. Finally, the statute says that for a zone change to be approved, there must be major unanticipated changes of a physical, social, or economic nature. Since the applicant hasn't pursued that, I'm not going to waste your time in talking about that response. Moreover, much effort has gone into describing the applicant's previous economic investments in this community. Investing millions of dollars in a county does not convey to anyone the right to operate above the law and should not be an issue here. Finally, the pressure to rezone is apparently because our local industrial development authority says that we need industrial space and we need this for economic recovery. However, without a life cycle analysis detailing the revenue generated by the development compared to the costs of the development, such as water, sewer, police, and all those public service infrastructure, ongoing maintenance, and service opportunities that the community, the county provides on tax dollar money, we don't know if this will be an economic benefit to the county or not. There are many cases in which the developer does put in the initial infrastructure, and then it's all handed over to the county government or the city government, and the county government and the city government have the burden of taking care of that property and maintaining it, and the costs are enormous and must be considered in the final analysis. Lastly, inefficient use of Our industrial park should not be an excuse for sprawl outside of the park. Specifically, office use in our industrial parks is taking up space that could be made available for industry, alleviating the need for rezoning.
2 minutes.
Thank you. There might have been an agreement about office park being in our industrial park, but I submit that our industrial park should be used for industry, and office space is more appropriate in infill areas, and we should move to direct our development in that way. I also submit that the type of industry we recruit should be what the comprehensive plan laid out, which is high-end, high-tech jobs that are going to be the most benefit for the community. And I'm not sure that's the case in this situation. In conclusion, this is a pivotal moment for Franklin County. Envision Franklin County turns 16 years old this last month. We have been involved in development issues the entire time, and we have never seen a worse proposal by a worse applicant. We urge the court to vote no to the rezoning. Thank you very much.
Okay, thank you. Are there questions for Ms. Schindler? Squires? Squire Booth?
Hello, Chris. I want to ask you about the effect that the development, if it is approved, or if the rezoning proposal is approved and construction commences, what do you think that the people that are driving by the acreage, what do you think that people will think about Franklin County when they drive by?
Well, it's an eyesore, and it's not a great way to start the head of the Bourbon Trail going down to some really important economic drivers, distilleries down Duncan Pike there. I believe we need to expand our thinking as a community to see economic drivers as being more diverse than just industrial development. It's ugly. I mean, when I go by, it's just shocking to me what it looks like. I don't think it speaks well of our community. For years, the planners told residents in the area that you're fine. The Blanton Crutcher Farm will be a buffer between you and the industrial park. And no wonder they're angry, because that's just been pulled out from under them.
Oh.
Okay, Squire Sebastian?
Thank you, Judge. Chris, are you making specific findings of fact? And I've meant to ask every person this, and I have flipped to the wrong page on my notes. Have you submitted specific findings of fact to be considered tonight?
No, we didn't. We just submitted our comments. The Duncan Road Neighborhood Association, I believe, has.
Okay, thank you. Thank you.
We submitted findings of fact for the Planning and Zoning Commission. I didn't know none of those would be considered. I thought you guys had access to all those.
Oh.
Okay.
So can I ask a question of, I'm sorry, can I ask a question of our attorney, or should I wait for that? I'll wait. I'll wait, because I don't want to cut into anybody's time. I'll wait. Thank you.
Anyone else? Any other squires? Seeing none, Mr. Hewitt, do you have any questions?
Yes, Ms. Schindler, when the comprehensive plan was being updated in 2010 and 2016, did anyone from Envision Franklin County participate in that process?
Okay, hang on.
It's what?
Okay. Turn the camera.
Do what?
Yes.
Okay. You just testified under oath that planners in the past had told all the Hilltop Meadow residents that they were fine, that the Blanton Crutcher Farm would be a buffer. Did anyone from Envision who participated in the comp plan updates in 2010 and 2016 object to the future land use designation of this property?
Yes, we did not think it was appropriate.
Did you put that in writing?
Yes, I'm sure we did. I didn't go back and pull up those, but we really felt that radius that was drawn around the interstate for development was arbitrary, because it's a 3,500 foot radius and we didn't think it belonged in all the quadrants. It was also, that figure was pulled, I believe you all found that because of it was what you could find that was appropriate for signage around the interstate. And to us, it didn't feel like it was grounded in the kind of research or the kind of rationale that would actually apply to planning issues and development issues. The future land use map with the designates the farm as future employment center is wholly outside of that circle around the interstate, which we believe to be arbitrary in the first place. Now, remember in the first round of the comp plan, we were all super involved. There were lots of people, as you said, 30 people on committees. We were there all the time. We sat around the table, we hashed things out, and I thought it was a good process, and we came up with a good comp plan. The most recent revision was quite a different matter. People were busy, there wasn't much time or effort put into it, and I remember Envision just reacting to the proposal of the revision and standing in front of the Planning and Zoning Commission and giving our comments that we didn't think it was appropriate. But you know, I don't have this exact comments.
Thank you.
No other comments?
No, sir, I'm fine. Thank you.
Mr. Rump? Ms. Schindler, thank you very much. Thank you. God bless you for standing in here for 4 hours and waiting on us.
There's nobody else in the hall.
There's nobody? Okay. All right. Thank you very much. Appreciate it.
Thank you.
Okay.
Yeah. Bye.
Squire Sebastian, you want Mr. Sparks?
Well, I was going to ask if this was an appropriate time to ask, because I've not heard any of the additional speakers outside of our planning director talk about findings of fact. And I don't, so are we to go back through the material that was handed to us and find the findings of fact? Or how are those to be presented to us in addition to what we've heard from the planning director? Thank you.
We do have that on our agenda, Squire, to talk about findings of fact, and hopefully before midnight, before we get to them.
Judge, I just like to clarify that so far, and my tally might be incorrect, but regarding the statutory threshold and potential findings of fact, you have now had 3 witnesses who have discussed that. Mr. Tierney, and I appreciate his pointed direction on that when I asked him, and his representative, Mr. Rumpf, as well. Mr. Hewitt, by way of his report, and now Ms. Schindler's analysis of that statute. So there have been witnesses who have been very directed in their testimony at different points. Squire Sebastian, you're correct. We have not got to the point yet for the court to consider how you want to structure or deliberate the issue regarding findings of fact. But I would note, again, if my tally's correct, you're up to 3.
What are they?
Mr. Rumpf, Mr. Hewitt, and now Ms. Schindler discussed the statutory findings. And I went back
but
on that.
You said we're up to 3. What are the?
I'm sorry. I would not deign to usurp the court's role. I meant there are 3 witnesses, and 4 if you include Mr. Rumpf, who also discussed that, who addressed the Chapter 100-213 standards. The court has not yet discussed potential findings of fact, but in terms of the standard, there are 3 witnesses and their representatives so far. I was referring to the number of witnesses, ma'am.
Okay. May we start doing that at this point in time?
No, we're not finished yet, Squire Booth. We're only halfway through with this meeting. We have a whole bunch of people that are online that are waiting to speak.
Oh,
Video
okay.
conferencing.
Well, we should hear them.
Well,
right.
If we were going to. Are there any other questions? Seeing none. Okay. Andrew, would you pull everyone out of the waiting room?
I thought we're going to pull them all out at one time. We're going to bring them in at one at a time, Judge. I thought we were going to bring them in one at a time.
We'll do one at a time.
Okay.
We've already read the housekeeping rules. And so who's the first one? Patrick Tierney? Hold on. Andrew?
Yes, sir.
Who is are you just showing us the picture and then we're supposed to ask their name?
Well, I'm not sure. Is Mr. Tierney I wasn't sure if he was looking to make is he looking to make a public comment during this time?
Yes, that is correct.
Okay. Then
All
you
right.
can start with him, and then we have 6 more people waiting, Judge.
Okay, Mr. Tierney, you're first. Clerk, will you please swear in Mr. Tierney? Please state your name, Mr.
Patrick Tierney.
Okay.
You promise to tell the truth, the whole truth, and nothing but the truth?
I do.
Okay.
Well, I appreciate your all's time, and I know it's been a long night, but this obviously is an important issue to all of us here. My name is Patrick Tierney. My father is Ron Tierney. We have been intrigued by this property for some time. There's a lot of potential with it. We put a lot of thoughts and effort into what our future can do for this. And in kind of listening throughout the last 5 hours, I was kind of wanting to reiterate the fact that, as Terry Bradshaw stated, there is only 9 acres of industrial land ready for development today. We've been fortunate the past couple of days where our phone has rang off of the hook. We've had people inquiring about land. Some thought that this pandemic would kind of slow things down and possibly do that. We're getting calls from pharmaceutical companies, different other groups that are interested in land. And Franklin County has the ability to be able to utilize that. What this decision is going to come down to is if the economic growth, are we going to economically grow in Franklin County, or are we going to put a stop to it? It's kind of that simple. This decision is what hinges on that. I just ask that the magistrates consider the facts related to the future land use for this debate. A no vote on this issue tells the taxpayers of Franklin County that Franklin County is closed for industrial business at that point, with the exception of 9 acres that are still available. Economic growth is what builds a community and keeps it growing for our kids and grandkids. That's what we all need. Mrs. Schemer discussed the costs associated with sewer and water and utilities. The infrastructure is there already. The cost would be for us not to utilize that infrastructure. And also I ask, I'm assured due to this, how big of a deal this has been, you all have seen the property that we develop. You know, we're not, just coming into the community and just trying to start something from scratch. We really put a good quality product together. It looks good, it creates jobs, and is good for the community. Let's see what else I got here. And also with the recent pandemic, it's shown that America wants its jobs back on our soils. And again, that's what we've seen. And my question to you all, are you all ready to tell the fiscal court that, during this pandemic, while you got a tight budget that was released last week, are you willing to tell the taxpayers that we're not willing to take this effort to create more jobs for Franklin County? Instead, we're going to create more tax revenue. What we ask for is that you make a vote yes to approve this deal.
Thank you, Mr. Tierney. Are there any questions from the squires for Mr. Tierney?
Yes,
Squire
Mr.
Booth. Squire Booth?
Yes. Patrick.
Yes, ma'am.
I thought that this is not self-storage. This is storage for companies that are doing business around Frankfurt. Is that up?
Let me make it very clear. It is not zero self-storage.
Oh.
Zero self-storage. This is building, when we say we build a warehouse, that's what the outside structure looks like. Now, inside there may be manufacturing jobs that could go on. There may be different types of light industrial, but in no way is it self-storage. We will not be building any self-storage on that particular land. Nor do we own any self-storage.
Oh.
We do not own any self-storage.
Pardon me, because you have Tierney Storage on your...
That is the name of our company, but Bob, I really appreciate you asking that question to clarify that.
All right. Thank you.
Okay. Any other question for any of the squires? Seeing no questions, Mr. Hewitt?
No, sir.
Mr. Tierney? Mr. Tierney, thank you very much for staying on and listening through this, and thank you for your comments.
Thank you all for hanging in there.
Okay, thank you. Andrew, we'll take the next speaker.
Yes, sir. Brett Connors. He's coming in right now. Mr. Connors, you're with us. If you want to turn on your okay. Unmute, and if you want to turn on your, there you go.
Okay, Mr. Connors.
Sorry about that.
Mr. Connors, welcome. Mr. Connors, if you would stand and raise your right hand and be sworn in, please, sir.
Do you promise to tell the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you. State your name once again, Mr. Connors.
Yeah, my name is Brett Connors. I'm a resident at 110 Shelby Street in downtown Frankfurt.
Welcome.
Perfect. Yeah, so I think, we've discussed a lot of the important points throughout the course of this that I think really just to drive down to the actual cursory law here would be imperative, and also to review the evidentiary assessment provided in the first instance being the traffic study. So one of the things that I think was brought up previously by potentially Squire Blackburn was that the traffic study is actually fraught with inaccuracies, and it's not fundamentally accurate because it only encapsulates 2 single days throughout the course of the year, and it does not actively and respectively consider distillery traffic and tourism within the sector. So the first day that was taken into account was Thursday, July 18th. Thursdays are notoriously pretty slow. You're going to have slow Monday through Thursdays in the distillery industry. The day was also 91 degrees, which also heavily hampers terrorism in that sector. An example of that would be the following day on a Friday. You'd probably see about a 70% increase in your total guest accounts on site. So those days were definitely strategically selected. Why? You're an expert witness, right? Everyone in the field of law knows that you're only paying expert witnesses that are going to expertly agree to the data that you're trying to have them provide. That's not a discredit to her credentials, but rather a better understanding of fiscal and exchange between expert testimonies. The second date, which was in July 18th, was August 20th, is a Tuesday. Castle and Key is closed on a Tuesday. That Saturday, they had roughly 450 guests to site. Those numbers should be included in the road assessment because I think it depicts the traffic inconsistencies in the sector. So were you provided a report that wasn't fully indicative of the actual traffic situation? I think the answer is clearly yes. So I think at minimum, the evidentiary assessment for that purpose would be to require a new traffic assessment with a neutral party that is actually unbiased and not just purely independent. And I think if you target a date in October or September, particular Friday, you're going to have a much better understanding of the traffic impact in that region. Now, moving on, I think it would be important to discuss the comprehensive plan. I think we've talked around it, and I know both Mr. Tierney and his lawyer have used the comprehensive plan as a justification for this type of transition. But the pure fact is, I feel like we're often picking and choosing weighted arguments. As mentioned before by, I believe, one of the magistrates, the criteria are natively unweighted. But what happens in that, especially in this sector, is that we often equate job numbers, which are often, dare I say, a little bit higher than expected. They're definitely more predictive than accurate. You're using those as a primary driver, but not actually the guidelines that are set aside in the comprehensive plan. If you go through the comprehensive plan in goals 1, 2, 5, 6, and 7, there's extreme native variation between your actual policy points. An example of this would be in goal 1, policy 4, to provide a level of public service to a rural area that complements the rural setting. This would be a failure on that account. Policy 6, providing overlays within the city and county that identify aspects of the landscape that are of cultural, ecological, and historic significance. Again, a failure. When you get into goal 2, policy 1, a failure. Goal 2, policy 5, a failure. Goal 2, policy 7, a failure. Goal 5, policy 1, a failure. Goal 2, sorry, I'm dealing with cats. It's inevitable. She is starved for attention. Let me flip back real quick. Sorry, Marceline hasn't gotten enough attention today. And then at goal 5, policy 1, 2, and 4, and 5, all subsequent failures that are inconsistent with the comprehensive plan, in this instance for rezoning. You also have goal 6, pretty much natively across the board. I think goal 5 is important because it includes a lot of your water issues that you're discussing for drainage native systems and ecological effect. Goal 7, 2, 3, and 4, all those policies are actually moot. I don't think they are reflective of the actual proposal. So I think what's interesting is we all tout the importance of the comprehensive plan, but we're willing to ignore it when it's inconvenient for fiscal gain. And I think that's non-reflective of the purpose of the comprehensive plan. You know, it reminds me of my pastor saying you can't pick and choose the commandments, right? They're all in there for a reason, and the comprehensive plan is in totality meant to represent all of those viewpoints from both a moral but also from a functional standpoint. And that doesn't mean that that hinders growth. You know, in a situation like this, instead of being smarter and more creative, we look for the simple solutions. Storage, industrial storage, which arguably doesn't actually create the jobs that are being falsified in this account. You do see if the manufacturing facilities that Mr. Tierney has been gracious enough to build in the site, yes, that does create jobs. It creates huge economic impact. But the question then begets, is it sustainable economic impact, and is it sustainable job creation? We see the world diversifying in multiple ways and getting younger, more creative, more vibrant. And Frankfurt, in a lot of ways, is behind our neighbors. You know, Versailles and Woodford County has a much more robust historic preservation perspective than us. Georgetown has a much more robust industrial perspective than us. So we try to be both, but we end up being neither. And I think that shortcoming is really the challenge that Frankfurt's going to face in the future. And in a zone like this, you know what the great idea would have been? Agricultural tourism. Look at the success of a facility like West 6th Street has had at their farm in Franklin County. Phenomenal tourism numbers, great taxation for the state. They're able to produce a quasi-industrial product while still maintaining agricultural perspectives that are as old as the 17th century in Kentucky, all of making beer. You know, so instead of seeking that kind of business interaction, we instead sell our soul to buy more industrial facilities in a time that we're going to see a likely decrease in industrial commercial property revenue. Following that, I think there's also a misperception that historic preservation sabotages housing costs or sabotages regional costs as well. Frankly, if we look at the square footage, am I winding up on time? Sorry, I thought I was just checking something. But if you look at square footage costs in new built neighborhoods versus our downtown neighborhoods, the numbers aren't consistent. You can buy a historic home for a much more affordable price point per square foot than a new home. And I think my generation is hopefully remembering that and seeking back that finding of preservation. You know, I think we discussed the farm's history often. I know in the previous meeting that is apparently de novo, and, you know, while they're not, this is a judicial hearing, is missed by some people in the room, I guess, but it's not. So I think the important thing when you look at those kind of factors is the site that was historic on that location was removed. And I think one of the magistrates brought up earlier that he had the right to remove that structure under an agricultural premise. But I think that's not in the spirit of the statute. If you had never had any intent to use that property for agricultural means, to use an agricultural statute to remove a building without authorization is immoral, because that statute is specifically designed for farmers to be able to modernly be flexible to adjusting to their current needs. You know, we know agriculture is a really hard business, so being able to do what you have to do to provide for your family and grow into different crop introspections or different farming or animal introspections is important. Removing a building because it's inconvenient for you prior to you wanting to be rezoned is unfortunate. And if we allow this to continue rampantly in Frankfurt, what we're losing is our history. You know, this region is really intrinsically important to Kentucky for both its history and from a tourism perspective. You know, I know Woodford Reserve's in Woodford County, but between Buffalo Trace, Castle and Key, Glens Creek Distilling, you know, we're likely bringing in about 300,000 visitors a year if Buffalo Trace's numbers are currently accurate. That's a lot of guests that are doing what? Eating in Frankfurt, staying in Frankfurt. You know, why don't we adjust to that kind of tourism perspective to build better industry that's more sustainable for what we're actually good at? Providing, you know, middle income jobs in an industrial sector might not be the best example of that. You know, if you look at warehouse jobs rates versus distillery job rates or brewery job rates, they're actually lower. So instead of benefiting the options that are in the sector, you know, I'm just kind of in general calling for us to be more creative with our economic solutions and not to just consistently pander to those who don't live in Frankfurt, who don't actually have a vested viable economic interest and plan to sell their means the second it's built. You know, so maybe let's let Frankfurt focus on Frankfurt a little bit and protect our historic agricultural resources. You know, this area is wildly important to Frankfurt, and it's one of the last examples in that sector. We allowed the rest of it to become industrial, to become car parks. You know, some of the earliest farms in Kentucky are now where you can buy a Honda, which is not an offense. I love my Honda, great car. But to allow them to, one of the last and most important ones to be removed is just, I think it's a shame, frankly. Now, I guess my last comment is also on companies having an ethical responsibility to the communities that they exist in. You know, I know where I work, we have a really intense passion for providing community access, community benefit, and being considerate of those around us. You know, to the point where everybody knows if you're having a problem with one of our employees, come tell me. I'll deal with it. You know, if you want us to slow down when we're driving by your house, I'll yell at him myself. Anything we can try to do to make the community more inclusive is important. That's not what this is. In fact, for the jobs that are going to be created from this, I would love to see an assessment of the property value decrease that's going to be systemic from this. You know, all these farms around here are going to be bad.
Time is up. I'm sorry, Mr. Connors. I'm sorry.
No, don't apologize.
Do you have, Magistrate Squires, do you have any questions for Mr. Connors? Squire Blackburn?
You're muted.
Yes, Mr. Conyers, I would like to hear your last point one more time.
Oh, I think the real point is that companies, and especially anyone who's doing any development in our sector, should have an ethical responsibility to the communities that they're centric to. You know, and I think that's a big thing that you want to talk about social change that's currently occurring. I think that's more and more important every day. You know, you aren't just building a business and leeching money from the community. We talk about tax benefit, but what you're also talking about is you have to exist there. You have to live there. You have to be around your neighbors. And being a bad neighbor is not indicative of economic benefit. You know, if all that does is cause strife, regional toxicity, it is really the challenges of like a lot of gentrification in major urban sectors, you know, where if you're a positive neighbor and you work really diligently to benefit the community around you, I think it natively integrates more. And that's really what's going to drive modern businesses to this sector.
Okay. Squire Blackburn?
Yeah, could you give me a little bit about your background in education, please, sir?
Yeah, absolutely. So I am educated at George Mason University and the University of Malta. My bachelor's degrees are in art history. My second bachelor's degree is in conflict analysis and resolution. My master's in the arts is in conflict analysis and resolution from George Mason. And my master's of science is in Mediterranean security with a focus on small arms proliferation and counterterrorism analysis.
Thanks, sir.
Yep. Oh, and currently I make gin and bourbon for a living and do historical introspection.
Any other questions for Mr. Connors? Okay. Mr. Hewitt?
No question.
Mr. Tierney? Mr. Rump?
Mr. Connors.
Mr. Connors, can you hear Mr. Rump?
No, I cannot.
Okay. Where do you work?
Mr. Rump, I am currently employed at Castle and Key Distillery in Frankfort, Kentucky.
And how long have you been? Is that in Frankfort, Kentucky?
That is in Frankfort, Kentucky. We are definitionally in Millville, which is unincorporated, but we pay taxes to Frankfort. We're a little bit of both, just like y'all. Okay. But we take a little bit more pride in being from both.
When did you move down to Kentucky?
I moved to Kentucky in, I believe, 2012. I was working for Bluegrass Hospitality Group at that juncture. And then I started consulting on both the beverage side for food and bev, and then transitioned into Castle and Key Consulting in 2014 and started with that project in 2016.
And you have no educational or experiential familiarity with traffic studies and the dynamics of that and how that computer model works and what is the accepted standard of conducting traffic studies, do you?
So I would say I do have 2 masters that are associated with research data assumption. I do not have a JD, but I can tell when data is being determinately skewed for viability. As a lawyer yourself, you definitely understand when expert witnesses are paid, it creates a dynamic that is often non-decisive for instances like this.
Well, I understand that, and I will say this, that Diane Zimmerman, I'd like to say what we commonly refer to in the legal profession, and she's not one, okay? So I assume you also feel the same thing about the Planning Commission's traffic engineer who reviewed that report, and I assume the same thing about the Transportation Cabinet and their engineers there that reviewed that report. If you're going to be critical of Ms. Zimmerman, you need to be critical of everybody.
Well, I'd love to. So it's not necessarily critical of them. I think you have to look at their job burden and the role that they play in our communities. So she's an expert who provided them an expert report. They reviewed it for nominal oversight and made what in her opinion was minor overall changes to that document.
How do you know that? What do you know about traffic?
Can you not interrupt me? That is extremely rude and unprofessional.
Hold on. Come on. Okay. Let him finish, and then he'll.
I understand.
Go ahead, Mr. Connors. Finish your statement.
Yeah. So it wasn't that I was even critiquing her as a professional. What I'm critiquing is the data set. So I think if we remove the people from this situation, we can understand that it's not a conclusive or a conducive data set for this experience. I think one of the magistrates previously mentioned that if you were doing a full week introspection on this, you would have a much better data set that would be more indicative of the circumstances of the region. In addition to that, there's been previous traffic reports that contradict hers. So when you're submitting that and there's oversight, I would love to, they're going to look at it, but they're looking at it from a cursory perspective because she's an expert. They're not going to waste their time.
Okay.
You have other traffic reports you'd like to present to the fiscal court that show that her methodology, the choice of this, you have all those documents you want to present to the court?
So I do not have those reports because I'm not fiscally viably involved in this other than as a citizen of Frankfurt, unlike your client who is not a citizen of Frankfurt. And in this instance, I think it would behoove you all to produce accurate data, not have that fall back to a mere citizen of the county. That is ridiculous.
Okay.
That's all.
All right. We're gonna end the conversation. That's the last. Mr. Rump, and you all don't have any further questions. Mr. Connors, thank you for your comments. We appreciate it.
Sure.
And
thank you guys.
Andrew, bring the next witness in, please.
Clay Barkley.
Who?
Clay Barkley. He's coming in right now.
Clay Barkley. Thank you.
Mr. Barkley, you should be joining us.
Yes. Can you hear me?
Yes, sir.
I'm happy to go on video if you all think it's better. But if we're worried about bandwidth, I'm happy to stay on audio for now.
All right, Mr. Barkley, will you please raise your right hand? And
yeah.
Do you promise to tell the truth, the whole truth, and nothing but the truth?
I do.
Okay.
Judge, for purposes of the record, if Mr. Barkley has no objection, it may be beneficial for all parties to just engage video on that. But I'll defer to you, Mr. Barkley, your degree of comfort.
Sure. No, I'm if a small child walks in, it's not my fault. And I know you all have been here for a while, so I really appreciate it. I'll try to be fast because my wife might kill me if I don't.
Okay, hold on a second, Mr. Barkley. Hold on 1 second, and I apologize. Mr. Yes. Sparks, do we have to do the swearing in again?
No, sir. Unless I was stepping away for just a second, I believe he was sworn in. If that is a question of the record, you don't hurt nothing. But I think he did acknowledge the oath.
He did.
If I'm mistaken, though, I stand corrected.
Okay. Okay, Mr. Barkley, proceed. Thank you. I apologize.
No problem. My name's Clay Barkley, and I'm an attorney with Strobo Barkley PLLC. I grew up in Frankfort, Kentucky, on 3rd Street. Went to Frankfort High. I now live in Anchorage, Kentucky, outside of Louisville, and I represent clients who are neighbors adjacent to 690 Duncan Road. So what I'm going to do today is try to give you all some legal analysis or tools that will help you all in making this decision tonight. I know that you've heard a lot regarding KRS 100-213. There are basically 3 prongs of it. You can meet any of the 3 prongs in order to obtain a zone map amendment under Kentucky law. 1 is you can be consistent with the comp plan. 2 is the existing land use is inappropriate, the proposed land use is appropriate. And 3, which is not contested, is that there were major changes of an economic, physical, or social nature within the area involved, which weren't anticipated in the adopted comp plan. So we've heard a lot of information about surveys and transportation plans, and I'm basically going to rely on the record today for purposes of that. We've submitted comments. Envision Franklin County has submitted comments, and we have incorporated those. So I'll rely on those. I want to focus on the future land use map, because the future land use map is what the attorneys for this developer and people who are in favor of it rely on. They say that future land use map is employment center. It was done in 2001, and everything flows from there. Mr. Romp, I think, described it as a puzzle. From that puzzle, we basically get the ability to rezone this industrial. Well, I would submit to you that you need to consider relevant law. And the Lexington Frankfort Scenic Corridor versus Franklin County Fiscal Court case, which is a Court of Appeals case, which involved the Hayes property, or forgive me, the Hay property, which is 50 acres, really across the street, 60 from this. And in that decision, the court cites the Supreme Court cases, and they find basically, here's how you analyze a future land use map when doing a zone map amendment. It states, I want to be clear about this, a zoning agency, as the fiscal court is a zoning agency here, is not bound to follow every detail of a land use plan. They are not bound. And this is the fiscal court who provided this analysis in 2003. And it is related to this exact same future land use map that you all are considering today. They also say the plan is simply a basic scheme and continually subject to modification. It serves as a guide rather than a straitjacket. It's simply a guide. You don't have to follow it completely. Further, and this is important, the land use plan element or land use map is not the only portion of the comprehensive plan to be consulted. You have to consult the rest of the comp plan. And that is, we've talked about that, how do you weight the considerations in the comp plan? So you look at the land use map, you look at other things, but you are not bound by the land use map. The complete comprehensive plan must be considered as the testimony of the, as well as the testimony of zoning staff and other qualified individuals. So I would tell you basically that what we've heard is that because it's employment center on the land use map, then from that flows this idea that we have to have industrial, even though employment centers include commercial, they include other uses. And that's just not true. Frankly, what you have to do, your job is to, first prong of KRS 100-213 is, does the application, is it consistent with the comp plan? And it's not. And it's not for a number of reasons that have been outlined today. It's inconsistent with Goal 2, Policy 5, which says encourage the preservation of existing farms and rural lands outside of existing and planned urban areas. It's inconsistent with Goal 4, Policy 5, emphasize tourism, including heritage-related tourism, as an important economic development asset in the community, including the Kentucky River and its tributaries. It's inconsistent with Goal 7, Policy 4, preserve rural character where appropriate. In particular, I think all this body needs to do to make a determination that this application is inconsistent with the comp plan is to look at the general development guidelines for industrial uses in the comprehensive plans, in the comp plan, which states new industrial development should be placed in areas where there is a minimal impact on residential uses and the natural environment. There's no way for this developer to show that there's a minimal impact on the residential uses. There's an entire neighborhood that's adjacent to this property. So the whole purpose of zoning, as you all likely know, Euclidean zoning that came about in the 1920s, is to protect people who are residential, people who have homes, from industrial uses, from fumes, from all kinds of nasty stuff. And there's going to be nasty stuff coming from here to this place. This is not warehouse. Industrial general zoning in Franklin County allows for heavy manufacturing. It allows for heavy manufacturing. And that's simply inconsistent with being right next door to my clients and other neighbors. So I really think that is really all you need to do. Another area of law that's relevant is whether or not what this body has the right to do. So under KRS 100-211, you, the fiscal court, have the final authority over zone changes. You can consider the recommendation of the planning commission. So you're kind of wearing two hats. I think the attorney for the developer got it wrong. This is not really a de novo case. You both can consider the recommendation of the Planning Commission and reject it. But also you're doing an evidentiary hearing and you can make your own decision. In order to reject the Planning Commission's recommendation, you could do it by a resolution. However, you cannot simply do it by a resolution to make new findings of fact, to basically do it in another way. So I would recommend that you have those findings of fact. And we have provided those findings of fact in our basically 6 pages of them to you that should be in your packet. And I went through a few of them, but there's 6 pages, so you can choose the ones that you think are relevant. So basically, this is a fundamental case of an incompatible use. We have an industrial use. It doesn't matter that the existing industrial park is already there. It's not your job to decide which property to buy for Mr. Tierney or others. The bottom line is that this is an incompatible use and it cannot be located here. You cannot do industrial this close to residential under Franklin County zoning ordinance and its comp plan. Essentially, this property is function as a buffer, and so it should continue to basically protect those residents who were there a long time before the industrial park came there. So I want to address a few other issues, but I want to do it quickly. So basically, I talked about what your authority is under KRS 100. Also, I mean, the basic job of zoning is to protect public health and safety. The developer's attorney basically said, we don't have to worry about the few. I would disagree. I think that the few is exactly who you all should also represent. That's who you are elected to represent, and that's simply your job. There's no exception for economic development activity. So just simply because this developer is, doing things which arguably are beneficial to the community does not mean that he gets a pass on following the law. I'll try to be quick, but I think I should have more time. And frankly, I'm going to have to object if you don't, if I'm going to be cut off in 2 minutes, because I think their attorney was provided about an hour and a half. I'm happy to be cut off, but I think that's an error. So there are 212 square miles in Franklin County. There's 135,000 acres. And so it's not, it's the job of basically this developer to decide what property to buy. If that property is incompatible, that's just the way it is. And he cannot then violate the law in a number of ways in order to, allow this development to go forward. This property could be used as residential. It could be used for more dense residential, but it's not being used for more dense residential. It's being used for industrial. Industrial is the absolute highest use, intensity use under the Franklin County zoning code and comp plan. And ag is the lowest use. He's going from the lowest use to the absolute highest use. He's not moving to residential or commercial. He's going all the way to industrial. And that difference is simply incompatible, I would argue. So, regardless,
Mr. Barkley, I'm sorry, your time is up.
Well, I do have one thing. I think I should be able to provide something of record, which is that my law firm did provide findings of fact and did receive a return receipt from Mr. Hewitt, which I don't know if it's in the record, but I think I should at least be able to state, what he said, which is that please accept the message as receipt of the findings of fact attached in the email you sent on January 30th, 2020. And so okay. I think that's in the record.
That's in the record. Thank you. Okay. Mad Squires, do you have any questions for Mr. Barkley? Mr. Hewitt, do you have any questions for Mr. Barkley?
No, sir.
Mr. Rump, do you have any questions for Mr. Barkley? Mr. Barkley, thank you. we're sorry you live in Anchorage. You can come back to Frankfurt. It's a good place to live.
I will. I need better neighbors.
Thank you, sir.
Your Honor, Judge, can I ask Mr. Barkley one quick question regarding the proposed findings of fact?
Mr. Barkley?
Yes, sir.
Mr. Barkley, this is Rick Sparks, the county attorney. Did you forward, and I know you said you did it back in January for that matter before the commission. Have you presented those? And I'd also like to thank you for keeping it grounded, much as I've tried to do as well. Have you presented those to the fiscal court for this round?
Rick, Mr. Sparks, I have, and they're in the Google Drive doc, which says Strobo, and I think it's about 42 pages, and they're maybe the 37th through 42nd pages of that document.
Okay, I knew that. Okay, that was my only question. Thank you very much, sir, and appreciate your time.
All right, thank you. Andrew, next.
Natalie Wilkerson is coming in.
Natalie Wilkerson, okay.
Yes. Miss Wilkerson, you're joining us. If you want to turn your mic on, turn your camera on if you can. Miss Wilkerson, can you hear me? Natalie?
Yeah, I can hear you all. Can you all hear me?
I've got you now. Can you? Yeah, there you go. Thank you.
There you are. Okay. Would you please state your name?
Natalie Wilkerson.
Okay. And would you raise your right hand to be sworn in?
Do you promise to tell the truth, the whole truth, and nothing but the truth? Thank you.
Yes,
Thank you.
Yes, I do, and I hear you. Can you hear me?
We hear you. Thank you. Welcome. Welcome. Sorry. Can you hear us?
Yeah, but there's something in the background. Hang on. Maybe I ought to turn.
If you have the Facebook stream going, you're going to need to turn that off. Yeah. We have you loud and clear, though.
Gotcha. I'm here. Okay. Hi, good evening. My name is Natalie Wilkerson, and I'm here before you today as the president of the Franklin County Trust for Historic Preservation. The Franklin County Trust opposes this zone change, and I'm here today to ask for your protection of this rural landscape. Franklin County's agricultural and landscape features are vital not only to the scenic and ecological health of the bluegrass, but also its potential for healthy economic development. This farm is located on a state-recognized scenic byway. It buffers the adjacent farms and neighborhoods, and importantly, is a popular route connecting our city of Frankfurt on the Bourbon Trail. The Trust's role in this community is often focused on advocating for the protection and revitalization of the built environment, as we recognize that in the promotion of Frankfurt and Franklin County, unique places create value. Without this sense of place, Frankfurt and Franklin County could easily transform into, say, Industrial Park, USA. The entire acreage of the Blanton-Crutcher Farm was listed on the National Register of Historic Places in 1975. Although the historic farmhouse has been demolished, the agricultural fields that comprise the farm are also noted as significant in the National Register. The agricultural lands, their contribution to the scenic landscape adds value to Franklin County residents and visitors alike. Let's remind ourselves again that this property is bordered to the south and east by rural residential and agricultural properties. It's at the head of the watershed for the Slickaway Branch and is in the backyard of Kentucky's trademark bluegrass region of horse farms and distilleries. As has been pointed out, the 2016 update of the comprehensive plan marks this property for future employment center. Though we believe this designation is inappropriate and misguided, particularly considering that a portion of the property lies within Woodford County, and it has been identified as a buffer farm to the neighborhood residences in the past. However, I'm not here to argue that this property stay agricultural in perpetuity, nor does the Trust expect this owner or any owner to reverse the clock and give our community back what it lost. The comprehensive plan encourages the employment use category to aid in diversifying the economic base of our county while blending in with residential commercial areas. I quote that. The plan goes further to encourage in this use, quoting again, the development of high-tech industries. This application does neither. This particular zone change application shows blatant disregard for the comprehensive plan's principles, calling for the preservation of historic sites, enhancement of agricultural lands, protection of natural features, and the prevention of sprawl and the buffering of neighborhoods. Further, it is the practices of this particular applicant that have attracted the ire of its neighbors, neighboring communities, and an investigation from the Kentucky Energy and Environmental Cabinet. To be clear, again, this is not to say that any zone change at this site would be so contradictory to the principles of the comprehensive plan while fulfilling the potential land use of employment center. Again, it is this particular zone change application that is inappropriate and must be denied. Again, looking at KRS 100.123 or whatever it was, you all are tasked with finding in this zone change amendment to amend the zone change map that something significant, that a significant change has occurred in the economic, physical, social, climate of the county. And I would argue here that we have had two major changes that have diversified Franklin County's economy for the better since the comprehensive plan update in 2016. And that is the development and reopening of Castle and Key Distillery just south of this property, and in northern Franklin County, West 6 Farm, which is highly increased tourism and visitors, as Mr. Connors pointed out, in our county, and is the kind of positive development that Franklin County needs, and we believe many citizens have said to you that they want. West 6 Farm in northern Franklin County and nearby event venues like Heartland and Versailles are successful projects that have adapted their rural property for economic benefit. Adaptive reuse is a pillar of revitalization, and it is important to economic development everywhere. In this pivotal location on Duncan Road, with nearby horse farms, distilleries, wineries, and adjacent residential development, it is your duty to ask for more from an applicant and to see that an adaptive reuse of this property successfully creates jobs and development while celebrating Kentucky's history, culture, and landscape features. Again, we ask that you deny this zone change application. Failure to do so gives implicit permission for unpermitted destructive practices to continue in the future anywhere in our county and wrecks the identity of our community. Thank you.
Thank you. Squires, are there questions for Ms. Wilkerson? Mr. Hewitt, do you have a question for Ms. Wilkerson?
No, sir.
Mr. Rump, do you have a question for Ms. Wilkerson?
No, sir.
Ms. Wilkerson, thank you very much for your statement tonight. We appreciate you being here, and bless you for staying on for so long. Thank you very much.
I appreciate you all.
Thank you. Mr. Hewitt, next speaker. I mean, Mr. Tippett, sorry.
Yes, sir.
It's been a long night. It's been a long night, Mr. Tippett.
Yes, sir. Roger Crittenden, Judge Crittenden.
Oh my goodness, I remember way back before 5 o'clock he was on there.
Yeah. Yes. Still waiting. Let's see.
Turn his phone over.
You got to turn his. Judge, we're gonna have to look at you like this, so we appreciate it.
I have to turn it around.
There you go. You're looking good now, Judge. It's been a long night. Welcome.
I know it has.
Okay.
I've been able to have dinner. Thank you.
Would you please state your name? State your name.
My name is Roger Crittenden.
Okay.
Do you promise to tell the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you.
Thank you.
Welcome, Judge.
My name is. Thank you, Judge and members of the Fiscal Court. My name is Roger Crittenden. I live at 305 Stonehenge, and I am in the Slickway watershed. I'm at the mouth, I guess the mouth. I'm close to where it empties into the Elkhorn. So I get everything that comes from up above. And frankly, my opinion is that the Fiscal Court shouldn't grant any zoning change or approve any construction in the Slickway watershed until all the problems are corrected. And I know you're not to blame for the problems in the past, but the fact of the matter is every time it rains now, we get a lot more water than we did even 5 years ago. We've had 3 major flood events since 2015 that have blocked the access to 2 creeks at one time or another. But basically, that is my position, and that is what I want to communicate to you, Judge, and to the members of the Fiscal Court. I will say I don't know Mr. Tierney. Mr. Rumpf and I are law school classmates. So we've known each other for longer than either one of us will care to admit.
Okay.
All right.
All right. Are there, Squires, are there
If
any
anyone has any
questions for
questions,
Judge?
I'll be glad to answer any questions. But that's just you and I have talked, and I've talked with Mr. Hewitt. We've been in meetings involving the problems with Slickway, and you're aware of them. And I think and maybe the Kentucky Industrial Development Authority can come through with some money to help fix this problem if it's so beneficial to industry.
Are there any questions for Judge Crittenden from the Squires? Squire Moore?
Yes, Your Honor. Why would you leave Logan Street for a cesspool like Two Creeks?
You know, that's a question I wonder every once in a while after been there for 39 years. I needed to downsize to a house on one level. Let's put it that way.
Okay.
Are there any other questions for Judge Crittenden?
Your Honor, I'd just like to say, Judge Crittenden, it's a pleasure to have you in my court for a change. So thank you for hanging
Mr.
out.
Sparks.
My apologies.
Thank you, Rick.
Mr. Hewitt, do you have any questions from Judge Crittenden?
No, sir. Thank you for your patience.
Mr. Rumpf, I'm sure you would like to say something to Judge Crittenden.
I would absolutely like to say something to him.
There you go.
I think he and I both learned the same thing in law school, that you never ask a witness that you don't know his answer to the question. That's the first thing.
Right.
Having practiced before Judge Crittenden, I know he recognizes that cardinal rule. So I hesitate to ask any question, but I think you probably have endured the whole hearing, and you heard the engineer talk about the stormwater management on this property. I think Mr. Tierney is committed to reduce the runnage off of this property by more than, not only his runoff, but by more than 20%, and that may by up to 20%. So that may aid this problem rather than hurt it. But it sounds to me like your watershed is a whole lot larger than the one that we're dealing with here. It's probably got the cold store over there in it, and it's got a lot of other development in it as well. So, but I appreciate your comments.
Thank you, John.
There's no
Good to
question
see you.
there, by the way.
Thank you.
Squire Blackburn, you have a question for Mr. Rumpf?
I just wanted to thank him for, no, I had a question for Mr. Crittenden. I want to thank him in a statement. Tell him thank you for coming on tonight and waiting. And this zone change is requested in the 2nd district. You live in the 2nd district. This is a big issue for us. So I appreciate you coming on tonight and speaking.
Okay, thank you. Thank you, Squire.
Okay, here, seeing no other questions, Judge Crittenden, thank you. Bless you for staying on for so long of time. We appreciate you, sir. Thank you for your service.
Thank you, Judge. Good to talk to you.
Yes, sir. Okay. Now, do I have a motion? Is there someone else?
We still have more people to go, sir.
Okay, I'm sorry. I thought I was told that was the end. Okay.
No, sir. I'm sorry. We've got at least 3 more people.
Three more people? Well, welcome.
Yes, sir. We have Connie Lindley.
Okay.
And if you want to turn off your microphone, if you can turn on your camera, that'd be great.
There she is. We see her. Hi, Miss Lindley. Welcome.
Hello.
Lindley. Can you please state your name?
My name is Connie Lemley. I live and farm at 7134 Owenton Road.
Okay. Would you raise your right hand? Doesn't matter.
Do you promise to tell the truth, the whole truth, and nothing but the truth?
I do.
Thank you. You may begin.
Okay. Thank you for taking the time to hold this hearing. As many have noted, there is a lot in the comprehensive plan. I served on the 2010 Comp Plan Update Committee and spent many hours thinking about and working on the goals and policies and other narrative sections of the plan. However, neither the Comp Plan Update Committee nor the Fiscal Court had the opportunity to directly develop the future land use map that seems to be the only portion of the comprehensive plan that many folks look to when considering a zone change. I submit that the comp plan is much more than the future land use map, and that much of the vision for our community that was collaboratively crafted by the comp plan committee is lost if you distill the comp plan down to the future land use map. As Envision Franklin County and others have explained in comments submitted to you, there are many ways that the comprehensive plan does not support the proposed zone change. I ask you to reject the request for a zone change on these grounds. The existing agricultural zoning classification is appropriate and best matches our community's vision for land use as described in the comprehensive plan. As you drive out Duncan Road and round the bend at 690 Duncan Road, you know that you're entering one of the most beautiful rural areas in this region. The distinction there between town and country is really clear. The comprehensive plan also emphasizes the need for infill development before allowing new development to sprawl onto our community's farmland. We have been reminded in recent months of how essential the resilience of our local community and food supply are, and that only underscores the need for infill development. We can build new industries, create new jobs, protect our natural and cultural resources, and make our community a great place to live. Approving this zone change is not a step in that direction, however, and I ask you to reject the request. And just to offer a finding of fact or two, first one, the proposed zone change is not supported by the goals and policies of the comprehensive plan, specifically Goal 1, Goal 2, Policies 1, 2, 3, 4, 5, and 8, Goal 4, Policy 5, Goal 5, Policy 1, Goal 6, Policy 5, Goal 7, Policy 4. And that's not an exhaustive list, but those are ones that specifically called out to me as I was revisiting the stuff that we worked on for 5 years. Also, second finding of fact, based on the goals and policies of the comprehensive plan, the existing agricultural zoning classification is the most appropriate zoning for this parcel. So thank you.
All right, thank you. Squires, do you have a question for Ms. Limley? Squire Muller.
Hey, Connie, how you doing tonight?
Hi.
So question, so you said in 2010 you worked on the comprehensive plan for 5 years, correct?
Yeah, I think we started in 2005, 2006.
Okay.
And it was approved in 2010, I believe.
Okay, so was the future land use map part of that, or was it completely separate from what you worked on?
My memory is that we started with working on the goals and policies, and that the goals and policies was the only portion of the comprehensive plan that had to be approved by the fiscal court. And so that was approved. And then there were various committees that worked on the different narrative sections of the comprehensive plan. But there was never a time that a big group of people, and it's a little hard to imagine how that would happen, sat down and started coloring in the future land use map. You also have to remember that even though it was an extensive update, what we did at that time was just an update of the 2001 comprehensive plan.
Okay, thank you. And then Mr. Hewitt said, I guess 2016 was the next one. Do you remember being involved in that at all, or were you done by then?
That was a much more limited update of the comprehensive plan, and I was not on that committee. And it was just much more limited, and I think there was far less community participation in that one.
Okay, thank you.
Any other questions from the squires? Squire Booth?
Unmuting. I remember the 2010, the preparations for it, and anybody that wants to participate in that is really signing on for a lot of meeting. And I think that people that did participate in the planning were really looking or had a good idea of the future of Franklin County. And I don't think that the future land use plan was discussed at all. I didn't go to all the meetings, but I went to quite a few. And there was a lot of discussion, a lot of, but there was no future land use, even though we had an idea where we wanted the county to go. There was no plan for it. I'll just put that forward. That's all.
Are there any other questions for Ms. Limley?
Judge, just Rick, just briefly.
Yes, sir.
Ma'am, did you provide any written comments where you would have attached those findings of fact that you've discussed, similar to the question that I asked the gentleman a bit ago?
I did provide written comments, but during the last 5 hours, my spoken comments evolved and I developed these findings of fact. So no, they were my written comments are different than what I shared with you. They are complementary, I was just, but different.
I understand as the discussion went on that likewise, ma'am. I just wondered if you had attached that with your previous written comments. Thank you, ma'am. Thank you, Judge.
Okay. Okay. Mr. Hewitt, do you have any questions of Ms. Limley?
No, sir.
Mr. Rump, do you have any questions? What did you say? I'm sorry. No. Ms. Limley, thank you very much. Thank you for staying on so long. We appreciate it. Thank you for your comments.
Thank you.
Okay. Andrew, the next.
Susan Goddard. Miss Goddard is with us, it looks like.
Okay. Miss Goddard, welcome.
Thank you.
Would you please state your name and then raise your right hand?
My name is Susan Hall Goddard.
Okay.
Do you promise to tell the truth, the whole truth, and nothing but the truth?
I sure do.
Thank you.
Thank you. Welcome, Miss Goddard.
Thank you. My name is Susan Goddard, and I live on the Scenic Spring Farm at 1300 Duncan Road. Our farm spans both Franklin and Woodford County, and I pay taxes in both counties. I was born and raised in Franklin County, and I retired from the state from Franklin County. And I am a big supporter of local business, and that's where my tax revenues go, mostly is in Franklin County. I had planned on addressing you. First of all, Judge Wells and honorable magistrates, I thank you for calling this evidentiary hearing and affording us this opportunity. I really do appreciate it. I'd planned on addressing you all in person. However, my health was directly affected by the recent illegal fire that was set by the applicant. For approximately 3 hours, the wind carried the smoke toward my home, our farm, and the home of my son and his family during a time when we are under stay healthy at home orders from the governor. The noxious fumes has caused me breathing difficulties and has exacerbated my heart condition and actually sent me to the emergency room during a worldwide pandemic. And that was not a fun place to be. The fire made me even more vulnerable to COVID restrictions, according to my doctor, and therefore I must now address you via video conferencing instead. For the record, I and members of our neighborhood association, for which I'm a co-director, strongly oppose the 690 Duncan Road zone change. We ask that you vote to retain its agricultural zoning. Out of the ordinary actions in the rezoning public hearing process have brought us here today for you to examine the facts. For years, my neighbors and I lived near the industrial parks. For the most part, it's been peaceful. We were buffered by large, mature hardwood trees, large evergreens, and tall brush. It helped to buffer out the sounds and all the evening lights of the park. But all were removed from while the applicant was awaiting this hearing. We've been told by fiscal court staff that there are no protections that exist for adjoining neighbors for an industrial park for noise, light, and odor. This is in direct conflict with the comp plan, public comments, and fiscal court ordinances. Does everyone who applies for a zone change get approved? I would surely hope not. I trust that each case would be carefully considered. Whether or not the area is already overstressed, ours is. I would hope that you would look at the impact that it has on the citizens of the community. I would hope that you would look at existing problems in the area, such as flooding and traffic concerns, and you would assess any historical value. You would look at public safety and preserving the natural resources in the area. We strongly believe that the zoning map does not comply with the narratives in the comprehensive plan, nor does it accurately depict the wishes of the general public. Throughout the years, I have attended and participated in several comp plan update meetings, and I heard comments for preservation of history and natural resources firsthand. I was at the 2000 and the 2010 comp plan meetings. This development has drastically changed the landscape. It has destroyed a beloved historic property with direct ties to the booming bourbon industry. It has affected our health, our properties, and our daily lives, and our quality of life. Residents and tourists at times are trapped on either side of the road due to high water or totally closed road due to water. So we're either waiting for the waters to recede so we can get home, or waiting for the waters to recede so we can get out. It concerns me also that a quasi-government entity such as KCDC, paid for with tax dollars, would recruit general industrial for this property instead of agribusiness, especially for this particular farm. I think that lacks insight. It also sets a very dangerous precedent for business practices. It goes against historic preservation. It is not smart growth. My family maintains and uses organic techniques on our farm for future farming ventures and to protect our valuable resources. An industrial development right alongside us threatens our farm, our water, and any of those future plans and our property values, as their stormwater crosses in 3 places across our farm. Neighbors directly across from this project will have only a 2-lane road that's going to separate them from huge warehouses with no buffers for lights, sounds, or odors. Several inaccuracies within the Planning Commission's finding of facts do exist and need to be recognized and corrected. We have updated we sent in our finding of facts to reflect these. And one of them talks about how that Mr. Tierney has complied with everything within the comp plans and has gone with every rule and regulation, when in reality, several required permits were never obtained and a stop work order was never issued. On the land disturbance permit, Mr. Tierney said that he was going to disturb less than 1 acre of land. He even testified to that at the Planning Commission under oath. I have his application right here. However, that very same day, the State Journal came to fly a drone over to see how much acreage, and it's approximately 10 acres at that point that he had disturbed. Slickaway Branch and Glens Creek are already having additional flooding for this overstressed area due to the stormwater runoff. And we ask that no more development happen until the current flooding problems are rectified. And one question we have is, how can someone who has applied for a zone change to industrial, which, by the way, Mr. Tierney said that tonight under oath, that he applied for the zone change in January of this year. However, I have a copy of his application where on July the 29th in 2019, he applied for the zone change for the map amendment for the September 12th, 2019 meeting. So I just thought I'd bring that one up. Also, I wanted to point out that my farm is labeled incorrect on that map that he had brought up, Mr. Hewitt had brought up. It talks about how that there's supposed to be a zoning for industrial and employment center is part of the sliver of my farm. My farm is completely agricultural in both Woodford and Franklin counties, and that's what I pay on my tax base. So I wanted to point that out. Also, Squire Booth's comments were very on track when she talked about him being whether or not he was a good steward of the land. I pointed that out at the Planning Commission meeting because we did not think he was a good steward of the land. And I was told that that was not pertinent or relative to a zone change. I was also told that the county line, which at the time had gone through technical committee twice, was also not relative or pertinent to a zone change. And on the finding of facts, I would never have known that our finding of facts document for our entire association was not included had a State Journal reporter contacted me right before the meeting and asked me, did you all submit your finding of facts? To which I said, yes. And she said, well, I did an open records request and yours was not among them. And I said, well, I did. She said, did you do it on time? Yes, I did. So I actually have, Clay Barkley spoke and said, yes, we did get it, and we did. And not only did Mr. Hewitt say that he had received it, he also, the e-copy, he also said he received the hard copy, was delivered to my office, and I will distribute the document to the Planning Commission. However, it was not. I would like to know if the current industrial zoning before us is correct. The farm's 103 acres, as well as the mansion house, was listed on the National Register. It still has 2 barns, one with a silo, and a small lake and a wetland still exist. It had been a pre-Civil War working farm. It grew hemp. Graves are there. Historic artifacts can still be unearthed. KCDC's Terry Bradshaw had previously stated that they needed 100 acres of land to meet the industrial needs of this county, to build large industrial warehouses and other buildings because there aren't any available. However, while requesting that same acreage for rezoning of Duncan Road, I found that Mr. Tierney had asked for a request in February and had gone through planning and zoning to actually downsize one of their industrial lots, a big industrial lot in Industrial Park 3, to put 4 small buildings on it. When right down the road at Bizac property and Mill Creek Park, there are building lots available for those size properties. I don't understand. It seems like, you know, why downsize lots that are desperately needed for future industrial? They did. I also, along with Chris, had found the survey article from the State Journal dated June the 27th, 1999. It was a survey that was conducted by the Commonwealth Credit Union and the State Journal, in which they did a survey and they said, Franklin County residents want their community to grow, but without sacrificing the environment or historical character of the area.
Thank you for your comments, Ms. Goddard. Thank you very much. Are there any questions for Ms. Goddard from the Squires? Squire Booth.
Yes, Mrs. Goddard. Susan,
Yes.
Are you?
Pardon?
Oh, are you and your husband planning to sell and move?
No, ma'am. My father and mother bought this farm years ago, about 35 years ago, and we built our own house. My husband and I actually built it with our own hands.
Oh.
We didn't hire, we didn't have a regular builder. We built it with our own hands, and we had a lot of payback because we had a lot of friends helping us throughout the year. But no, when we gave a lot to our son, and he and his family have moved on there. I gave them the barn so that we could continue our farming operations.
Wow. Well, I commend you. I called your son a citizen. I call you a citizen.
Thank you.
Squire Blackburn.
Yes. Yes, Susan. Thanks for coming out tonight. And
I can't hear you. Are you muted?
Can you hear me? Can you hear me now?
No, I can't hear you.
Unmute.
I've done that twice already. Can you hear me now?
Yes, I can. Thank you.
Wonderful. Thank you. I'm real confused, Ms. Goddard. You said that you had submitted your findings of fact, and that was attested to. I spoke with Robert Hewitt. I asked him a question earlier, and Robert, you might listen in on this. I'd asked you a question earlier, and you submitted an answer under oath that you did not reply to Mr. Strobo when they submitted their findings of facts. I know it's been a long time, but did you reply to the Homeowners Association lawyer after they submitted their findings of fact electronically and a paper copy?
Sir, your question before was, did I email them the next day? My response was no.
Okay.
Yes, it was the next day. Yes, sir.
Let me pull it up, Mr. Hewitt. I have it with me.
No, if I respond to them about it being, you referred to it being late.
Okay.
Now let me just finish my question here. Okay, they sent June. Okay, yeah, I think it was the next day. It said that you had received it, the hard copy delivered to your office. You will distribute the document to the Planning Commission. So my question is, after telling them that you would distribute it to them, why did you change your mind after telling them that you would do something?
Because it came in after my office had closed, and I received many other comments, namely the Chamber of Commerce. And if I was not going to accept anyone else that came in late, I was not going to accept that association's letter came in late. I had not had an opportunity to consult with the Planning Commission's attorney to address the question. And the question by Ms. Goddard was brought up at the February hearing before staff was even asked if I had anything else to enter into the record. So I was not given an opportunity before Ms. Goddard interrupted the hearing just after the roll call.
But later on, the Planning Commission approved that the document be.
Yeah, the document was entered into the record. Regardless,
I mean, let's not argue about that because it ultimately was entered into the record.
Well, it ultimately was not given due process, Judge, respectfully. 9 days before the hearing, you said you would show it to them, and you did not. You knew the day you replied to this that it was after the timeline that you had set, and you still said you would give it to them. I'm just confused.
On the 13th, as it is to June the 9th.
Okay. Mr. Sparks, can you intervene on this?
Yes, hello, Ms. Goddard, and thank you for your patience in this extremely exciting and robust discussion.
Thank you, Mr.
I appreciate it more than you know. I guess to get over the hump and move forward, have you submitted, along with any public comments, your proposed findings of fact in this matter now today?
Yes, sir.
Okay, so that we can just check that off the problem list and then go forward and save other people to look back if they choose to do so. But it is of record and it's available for members of the court to consider now. Is that right, ma'am?
It is, and we also submitted my letter of objection that was dated August. We did our I had a letter of objection to the project that was also not submitted to the commission for the January meeting.
But as it relates to our hearing here tonight, those are presented for this hearing. Is that correct?
They are presented for this hearing, but
okay.
Had the reporter not asked me, that is the reason when Mr. Hewitt said that I interrupted the commission 3 times, it was to ask them, do you have before you our commission's finding of facts? And they finally responded that they did not. They asked Mr. Hewitt what they were talking about. And at first Mr. Hewitt said, I don't know. And then that's when I got up and walked over to Mr. Hewitt and Mr. Logan, and I handed Mr. Hewitt a read receipt, and the document. So,
okay, Ms. Goddard, and I appreciate that, but this is June the 9th. This is a public hearing, an evidentiary hearing. And so we're dealing with June the 9th, and it is on record. And so we're good to go with that. The court has plenty of time to review that. Are there any other questions?
Thank you, Judge. Thank you, Ms. Goddard.
Thank you.
Squire Muller.
Thank you, Judge. Thank you, Mrs. Goddard. I know it's late. Can you go? I want to date check something. You went back, and I've been taking notes all night. You had said that the applicant filled a zoning application July 29th. Was that correct?
Yes, sir. It's July the 29th, 2019, application for zone map amendment for the meeting date of September 12th, 2019. There it is right there.
That's interesting because he told me earlier under oath it was January 9th. So,
yes, sir, he did.
Okay, thank you for clarification.
Thank you.
Okay, you'll be able to ask that question to Mr. Rump in just a second, Squire Muller. Are there any other questions for Ms. Goddard from the Squires? Seeing none, Mr. Hewitt. Mr. Hewitt, do you have a question?
I do. Ms. Goddard, you said tonight that the zoning map of your portion of property within Franklin County was identified incorrectly. Is that true?
Yes, sir. It should be agricultural.
Mr. Tippett, would you put on the screen staff exhibit number 8, please?
Give me just a second. I'm going to have to. track that down. Okay, here you go, Mr. Hewitt.
Ms. Goddard, do you see the property outlined in teal that says subject property 690 Duncan Road?
Yes, but let's see.
AG within that polygon?
Okay, I do see AG, yes.
So
there was another, okay, I'm sorry. There was another map that you had showed. It wasn't that map. There was another map that I looked at that you had showed, and it said that it was already zoned in the proposed map, like the land use map, that it was proposed that way. That was the one that I had objection to. It was not that one. There was another one that you had done. But I will say that this was the zone map that was handed out at one of the meetings that I have. And it was also, mine was listed for my Woodford County property and my Franklin County property to be in the employment center usage. And that was incorrect. And so I was scared that that map, since it was one of the earliest maps, that it had continued to, I guess, the incorrect information be passed on to the next map.
And then one last question, Judge, if you don't mind.
Yes, sir.
Okay. Would you mind holding that zone map amendment application back up again from July, please?
This one? Can you see it?
Yes, ma'am.
This was what I received from your office when I went down to get the information for the public information for the hearing.
Yes, on the
and
second.
You all had actually postponed that hearing, and it was for a later date. But I did get this information actually through open records request, I believe.
On the second. On the second page.
Go, keep
going. On the
going.
second page of that application, item number 11, what does it show the property acreage as?
95.53 acres.
Yeah. So
that's the one we withdrew.
Yeah, that was the one that was withdrawn. Court, that application was withdrawn because it was not a stamped survey of the property. So the application you have in your report has my handwriting at the bottom of the page that states this application reflects land area in Franklin County only, and it got cut off, and then you see my signature. So that's why she has another application in her possession.
But that was withdrawn.
That was withdrawn and a new application filed, correct?
Okay.
January 9th.
On January 9th. Okay.
Correct.
But still, he first filed for a zone map amendment on July the 29th, 2019. So.
But he withdrew that.
Correct.
So Squire Muller, that was your question. Did you get your question answered?
Well, I did, but I think to Mrs. Goddard's point, he knew then that he wanted to change the zone, but then for the next 6 months, he did all the demolition under the agriculture clause. That's why I have a little problem here.
Okay. Do you have any other questions?
No, sir.
Okay. Mr. Rump, Mr. Muller, you want to ask your question to Mr. Rump, please?
Sir, I mean, he's heard what I said. If he would like to say something, that'd be fine.
Well, I don't think you asked a question. You said you had some concerns. I'm not sure.
Okay. Well, I guess my concern is when we started the meeting, he stated that he bought the property on July 19th, 2019, and that for the next 6 months, a farmer was getting hay and things off the property. So they were treating the farm as agriculture. And he didn't submit his zoning change till January 9th. But now I'm learning that July 29th, he had every intention to get a zone change, but basically spent 6 months working under the agriculture kind of, whatever you want to call it. I'm tired. I don't know. You know what I'm saying.
He actually began bulldozing on July the 17th and 18th. That's when he filled in the pond. That's when he filled in the pond. And I have video record of it.
Okay, Ms. Goddard, it's there.
Just to clarify, Mr. Tierney bought this property with the intention of developing it for industrial use. He began working on the property. It was a farm. It had a farm gate. It had actually had a tenant farmer with hay on the property. So he began doing various work on the farm, and you know, it may be a farm, who knows? And the work he's done on the property is just as useful for a farm as it is for industrial use thus far. So he's not beginning any grading work or anything of that nature. He didn't intend to occupy the house. He saw the house as a risk. So yes, he did do things, and you could say he took advantage of agricultural exemptions that, you know, the regulations. I think the evidence was at the previous hearing he didn't violate any regulation. Now he did some things have happened since the previous hearing that he, you know, was cited for, and he's going to work on. So he's ready, I guess is what I'm saying. So that's, I mean, absolutely. And he, I think he recognized when he bought the property that he wasn't going to flip a light switch and it was going to be industrial. He knew that. And, you know, it's a long process. You heard his engineer talk. All those studies and everything had to be done before he can come back with a development plan. It'll be a while. If you approve this rezoning, it's going to be a while before he's able to do site work on the property and get it developed. I don't know how long it took to develop Industrial Park number 3, but he recognizes he's in for the long haul.
Mr. Rolfe, why then under oath at the January meeting, when I asked him, did you apply for a land disturbance permit? And he said yes. And I said, did you apply for less than 1 acre? And he said yes. And I said, does that still apply? And he said, yes, I have disturbed less than 1 acre, when in fact he had not.
His engineer applied.
There were witnesses and photos to the opposite. So,
okay, Mr. Rumpf, do you have questions for Miss Goddard?
No, I do not.
Okay, all right, Miss Goddard, thank you for your testimony. We appreciate it. Thank you for being on here for a long time.
Can I ask you one more question? Judge James Kay from Woodford County had submitted a letter, and he asked that it could be read into the record. Does someone there plan to do that, or
no,
am I allowed to do that?
No, we will. We're going to take all documents in just a second and submit them as part of the record.
Okay, it was his objection to the.
I got his letter too.
Okay, I just want to make sure you got his objection to the zoning. Thank you.
I got it. Thank you very much. We appreciate you. Thank you.
Appreciate it. Thank you, Squires.
Andrew, the next person, please.
Will Arvin.
Okay, Will Arvin.
Will
Arvin, he's still joining us. Hold on just a second.
Will Arvin?
Hold on, he's still joining us, Judge.
Okay.
Mr. Arvin?
Yes, that's me.
Yes, sir. You can, if you want, you can unmute, and if you can turn your camera on, you're allowed to do that. And we're getting ready to get you started, Judge.
Okay.
Hang on 1 second. Are you going to do your camera?
I'm just going to do audio if that's okay.
Okay. Mr. Arvin, state your name and then raise your right hand.
Will Arvin.
Do you promise to tell the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Thank you. Go ahead, Mr. Arvin.
Thank you, Judge. Thank you, magistrates. What a long night for you all.
You too.
I submitted a letter to you to the court today. I'd like to make sure that's entered into the record, and if the court pleases, I'm happy to read it into the record.
We will take your document if you would prefer to. If you want to make that just your speech, that's fine. But if you've got more things to say, don't use your time up by reading that, because we're going to accept that as part of into the record. But it's
okay.
Up to you.
No, I'll stand on the letter as submitted in the record, and just also will add that one of the central points or theses in my letter is the flooding issue and what this potential zone change and resulting construction would mean to the potential for our property to flood downstream. And as I pointed out in the letter, we've had a flood, and the flood didn't come from the creek. The flood came from the spillways through the valley and flooded our entire property. And this will only exacerbate that, or this kind of construction will only, we're concerned that that kind of construction will exacerbate the potential for flooding and future damage and danger to our business there.
Okay. Now, Mr. Arvin, state your business for the record, if you don't mind, please, sir.
Yes, sir. I am one of the owners of Castle and Key Distillery in Millville, down at the bottom of Duncan Street.
Okay. Otherwise known as Duncan Road.
Correct.
Okay. Do you need to say anything else, sir?
No, unless you'd prefer me for me to read the content or substance of my letter into the record. Otherwise, I'll stand on the letter as submitted.
Okay. We'll go that route if that's okay with you. Are there any questions for Mr. Arvin from the squires from the court? Any questions? Mr. Muller, Squire Muller.
Yes, thank you, sir. I'm just curious, have you had much conversations with James Kay about this issue in person?
I have.
Okay, so you agree with him as far as his stance on not accepting the zone change, I guess?
That's right. It's my understanding that he is also opposed to this as well. I don't want to speak for him, but that's my understanding.
Okay, thank you, sir. I appreciate it.
Yes, sir.
Anyone else? Squire Booth, did you say you want to say something or ask a question?
Yes. I want you to know that I wrote a speech when I got my last job that I retired from, and I used exacerbate in that speech, and nobody knew what I meant. So I'm impressed that you used it.
Thank you. I hope I used it correctly.
Yes, you did. You said it was exacerbate the whatever. Exacerbate the situation, make it worse.
Okay.
Yes, ma'am.
Squire Blackburn.
Mr. Arvin, can you hear me?
I can. Thank you.
It's I think we're 50-50 now on my mute button working. Anyway, I want to thank you for staying up tonight. I know you've got a really vested interest in this. I also want to ask, how do most people access your location at Castle and Key? Which road do they normally take to get there?
As far as I know, it's Duncan Road all the way. That's the one I've used for the past 6 years. It's the most direct route off the interstate, or if you're coming on 60 from Versailles Road. So I would say the majority, if not all, of our traffic that come to our distillery as tourists would use that corridor, that path.
Thank you so much, and thank you for your time.
Yes, sir.
Squire Tracy.
Thank you, Judge. Thank you, sir. Quick question. Castle and Keys is often talked about by Franklin County tourism. Have you reached out to them and talked to them about the effect that this could possibly have on your business?
No, I have not. But maybe I should.
Okay, thank you.
Squire Blackburn.
Not just tourism, but also the chamber. I know that would be another voice they could listen to.
Right, and I was on their website today, and I noticed that the picture of their website is of a distillery or a distillation process, and it struck me that they put that much importance on the distilleries in our area and our community, Franklin County, Frankfort, as part of the business infrastructure. And gosh, we sure do stand to be impacted by this zone change. And I would hope that they would align themselves with our business interests here, and as a chamber that promotes businesses and especially tourism for us, which is what makes us so unique and special. So hopefully they would support this effort.
Okay.
Thank you, sir.
Anyone else?
Judge, this Rick, just very briefly, if I may, Mr. Arvin.
Sure.
Just to clarify, and there was a number of witnesses previously that testified about residences, and of course, thank you for bringing that lovely distillery back to life. When you're talking about the flooding area, et cetera, you're referring to Castle and Key. You're not referring to a residence. Do you live in the area, or were you referring to the distillery proper?
I actually live in Jessamine County, but I commute every day. And the flood that occurred back 2 years ago, roughly, flooded the whole bottom. And again, the floodwaters came off of the mountain shed from atop Duncan Road and resulted in a flood event that caused us in excess of $1 million worth of damage. And we're concerned very much about that whole flooding problem for this basin. And if we have another flood like what we had 2 years ago, it would be devastating to us.
Okay, the reason I ask is so far, if my tally's correct, you're the first witness from a commercial or business enterprise that discussed the flooding. The other witness, pardon me, there was one other one. I just wanted the squires and the court to be able to distinguish, because there have been some testimony about residences, et cetera, so they can keep everything on the same page. And again, thank you, sir. Appreciate it.
Sure.
Mr. Hewitt.
No question, sir.
Mr. Rump.
Mr. Arvin, have you, after you had this flood and suffered this damage, have you done any analysis of, hired an engineer or anything to look into the cause and the possible remedies for that to protect your property?
Have we hired a professional engineer? Not yet.
Please?
We have not hired a professional engineer on that issue as of yet.
Well, our professional engineer is watching this proceeding,
public hearing.
This proceeding, and he's done some quick math and working, and he believes that there's 32 square miles of drainage area that drain into the basin where Castle and Key is. Is that something that's within your knowledge?
At a technical level, no. But I'd be happy to show him our grounds and where we were flooded and the source that we visually saw, where the waters were coming from. And it was a fairly traumatic event for us. So I'm going on my visual observations.
He also indicates that your property is located within a regulatory flood plain. Flood zone. Are you aware of that?
I am. A part of our property is located in a floodplain, but that's with respect to Glenn's Creek. And the interesting thing about the flood that occurred on our property is it wasn't Glenn's Creek that flooded. It was the runoff from the mountain shed coming down the hill, coming down Duncan Road, coming down the mountain ravines that caused the flooding at our facility, not the creek, and which would be the reason for the location in a floodplain. The creek, I mean.
Are you aware that the 690 Duncan Road is 0.05% of the drainage area that feeds onto your property from the Duncan Road area? 0.05.
That's a technical question, and I wouldn't be competent or qualified to answer that. Again, I'm just I'm giving you my verbal my visual observations of what I've seen since we've been working on restoring that property there. and as a result of the flood event that we had that overwhelmed our entire facility from the waters that came off the mountain shed.
That's all I have.
Okay. Mr. Arvin, thank you. Bless you for opening up Castle and Key.
Well, thank you.
We really appreciate it, and we love it as part of our own Bourbon Trail. Thank you.
Thank you, and I hope that you all will make the decision to preserve that corridor. It's an important ingress, egress for our tourism business and all the other businesses that are starting to grow in Millville, and we'd really like to preserve that the aesthetic and the nature of that point of ingress and egress for us and everybody else.
Thank you for your comments. Appreciate it. Thank you very much.
Yes, sir.
Andrew, is there someone else? Is there next?
Judge, I think we're finished with virtual
What?
commenters.
Finished at 11:30?
Yes, sir. I think so.
We're finished at 11:30. Okay.
Excuse me. I still haven't had a chance to speak.
Oh, Brian Irwin. Okay. Mr. Irwin, I apologize. Andrew thought you were off, I guess.
I was part of the applicant team. Sorry.
Yeah.
I apologize, Mr. Irwin.
Oh.
Mr. Irwin, will you please raise your right hand?
Do you promise to tell the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Mr. Irwin, I apologize. I am so sorry.
Hey, no problem. And I'll keep it brief. I know everybody wants to wrap it up for the evening, but my name is Brian Irwin. I am a commercial realtor with the Gibson Company. Primarily specialize in industrial properties, and just wanted to give everyone kind of a broad stroke, of what the industrial market has been doing, especially post COVID-19 situation. Well, not post, we're still in it, but the industrial market it's going to bounce back a lot quicker than some of these office and retail, where we have lost some jobs and lost some tax revenue and seen some bankruptcies. As Patrick Tierney touched on, activities picked up quite a bit from industrial users, and we track quite a bit of information, that the amount of searches that will come through across our desk. And I know from 2018, we had about 1.6 million square feet of searches. That's bumped up to 2.5 million square feet of searches in central Kentucky. Like Carmen at the chamber and Terry touched base on, the importance of having shovel-ready development site for these folks is imperative. Otherwise, they're going to look at other sites. Think if you take Lexington, for example, who has little to zero industrial land, people overlook that site. They just will not come. Terry said these 7 groups that were looking at the farm, the minimum acreage was 5 acres. You want 5 acres in Lexington, you're going to pay over $1 million for it, over $2 million for it. It's about $225,000 an acre. So Lexington gets overlooked, and the outer interstate markets have benefited from that. Frankfort, Georgetown, and Winchester, where things can't go there. So they'll, go to the outer markets, but it's imperative to be within about a mile or so of the interstate. And if you can't provide that, these businesses and tax dollars will look elsewhere. Recent surveys showed about 2/3 of North American manufacturers intend to bring back manufacturing to our shores. And they anticipate this could be anywhere from 750 million square feet to 1 billion square feet throughout the United States. It's just a matter of, it's coming back. Are we going to be able to provide them an opportunity to bring those jobs to Frankfort? And so another thing that makes Central Kentucky ideal is the fact that we are right there at the I-64, I-75 corridor. We are 2/3, we are a day's truck drive from 2/3 of the nation's population. It's a reason that UPS, Whirlpool, Toyota, Ford, and Amazon has located to Central Kentucky. We have the 3rd largest air cargo shipments in the country. We have industrial utility expenses that is 20% lower than the national average. We are a very attractive area for these businesses to relocate. Just in the last 2 weeks, we have had discussions with groups from California, Colorado, Idaho, and Texas about coming into central Kentucky. Fact of the matter is, we do not have shovel-ready sites for them to come to, and we cannot provide those. Again, they're going to continue to look elsewhere. And so, again, I don't want to take up too much of your all's time. I just wanted to kind of give a rundown on what we see on a commercial real estate side, because the Chamber of Commerce and the KCDC and us, we are kind of the forefront when these businesses potentially look to relocate, and we need to be able to provide them with sites that they can bring these jobs in, and we look forward to continuing to do that like we've done in Franklin County for the last several years there with the Tierney project. So I appreciate your all's time, and would really urge you all to push this rezoning through so we can bring more tax dollars in, especially during this economic time with everybody. So thank you all for your time.
Thank you, Mr. Irwin. Great, nice comments. From the Squires, are there any questions for Mr. Irwin? Mr. Blackburn, Squire Blackburn.
Yes, I'm sorry, I didn't catch his background or relevance at the beginning of this.
I am a commercial real estate agent. I represent the Tierneys. I've been in been a real estate agent since 2006, and we help relocate businesses, primarily industrial, to central Kentucky.
Where are you located?
My office is located in Lexington, Kentucky, but we cover central Kentucky, about an hour, 45 minutes all around Lexington is our coverage.
Thank you very much.
Squire Tracy.
Thank you, Judge. Yeah, just one quick question. Out of the Tierney properties, how many would you say, as far as recruiting businesses to Frankfort and Franklin County, how many would you say that you have been involved in directly?
So we've had, looked at about 5 to 6 properties. What we've talked about was also the TRG. They started in 60,000 square feet over there. And unless we invested that money into 2001 Leestown Road over in the former Bendix building that had sat dormant for a while, that investment enabled them to grow into about 200,000 square feet over there. We brought American Wound Care over to 119B. It is a California distribution company. And airtight is that building right there in front of it. The interesting thing with 119B, the American Wound Care, we asked them, why did you choose Frankfort when they came in for their site visit? And they had a site logistics study done by FedEx and their distribution hubs. And they said, you need to be in central Kentucky due to your truck drive time and your proximity to the interstate. And that was an imperative decision for them to come to the area.
Thank you. And so just to follow up, so out of those 5 or 6 properties, how many jobs would you think you had a hand in bringing to Frankfort and Franklin County?
There's been, I guess TRG's got upwards of, it was about 135, I believe, by that count. And HTNA has got several hundred that we were able to help them expand. I think American Wound Care's probably got about 20 over there in their distribution. And I do not have the exact figures on all of the employment numbers for each individual business as they've grown in the county.
Okay. Thank you so much.
Thank you.
Squire Moore.
You kind of touched on this, but I hear a lot from truckers talking about how easy it is to get to all of the Franklin County industrial parks, all 3 of them. Any comments on that?
When we talk to site selection folks, it's typically a mile or less to the interstate is what they want to be in. And so every bit you're running 1,000 trucks a year, that extra mile, if it takes to get 2 miles there, really adds to their bottom line. And that's why typically a mile or less is their desirable location.
Okay, thank you.
Thank you.
Anyone else? Seeing none, Mr. Hewitt, do you have a question for Mr. Irwin?
No, sir.
Mr. Rump, do you have any questions for Mr. Irwin?
No, sir, I wouldn't dare.
Mr. Irwin, thank you. Thank you. You were last but not least on the list. Thank you so much for commenting tonight. We appreciate it.
Thanks.
Okay, is there a motion to stop? The motion to cease testimony. Is there a motion to cease testimony? Andrew, you're sure that's the end of everybody, right?
Judge, I had some questions to Robert.
Okay. I guess that's appropriate now.
Sure.
Go ahead. Okay.
Robert, let's see where I'm at here. It's been a long night. If the zone change was to go through and permits were let for whatever, could you or planning or the zoning board, whatever, mandate buffer zones? Would it be automatic?
Yes, sir. It's already automatic, covered in Article 4 of the zoning ordinance. Under industrial zoning, it's one of the design criteria.
So that would take care of that problem. Okay. Yes, as agriculture, any limits on what agriculture work could go on there?
No, sir.
So Grit Magazine says you can put 25 to 35 hogs per acre. That's over 2,500 hogs you can put on that farm. Cows, if you do crop or pasture rotation, you can put 100 cows on that farm. Horses, probably 30, 35 horses. I would rather than seeing a hog farm there or chicken farm, I think I'd rather see a big, nice building on that property for commercial use. I think this development would help the flooding, not hurt it. So that's another plus for it. I just don't see, I do see the problems the neighbors are having with it, but correct me if I'm wrong, but I think you can do just about all the dirt work you want over there without moving the mountain in an agricultural district, correct?
That's correct. I do not investigate farmers who are plowing fields, removing fence rows, or anything of that nature.
Right. So, all right, that's all I have for now. Thank you.
Robert, would you explain what goes into buffering between an industrial park and residence? What would you said that it was automatic that there would be a buffering. So what constitutes buffering?
Okay, so if you'll bear with me 1 second, I'll flip straight to the code. I always like to cite it straight. So the applicant has requested an IG zoning classification. So let's run with that scenario. If approved, Article 4, Section 4.416, design criteria, subsection A, says for any IG district adjacent to any R district or any residence, any side or rear yard shall be at least 100 feet from the property line, 100 feet, and include a visual and acoustic buffer comprised of landscape material of at least 30 feet in width, consisting of a triple row, staggered planting of evergreen trees, spaced 15 feet on center, and 6 feet in height at the time of planting.
So, Robert, in your estimation, there are really two major parts of where they're residents: the south end, the Castle and Key end, where the Goddards live, and then the 7 or 8 homes along that line, along Duncan Road. Those would be the areas that would be buffered. Is that correct? It wouldn't. The industrial part wouldn't be buffered, would it?
That's correct. The code does not require buffering between industrial and industrial. Additionally, though, the frontage along, or the property that fronts along Duncan Road would be deemed a front yard, even though there are homes across the street. through careful negotiation, I'm sure that we could have a conversation with the developer to say, based on the hearing, the testimony we heard at the hearing, would you please add a buffer, to this road frontage along Duncan Road? And oftentimes,
So you as a planning and zoning director can ask for more buffering if needed.
that is correct.
Can you as a planning and zoning director ask for more retention or detention basins if needed for flooding?
Yes, I can. It's clearly in the regs.
Okay. Okay.
In the new regs. Yes.
Okay. All right. Are there any other questions for Robert Hewitt? Squire Moore?
I had one more comment. As far as the flooding that was caused down at Castle Keys, I don't know anything about that, but on August 22nd of 2003, we had a 6-inch rain in 45 minutes in Ball Knob. The big creeks didn't flood. It was a little roadside creek, or no, it wasn't even a creek. It was a ditch along Stony Creek Hill there on Harvey Land. It took a house away with a woman and child in the house.
Yeah, good.
Yep.
You can't put stock in a little storm like that ever happening again. We hope they never do. But I remember that day very well. The big creeks didn't even come up, but the little creeks were a wipeout. That's all. Thank you.
Squire Booth? You have to unmute, Squire Booth.
Sorry about that. I move that we end commentary.
Hold on. We can't do that because we haven't gotten to the plaintiffs yet. Hang on. We're still with staff. Hang on. Are there any other questions for Mr. Hewitt?
Judge, this is Rick, and I know it's late, and I just want to clarify one issue so there's no confusion. Robert, Squire Moore asked a hypothetical about a high-density farm, such as a swine farm. Are those governed under different ordinal sections than a more low-impact farm, or is that a realistic potential use under the agriculture designation?
It's a realistic use of that designation.
So high-impact industrial farms are considered agriculture just the same as other agriculture uses. There's no distinction.
I'd have to research the land use code, which is the old SIC code. I don't believe that it is. I don't believe there is a distinction. If it's listed as, poultry production is listed as a permitted use in the ag, unless there is a lot coverage percentage requirement, which there is not in Article 4.105, then they can build as big as they want.
And likewise, if it were an IG usage, would that still be permitted?
I'd have to research the land use table. However, there are lot coverage requirements in the industrial zoning designation, but it's at 70%.
Okay, I just wanted that frankly, and as long as I've been doing this, that's the first time a discussion of a high impact potential use agriculture has been presented. So that piqued my interest, and I'm sure the rest of the court may have noted that as a unique theoretical possibility. Thank you.
Thank you.
Are there any other questions for Mr. Hewitt? Seeing none, Mr. Rumpf.
No questions.
Mr. Rumpf, I have a question for you. As Squire Moore mentioned that it was 2003 and there was a large storm, and Mr. Arvin mentioned that it was 2 years ago, and you all were not in ownership of that property 2 years ago. I've heard you testify, but I'd like for you to briefly go back through your testimony about drainage, how you were going to apply drainage to keep drainage from going onto the Goddards and down that hillside.
Well, I don't have my conceptual plan, but the conceptual plan had 4 areas set aside to handle stormwater. The one area was right down next to the Goddard's property. The one area was back, if you remember, on the right of the diagram, there's a ravine that runs down there. And the one area was there. One area was the pond out front and that's existing, and the other area was on the front right side of the property. There's also, the engineer testified that there's a drain that runs it's right on the Woodford County line where it begins, and that the plan would be to handle the drain, because we can't put detention in Woodford County unless, if they may agree to let us do it. I don't know, but if they do, then I think the engineer would prefer to have it there. But he said if they won't let us have it there, then he will build ditching or piping to take the runoff from the development over to the detention area right by Susan Goddard's property on the left of the property. So the main thing here is that I hear and I haven't really ever talked to this with Ron about this, but I did talk to the engineer, and Brad Gregory says that he believes there's enough, because of Ron's use of only 20% of the property for building, and that includes driveways and sidewalks and all that stuff. He's going to have 80% of this property to deal with the stormwater on. And that being the case, he believes that he will greatly exceed the requirements, or he can greatly exceed it by 10 to 15%. So I guess that's what I have been told, and that's what I think Mr. Tierney has told him, that is fine. So when I say exceed it, I mean, I think maybe Robert could correct me, but the regulation requires Mr. Tierney to have a runoff from his property in the 100-year or the whatever.
There's three design events.
Okay, three design events be no greater after development than it was before.
Correct.
Well, Mr. Tierney would be committed to make it 20 or 10 to 15% less than what was running off before. So we believe that would aid Judge Crittenden's problem. We believe that would perhaps aid Castle Creek's problem. From what the engineer was telling me while that testimony was going on, Castle Creek's problem is probably a lot larger than 690 Duncan Road because of the wide watershed. They're in the bottom of a funnel, is what it amounts to. And that's a problem. And what he's talking about doing is 690 Castle Road is 5/1000 of the drainage area that goes to Castle Creek. So I don't know whether anything that's done on the 690 Duncan Road property would aid Castle Creek. So we think we've proposed a very liberal plan in terms of stormwater drainage that allows a tremendous amount of area to handle stormwater. This is a comment. Industrial Park number 3, that big office building the state has up there, it has no detention facility. Mr. Tierney didn't build that. Am I right about that, Robert?
I believe you're correct.
It has no detention. And you look at that area photo, they've got 20 acres of parking.
Right.
And that's a problem. I think it's been said that the plan was to have some sort of regional detention facility. Mr. Tierney has put detention facilities on the properties he's built up there. And I think that's probably attributable to Robert's regulation of him. But we believe that we can develop this property in a fashion that causes the stormwater runoff to be 10 to 20% less than it is right now, and hold it there on the property. It's got unique features that allow that. And we're not being tremendously generous because we can't develop that pond area anyway. It's in a drainage and it's a pond. So, but he's committed. Brad says he can take that, he can make it hold even more water back. So,
okay.
Have I answered your question?
You have. Are there any other questions? Seeing none, is there a motion to cease testimony? Squire Booth, you made that earlier.
I'll second.
Judge, if I may, and not, I realize you used the word testimony. I understand that there are some written comments that will still be introduced. If you could just clarify the point of the motion to be live testimony or on line,
Okay.
but you'll still have the matter to address on written comments.
That's the next item. So is there,
Thank you.
is there a motion to cease verbal comments? Is that better, Mr. Sparks?
Yes, sir. Thank you, Judge.
Okay. So moved by Squire Booth. Is there a second?
Second.
Second by Squire Moore. Any discussion? Call the roll.
Squire Sebastian,
Yes.
Squire Blackburn, Squire Blackburn, Squire Blackburn,
Yes.
thank you. Squire Muller,
Yes.
Squire Tracy?
Yes.
Squire Booth,
Yes.
Squire Moore,
Yes.
Judge Wells,
Yes.
motion passes.
Next item is accept written comments into the record. Do I have a motion to accept all written comments that have been presented from the public that were received by 5 p.m. today, the deadline either by postal mail or the email address set up specifically for this hearing? Second, Squire Sebastian. Is there a second? Squire Muller. Any discussion? Call the roll.
Squire Sebastian,
Yes.
Squire Blackburn.
Yes.
Squire Muller,
Yes.
Squire Tracy,
Yes.
Squire Booth,
Yes.
Squire Moore,
Yes.
Yes.
motion passes.
The next item is establish findings of fact. Do we have a motion to establish a finding of fact? Squire Booth?
I move that we establish findings of fact.
Don't we have to lift them though?
Yeah, I see what she's saying.
Don't we have to do this individually though? Each one individually?
Yeah.
So
Do
we'll
we-
need to read the material.
Yes.
Do them individually.
Yes, that is correct.
Thank you, Rick.
I'm sorry.
You're
We
welcome,
had
Chair.
Rick, would you repeat what you just said? We did not understand.
Well, your problem is going to be a practical one, and as I said in response to Squire Sebastian's question, the answer to that is yes. Your findings of fact, again, number one, you've got information that hasn't been presented, i.e. the written comment. So that's still one issue. Then, as I pointed out at various times during the hearing, you have proposed findings of fact, which you haven't gone through. I don't see how practically you could generate findings of fact in terms of the detail and nuance required either for approval on a second reading. I mean, you got the one for the second reading. Don't get me wrong. Okay, you got that. But as to this hearing, if you're going to have additional or different findings of fact, you've got evidence that haven't been reviewed, i.e. the public comments, the written ones. And frankly, the written comments also included other findings of fact presented by the various witnesses, which also need to be reviewed at a different time. I just don't understand. I guess we can hash them out if you want to. It's only midnight, so it's rather early for me, but there's some homework that everybody's going to have to do in identifying what those findings should be. Mm-hmm. And I'm sure Mr. Rumpf as well wants to present, potential findings for the court to consider on the presentation for Mr. Tierney for all parties concerned.
He already has.
Great.
He already has. Okay. All right. So what do you want to do, Mr. Sparks? Can we make this finding of facts part of the court meeting on the 19th?
Yes, sir. That's your opportunity. There is going to be either a second reading or a resolution with independent findings of fact if you find contrary ones.
Okay. So we're not, I don't know, Tamara, you put this on here. You said, so are we?
We discussed it today and this morning, excuse me, Rick and Robert and I discussed that this morning, and we kind of went round and round, and the final decision was to put it on here for tonight.
That's correct. We wanted to preserve that in case the court wanted to address it. But after hearing all of the information, I mean, it's up to y'all if you want to do it. That's why it's on here.
No.
I just think practically it's going to be an impossibility.
I agree.
So should we recess the meeting and then we could reconvene to establish those before the June 19th meeting? Or do you want to, I don't know. I'm just going off.
Why can't we do it? Why do we need to recess? Why don't we make it part of the meeting on the 19th? I thought
okay, because Robert, this morning when we talked, we thought it would be too difficult to then go from the findings of fact to the ordinance, because the amendments that would need to be made for the resolution.
Either for the ordinance or the resolution.
Right.
Well, we got all night, so whatever y'all want to do.
Well, I don't want to.
Only got 3 minutes left of the night. It's tomorrow.
We got all morning.
I would submit that we need time to read, to review what has been written. We've heard some verbal testimony tonight that reflects individuals' requests for finding of fact, but there's quite a bit of written material that was submitted up until 5 o'clock that we've not had the ability to review. Okay. And that's been noted.
Okay. I agree with you. Squire Blackburn.
I agree with Squire Sebastian. I'd also like to note there were people that left the video teleconference because of the wait. So some of their stuff that they sent in as letters and emails we weren't able to review that before the end of this meeting tonight.
Yeah.
Did somebody, did you hear that? Did
Yes,
somebody
sir.
tell you that?
Yes, sir.
Okay.
Well, Andrew told us.
But is it a practical matter where we need to establish the findings of fact and they need to be published for everyone to review? Rick, is that correct?
No, ma'am. It's not. No? It will not be. No, ma'am. It will not be in the form of an ordinance.
No, I'm not meaning it as an ordinance. Don't we as a body though have to establish and vote on individually each finding of fact and then accept that and then discuss it on the merits of that? Is that the process? That's the way I understand it, and I could be wrong.
You can practically do it in a number of ways. You can meet and kind of hash them out, sort of in a deliberation, and then decide what findings that you're going to make. It doesn't have to necessarily be published. You have to incorporate it in the minutes, etc. But it's not a notice publication rule that I'm aware of. I'm not aware of anything under Chapter 100 requires that, but it does definitely require the findings. And your problem is, it's just a practical one. You know, you've heard all of the various detailed findings one way or the other. And even on the first reading that we had on the recommendation up from planning and zoning, they were rather detailed, and you got 7 people to hash them out. And it has to be hashed out in public.
Sure, and that's okay, but we will have to, as a group, take them up one at a time and establish it as, yes, a finding of fact that will pass, or will be a finding of fact that someone has submitted that's failed, correct? I mean, we have to take them individually. Is that right?
You use the word have to.
Okay.
You'll end up, there's not necessarily a requirement to take them up individually, but you're going to end up doing that as you go down the list on whether it comports with the factors under 213.
Yeah, that's all I meant. I'm sorry, I used the wrong phrasing. It's just
Well, I was
whatever
just trying
day
to be
it
very
is.
precise because it's a novel process for my court, and I respect that. I don't want to make it harder than it is because it's clearly already, it's a lot of stuff to do.
Okay.
That's
Vic,
what you got.
do you think this court, are we going to be able to, on June the 19th, come together and come up with findings of fact that we can either vote for or against the zone change?
I don't know.
If I knew the answer to that question, I'd play the lottery tomorrow night and wouldn't be worried about the 19th. I would hope that the court as a deliberative body can come up with that, Judge, because that's your job. That's what the court has to do.
Robert, when do we have to vote on this? Do we have to vote on the 19th or?
Yeah. The applicant has extended the time to July the 13th. That is your last date to prepare a final decision.
Okay.
So we could vote on it on the 30th.
Yeah, but still we gotta
discuss
the same process no matter when it is.
Right, but we wouldn't have to, we could discuss it the next meeting and vote on it the one after that.
Okay. Would y'all be okay with that?
It would make more sense for the court to be able to discuss these issues that, like several of us have said tonight, we haven't even seen at this point.
Yes. Well, maybe this will help. I'm recovering from fractured pelvic bones, and I have a lot of pain in my back. Right now, I do not want to sit up any longer.
Okay. Well, I'm tired and I don't want to sit up any longer either, but we're going to get through this and all right. So if it's okay with you, then we will do findings of fact and not vote on it on the 19th. Is that what everybody wants?
Yes.
Vote on it on the 30th. Okay. Looks like that's.
So are we going to reset, or are we going to table the item and then so we can continue the public hearing on the 19th?
Do we have to do a public hearing, Rick, to bring it back up?
No, sir. You can incorporate it in your regular meeting.
Yeah. Okay. So we don't have. So we can adjourn from this meeting and just bring it up as a part of a regular meeting.
Sounds good.
Yes, sir. You can adjourn the public hearing and then present and discussion as an agenda item on another date for discussion. Again, applying the 213 standards and perhaps even get an opportunity for everybody to address and review those proposed findings from the 7 witnesses who addressed that, 7 or 8.
Okay. So everybody okay with that?
Yes.
Yes.
Move for adjournment.
Well, hold on. Okay. Cease findings. Okay. We're going to close. Can we do adjourn? Do we have to do close and then adjourn?
Well, you already closed the public hearing, I think.
No, I haven't done that. No.
We have not closed the public hearing yet.
No.
So, I mean, from what Rick says, your findings of fact can be separate agenda items. So I recommend you have a second or a motion and a second to close the public hearing and then
Do adjourn. Okay. All right. Is there a motion to close the public hearing?
I move that we close the public hearing.
Squire Sebastian, do you second?
Yes.
Okay. Call the roll.
Squire Sebastian,
Yes.
Squire Blackburn,
Yes.
Muller,
Yes.
Squire Tracy,
Yes.
Squire Booth,
Yes.
Squire Moore?
Yes.
Judge Wells,
Yes. Is there a motion to adjourn the public hearing?
Make the motion to adjourn.
Seconded by Squire Muller. Call the roll.
Squire Sebastian,
Yes.
Squire Blackburn,
Yes.
Squire Muller,
I just want to say thank you to this court because we're all troopers. So, yes.
Tracy,
Yes.
Squire Booth,
I exacerbate Squire Muller's comments because this is a 7-hour meeting. First one. And it's during the budget procedure. We are wonderful. So I vote yes.
I want to thank all the people that came and spoke and presented, and Mr. Tierney for allowing us to extending our time limit on this, or we wouldn't be able to have this meeting. And I vote yes.
Judge Wells?
You know, there's one group, if anybody is still here watching and has watched this the whole time other than all of us that have participated, I thank you. God bless you. God bless you. With that, I vote yes. We are adjourned.